Chapter 1 Historical Background. The British came to India in 1600 as traders in the form of East India Company, which had the exclusive right of trading in India under a charter granted by Queen Elizabeth I. In 1765, the company, which till now had purely trading functions, obtained the Diwani, that is, rights over revenue and civil justice of Bengal, Bihar, and Odisha. This started its career as a territorial power. In 1858, in the wake of Sepoy Mutiny, the British Crown assumed direct responsibility for the governance of India. This rule continued until India was granted independence on August 15, 1947. With independence came the need for a constitution. Hence, a constituent assembly was formed for this purpose in 1946, and on January 26, 1950, the constitution came into being. However, various features of the Indian constitution and polity have their roots in British rule. There were certain events in the British rule that laid down the legal framework for the organization and functioning of government and administration in British India. These events have greatly influenced our constitution and polity. They are explained here in a chronological order under two major headings: the Company Rule 1773 to 1858, the Crown Rule 1858 to 1947. The Company Rule 1773 to 1858. Regulating Act of 1773. This act was of great constitutional importance as it was the first step taken by the British government to control and regulate the affairs of the East India Company in India. It recognized for the first time the political and administrative function of the company. It laid the foundation of central administration in India. The features of this act were as follows. Number 1. It designated the Governor of Bengal as the Governor General of Bengal and created an executive council of 4 members to assist him. The first such Governor General was Lord Warren Hastings. Number 2. It made the governors of Bombay and Madras presidencies subordinate to the Governor General of Bengal, unlike earlier when the 3 presidencies were independent of one another. Number 3. It provided for the establishment of a Supreme Court at Calcutta 1774, comprising 1 Chief Justice and 3 other judges. Number 4. It prohibited the servants of the company from engaging in any private trade or accepting presents or bribes from the natives. Number 5. It strengthened the control of the British government over the company by requiring the Court of Directors, governing body of the company, to report on its revenue, civil and military affairs in India. Amending Act of 1781. In a bid to rectify the defects of the Regulating Act of 1773, the British Parliament passed the Amending Act of 1781, also known as the Act of Settlement. The feature of this act were as follows. Number 1. It exempted the Governor General and the Council from the jurisdiction of the Supreme Court for the act done by them in their official capacity. Similarly, it also exempted the servants of the company from the jurisdiction of the Supreme Court for their official actions. Number 2. It excluded the revenue matters and the matters arising in the collection of revenue from the jurisdiction of the Supreme Court. Number 3. It provided that the Supreme Court was to have jurisdiction over all the inhabitants of Calcutta. It also required the court to administer the personal law of the defendants, that is, Hindus were to be tried according to the Hindu law and Muslims were to be tried according to the Mohammedan law. Number 4. It laid down that the appeals from the provincial courts could be taken to the Governor General in Council and not to the Supreme Court. Number 5. It empowered the Governor General in Council to frame regulations for the provincial courts in councils. Pitt's India Act of 1784. The next important act was the Pitt's India Act of 1784. The feature of this act were as follows. Number 1. It distinguished between the commercial and political functions of the company. It allowed the court of Number 2. It allowed the court of directors to manage the commercial affairs but created a new body called Board of Control to manage the political affairs. Thus is established a system of double government. Number 3. It empowered the Board of Control to supervise and direct all operations of the civil and military government of revenues of the British possessions in India. Thus, the act was significant for 2 reasons. First, the company's territories in India were for the first time called the British possessions in India, and second, the British government was given the supreme control over company's affairs and its administration in India. Act of 1786. In 1786, Lord Cornwallis was appointed as the Governor General of Bengal. He placed two demands to accept that post. That is, number one, he should be given power to override the decisions of his council in special cases. Number two, he would also be the commander in chief. Accordingly, the Act of 1786 was enacted to make both the provisions. Charter Act of 1793. The features of this act were as follows. Number one, it extended the overriding power given to Lord Cornwallis over his council to all future Governor Generals and Governors of Presidencies. Number two, it gave the Governor General more power and control over the governments of the subordinate presidencies of Bombay and Madras. Number three, it extended the trade monopoly of the company in India for another period of 20 years. Number four, it provided that the Commander-in-Chief was not to be a member of the Governor General's Council unless he was so appointed. Number 5. It laid down that the member of the Board of Control and their staff were henceforth to be paid out of the Indian revenues. Charter Act of 1813. The features of this act were as follows. Number 1. It abolished the trade monopoly of the company in India, that is, the Indian trade was thrown open to all British merchants. However, it continued the monopoly of the company over trade in tea and trade with China. Number 2. It asserted the sovereignty of British Crown over the company's territories in India. Number 3. It allowed the Christian missionaries to come to India for the purpose of enlightening the people. Number 4. It provided for the spread of Western education among the inhabitants of the British territories in India. Number 5. It authorized the local governments in India to impose taxes on persons. They could also punish the persons for not paying taxes. Charter Act of 1833. This act was the final step towards centralization in British India. The features of this act were as follows. Number 1. It made the Governor General of Bengal as the Governor General of India and vested in him all civil and military powers. Thus, the Act created for the first time Government of India having authority over the entire territorial area possessed by the British in India. Lord William Bentinck was the first Governor General of India. Number 2. It deprived the Governor of Bombay and Madras of their legislative powers. The Governor General of India was given exclusive legislative powers for the entire British India. The laws made under the previous act were called as regulations, while laws made under this act were called as act. Number 3. It ended the activities of East India Company as a commercial body, which became a purely administrative body. It provided that the company's territories in India were held by it in trust for His Majesty, his heirs and successors. Number 4. The Charter Act of 1833 attempted to introduce a system of open competition for selection of civil servants and stated that the Indians should not be debarred from holding any place, office and employment under the company. However, this provision was negated after opposition from the Court of Directors. Charter Act of 1853. This was the last of the series of Charter Act passed by the British Parliament between 1793 and 1853. It was a significant constitutional landmark. The features of this act were as follows. Number 1. It separated for the first time the legislative and executive function of the Governor General's Council. It provided for addition of 6 new members called legislative councillors to the council. In other words, it established a separate Governor General's Legislative Council, which came to be known as the Indian Central Legislative Council. This legislative wing of the council functioned as a mini parliament, adopting the same procedures as the British Parliament. Thus, legislation for the first time was treated as a special function of the government, requiring special machinery and special process. Number 2. It introduced an open competition system of selection and recruitment of civil servants. The coordinated civil service was thus thrown open to the Indian also. Accordingly, the Macaulay Committee, the Committee on the Indian Civil Service, was appointed in 1854. Number 3. It extended the company's rule and allowed it to retain the possession of Indian territories on trust for the British Crown, but it did not specify any particular period. Unlike the previous charters, this was a clear indication that the company's rule could be terminated at any time the Parliament liked. Number 4. It introduced for the first time local representation in the Indian Central Legislative Council. Of the 6 new legislative members of the Governor General's Council, 4 members were appointed by the local provincial governments of Madras, Bombay, Bengal and Agra. The Crown Rule, 1858 to 1947. Government of India Act of 1858. This significant act was enacted in the wake of the revolt of 1857, also known as the First War of Independence or the Sepoy Mutiny. The act, known as the Act for the Good Government of India, abolished the East India Company and transferred the powers of government, territories and revenues to the British Crown. The features of this act were as follows. Number 1. It provided that India henceforth was to be governed by and in the name of Her Majesty. It changed the designation of Governor General of India to that of Viceroy of India. Viceroy, was the direct representative of the British Crown in India. Lord Canning thus became the first Viceroy of India. Number 2. It ended the system of double government by abolishing the Board of Control and Court of Directors. Number 3. It created a new office, Secretary of State for India, vested with complete authority and control over Indian administration. The Secretary of State was a member of the British Cabinet and was responsible ultimately to the British Parliament. Number 4. It established a 15-member Council of India to assist the Secretary of State for India. The council was an advisory body. The Secretary of State was made the chairman of the council. Number 5. It constituted the Secretary of State in Council as a body corporate capable of suing and being sued in India and in England. The Act of 1858 was, however, largely confined to the improvement of the administrative machinery by which the Indian government was to be supervised and controlled in England. It did not alter in any substantial way the system of government that prevailed in India. Indian Council Act of 1861. After the Great Revolt of 1857, the British government felt the necessity of seeking the cooperation of the Indians in the administration of their country. In pursuance of this policy of association, 3 acts were enacted by the British Parliament in 1861, 1892 and 1909. The Indian Council Act of 1861 is an important landmark in the constitutional and political history of India. The features of this act were as follows. Number 1. It made a beginning of the representative institutions by associating Indians with the lawmaking process. It thus provided that the Viceroy should nominate some Indians as non-official members of his expanded council. In 1862, Lord Canning, the then Viceroy, nominated 3 Indians to his legislative council: the Raja of Banaras, the Maharaja of Patiala and Sir Dinkar Rao. Number 2. It initiated the process of decentralization by restoring the legislative powers to the Bombay and Madras presidencies. It thus reversed the centralizing tendency that started from the Regulation Act of 1773 and reached its climax under the Charter Act of 1833. This policy of legislative devolution resulted in the grant of almost complete internal autonomy to the provinces in 1937. It also provided for the establishment of new legislative council for Bengal, northwestern provinces and Punjab, which were established in 1862, 1886 and 1897 respectively. This was number 3. Number 4. It empowered the Viceroy to make rules and orders for the more convenient transaction of business in the council. It also gave a recognition to the portfolio system introduced by Lord Canning in 1859. Under this, a member of the Viceroy's council was made in charge of one or more departments of the governments and was authorized to issue final orders on behalf of the council on matters of his departments. Number 5. It empowered the Viceroy to issue ordinances without the concurrence of Legislative Council during an emergency. The life of such an ordinance was 6 months. Indian Councils Act of 1892. The features of this act were as follows. Number 1. It increased the number of additional non-official members in the central and provincial legislative councils but maintained the official majority in them. Number 2. It increased the function of legislative councils and gave them the power of discussing the budget and addressing questions to the executive. Number 3. It provided for the nomination of some non-official members of the Central Legislative Council by the Viceroy on the recommendation of the Provincial Legislative Councils and the Bengal Chamber of Commerce, and that of the Provincial Legislative Councils by the Governors on the recommendation of the District Boards, Municipalities, Universities, Trade Associations, Jamidars and Chambers. The Act made a limited and indirect provision for the use of election in filing up some of non-official seats both in the Central and Provincial Legislative Councils. The word election was, however, not used in the Act. The process was described as nomination made on the recommendation of certain bodies. Indian Council Act of 1909. This act is also known as Morley Minto reforms. Lord Morley was the then Secretary of State for India and Lord Minto was the then Viceroy of India. The features of this act were as follows. Number 1. It considerably increased the size of the legislative councils, both central and provincial. The number of members in the central legislative councils was raised from 16 to 60. The numbers of members in the provincial legislative council was not uniform. Number two, it retained official majority in the Central Legislative Council but allowed the provincial legislative councils to have non official majority. Number three, it enlarged the deliberative functions of the legislative councils at both the levels. For example, members were allowed to ask supplement questions, move resolutions on the budget, and so on. It provided for the number four, it provided for the first time for the Association of Indians with the Executive Council of the Viceroy and Governors. Satyendra Prasad Sinha became the first Indian to join the Viceroy's Executive Council. He was appointed as a law member. Number 5. It introduced a system of communal representation for Muslims by accepting the concept of separate electorate. Under this, the Muslim members were to be elected only by Muslim voters. Thus, the Act legalized communalism and Lord Minto came to be known as the father of communal electorate. Number 6. It also provided for the separate representation of presidencies, corporations, chambers of commerce, universities, and jamidars. Government of India Act of 1919. On August 20, 1917, the British government declared for the first time that its objective was the gradual introduction of responsible government in India. The Government of India Act of 1919 was thus enacted, which came into force in 1921. This act is also known as Montague-Chelmsford reforms. Montague was the Secretary of State for India and Lord Chelmsford was the Viceroy of India. The features of this act were as follows. Number 1. It relaxed the central control over the provinces by demarcating and separating the control central and provincial subjects. The central and provincial legislatures were authorized to make laws on their respective list of subjects. However, the structure of government continued to be centralized and unitary. Number 2. It further divided the provincial subjects into two parts, transferred and reversed. Reserved. The transferred subjects were to be administered by the governor with the aid of ministers responsible to the Legislative Council. The reserved subjects, on the other hand, were to be administered by the governor and his executive council without being responsible to the Legislative Council. This dual scheme of governance was known as diarchy, a term derived from the Greek word diarchy, which means double rule. However, this experiment was largely unsuccessful. Number 3. It introduced for the first time bicameralism and direct elections in the country. Thus, the Indian Legislative Council was replaced by a bicameral legislature consisting of an upper house, Council of State, and a lower house, Legislative Assembly. The majority of members of both the houses were chosen by direct elections. Number 4. It required that the 3 of the 6 members of the Viceroy's Executive Council, other than the Commander-in-Chief, were to be Indian. Number 5. It extended the principle of communal representation of providing separate electorates for Sikh, Indian Christian, Anglo-Indians and Europeans. Number 6. It granted franchisee to a limited number of people on the basis of property tax or education. Number 7. It created a new office of the High Commissioner for India in London and transferred to him some of the functions hitherto performed by the Secretary of State for India. Number 8. It provided for the establishment of a Public Service Commission. Hence, a Central Public Service Commission was set up in 1926 for recruiting civil servants. Number 9. It separated for the first time provincial budget from the central budget and authorized the provincial legislature to enact their budgets. Number 10. It provided for the appointment of a statutory commission to inquire into and report on its working after 10 years of its coming into force. Simon Commission. In November 1927 itself, that is 2 years before the schedule, the British government announced the appointment of 7-member statutory commission under the chairmanship of Sir John Simon to report on the condition of India under its new constitution. All the members of the commission were British and hence all the parties boycotted the commission. The commission submitted its report in 1930 and recommended the abolition of diarchy, extension of responsible government in the provinces, establishment of a federation of British India and princely states, continuation of communal electorates and so on. To consider the proposals of the Commission, the British government convened 3 roundtable conferences of the representative of British government, British India and Indian princely state. On the basis of these discussions, a white paper or constitutional reforms was prepared and submitted for the consideration of the Joint Select Committee of the British Parliament. The recommendations of this committee were incorporated with certain change in the next Government of India Act of 1935. Communal Award. In August 1932, Ramsay MacDonald, the British Prime Minister, announced a scheme of representation of the minorities, which came to be known as the Communal Award. The award not only continued separate electorates for the Muslims, Sikhs, Indian Christians, Anglo-Indians and Europeans, but also extended it to the depressed classes, scheduled castes. Gandhiji was distressed over this extension of the principle of communal representation to the depressed classes and undertook fast unto death in Yerawada jail, Pune, to get the award modified. At last, there was an agreement between the leaders of the Congress and the depressed classes. The agreement, known as Pune Pact, retained the Hindu joint electorate and gave reserved seats to the depressed classes. Government of India Act of 1935. The act marked a second milestone towards a completely responsible government in India. It was a lengthy and detailed document having 321 sections and 10 schedules. The features of this act were as follows. Number 1. It provided for the establishment of an all India federation consisting of provinces and princely states as units. The act divided the powers between the centre and units in terms of three lists: federal list for centre with 59 items, provincial list for provinces with 54 items, and the concurrent list for both with 36 items. Residuary powers were given to the Viceroy. However, the federation never came into being as the princely states did not join it. It abolished diarchy in the provinces and introduced provincial autonomy in its place. The provinces were allowed to act as autonomous units of administration in their defined spheres. Moreover, the act introduced responsible governments in provinces. That is, the governor was required to act with the advice of ministers responsible to the provincial legislature. This came into effect in 1937 and was discontinued in 1939. Number 3. It provided for the adoption of diarchy at the centre. Consequently, the federal subjects were divided into reserved subjects and transferred subjects. However, this provision of the Act did not come into operation at all. Number 4. It introduced bicameralism in 6 out of 11 provinces. Thus, the legislature of Bengal, Bombay, Madras, Bihar, Assam and the United Provinces were made bicameral, consisting of a legislative council, upper house, and a legislative assembly, lower house. However, many restrictions were placed on them. Number 5. It further extended the principle of communal representation by providing separate electorate for depressed classes, scheduled caste, women and labour workers. Number 6. It abolished the Council of India established by the Government of India Act of 1858. The Secretary of State for India was provided with a team of advisors. Number 7. It extended franchisee. About 10% of the total population got the voting right. Number 8. It provided for the establishment of a Reserve Bank of India to control the currency and credit of the country. Number 9. It provided for the establishment of not only a Federal Public Service Commission but also a Provincial Public Service Commission and Joint Public Service Commission for 2 or more provinces. Number 10. It provided for the establishment of a federal court which was set up in 1937. Indian Independence Act of 1947. On February 20, 1947, the British Prime Minister Clement Attlee declared that the British rule in India would end by June 30, 1948, after which the power would be transferred to responsible Indian hands. This announcement was followed by the agitation by the Muslim League demanding partition of the country. Again on June 3, 1947, the British government made it clear that any constitution framed by the Constituent Assembly of India, formed in 1946, cannot apply to those parts of the country which were unwilling to accept it. On the same day, June 3, 1947, Lord Mountbatten, the Viceroy of India, put forth the partition plan, known as the Mountbatten Plan. The plan was accepted by the Congress and the Muslim League. Immediate effect was given to the plan by enacting the Indian Independence Act 1947. The features of this act were as follows. Number 1. It ended the British rule in India and declared India as an independent and sovereign state from August 15, 1947. Number 2. It provided for the partition of India and creation of 2 independent dominions of India and Pakistan with the right to secede from the British Commonwealth. Number 3. It abolished the office of Viceroy and provided for each dominion a government who was to be appointed by the British King on the advice of the Dominion Cabinet. His Majesty's government in Britain was to have no responsibility with respect to the government of India or Pakistan. Number 4. It empowered the constituent assemblies of the 2 dominions to frame and adopt any constitution for their respective nations and to repeal any act of the British Parliament, including the Independence Act itself. Number 5. It empowered the constituent assemblies of both the dominions to legislate for their respective territories till the new constitutions were drafted and enforced. No act of the British Parliament passed after August 15, 1947 was to extend to either of the new dominions unless it was extended thereto by a law of the legislature of the dominion. Number 6. It abolished the office of Secretary of State for India and transferred his function to the Secretary of State for Commonwealth Affairs. Number 7. It proclaimed the lapse of British paramountcy over the Indian princely state and treaty relations with tribal areas from August 15, 1947. Number 8. It granted freedom to the Indian princely state either to join the Dominion of India or Dominion of Pakistan or to remain independent. Number 9. It provided for the governance of each of the dominions and the provinces by the Government of India Act of 1935. Till the new constitutions were framed, the dominions were however authorized to make modifications in the Act. Number 10. It deprived the British monarch of his right to veto bills or ask for reservation of certain bills for his approval, but this right was reserved for the Governor General. The Governor General would have full power to assent to any bill in the name of His Majesty. Number 11. It designated the Governor General of India and the provincial governors as constitutional nominal heads of the state. They were made to act on the advice of the respective Council of Ministers in all matters. Number 12. It dropped the title of Emperor of India from the royal titles of the King of England. Number 13. It discontinued the appointment to civil services and reservation of post by the Secretary of State for India. The members of the civil services appointed before August 15, 1947 would continue to enjoy all benefits that they were entitled to till that time. At the stroke of midnight of 14 to 15 August 1947, the British rule came to an end and power has transferred to the new independent two dominions of India and Pakistan. Lord Mountbatten became the first Governor General of New Dominion of India. He swore in Jawaharlal Nehru as the first Prime Minister of independent India. The Constituent Assembly of India, formed in 1946, became the Parliament of the Indian Dominion. Table 1.1, Interim Government 1946, Jawaharlal Nehru. Portfolio: Vice President of the Council, External Affairs and Commonwealth Relations. Number 2, Sardar Vallabhbhai Patel, Home, Information and Broadcasting. Number 3, Dr. Rajendra Prasad, Food and Agriculture. Number 4, Dr. John Mathai, Industries and Supplies. Number 5, Jagjeevan Ram, Labour. Number 6, Sardar Baldev Singh, Defence. Number 7, C.H. Bhava, Works, Mines and Power. Number 8, Liaquat Ali Khan, Finance. Number 9, Abdul Rab Nistar, Post and Air. Number 10, Asaf Ali, Railways and Transport. Number 11, C. Rajgopalachari, Education and Arts. Number 12, I. Chundrigar, Commerce. Number 13, Ghaznafar Ali Khan, Health. Number 14, Joginder Nath Mandal, Law. The members of the interim government were members of the Viceroy's Executive Council. The Viceroy continued to be the head of the council, but Jawaharlal Nehru was designated as the Vice President of the council. Chapter 2, Making of the Constitution. Demand for a Constituent Assembly. It was in 1934 that the idea of a Constituent Assembly for India was put forward for the first time by M.N. Roy, a pioneer of the communist movement in India. In 1935, the Indian National Congress for the first time officially demanded a Constituent Assembly to frame the Constitution of India. In 1938, Jawaharlal Nehru, on behalf of the INC, declared that the Constitution of Free India must be framed without outside interference by a Constituent Assembly elected on the basis of adult franchise. The demand was finally accepted in principle by the British government in what is known as the August Offer of 1940. In 1942, Sir Stafford Cripps, a member of the cabinet, came to India with a draft proposal of the British government on the framing of an independent constitution to be adopted after the World War II. The Cripps proposal were rejected by the Muslim League, which wanted India to be divided into two autonomous states with two separate constituent assemblies. Finally, a cabinet mission was sent to India. While it rejected the idea of two constituent assemblies, it put forth a scheme of the Constituent Assembly which more or less satisfied the Muslim League. Composition of the Constituent Assembly. The Constituent Assembly was constituted in November 1946 under the scheme formulated by the Cabinet Mission Plan. The features of the scheme were: number 1, the total strength of the Constituent Assembly was to be 389. Of these, 296 seats were to be allotted to British India and 93 seats to the princely states. Out of 296 seats allotted to the British India, 292 members were to be drawn from the 11 governors' provinces and 4 from the 4 chief commissioners' provinces, 1 from each. Number 2, each province and princely state or group of states, in case of small states, were to be allotted seats in proportion to their respective population. Roughly 1 seat was to be allotted for every million population. Number 3, seats allocated to each British province were to be divided among the 3 principal communities, Muslim, Sikhs, and general, all except Muslims and Sikhs, in proportion to their population. Number 4, the representative of each community were to be elected by members of that community in the provincial legislative assembly, and voting was to be by the method of proportional representation by means of single transferable vote. Number 5, the representative of the princely states were to be nominated by the heads of the princely states. It is thus clear that the Constituent Assembly was to be partly elected and partly nominated body. Moreover, the members were to be indirectly elected by the members of the provincial assemblies, who themselves were elected on a limited franchise. The election to the Constituent Assembly for 296 seats allotted to the British Indian province were held in July-August 1946. The Indian National Congress won 208 seats, the Muslim League 73 seats, and the small groups and independents got the remaining 15 seats. However, the 93 seats allotted to the princely states were not filled, as they decided to stay away from the Constituent Assembly. Although the Constituent Assembly was not directly elected by the people of India on the basis of adult franchise, the Assembly comprised representatives of all sections of the Indian society: Hindus, Muslims, Sikh, Parsis, Anglo-Indians, Indian, Christians, SC, ST, including women of all these sections. The Assembly included all important personalities of India at that time, with the exception of Mahatma Gandhi. Working of the Constituent Assembly. The Constituent Assembly held its first meeting on December 9, 1946. The Muslim League boycotted the meeting and insisted on a separate state of Pakistan. The meeting was thus attended by only 211 members. Dr. Sachidanand Sinha, the oldest member, was elected as the temporary president of the Assembly, following the French practice. Later, Dr. Rajendra Prasad was elected as the first president of the Assembly. Similarly, both H.C. Mukherjee and V.T. Krishnamachari were elected as the vice presidents of the Assembly. In other words, the Assembly had two vice presidents. Objective resolution. On December 13, 1946, Jawaharlal Nehru moved the historic objective resolution in the Assembly. It laid down the fundamentals and philosophy of the constitutional structure. It read, Number 1, this Constituent Assembly declares its firm and solemn resolve to proclaim India as an independent sovereign republic and to draw up for her future governance a constitution. Number 2, wherein the territories that now comprise British India, the territories that now form the Indian state, and such other parts of India as are outside India, and the states as well as other territories we are willing to be constituted into the independent sovereign India, shall be a union of them all. And number 3, wherein the said territories, whether with their present boundaries or with such other as may be determined by the Constituent Assembly and thereafter according to the law of the Constitution, shall possess and retain the status of autonomous units together with residuary powers, and exercise all powers and functions of government and administration, save and except such powers and functions as are vested in or assigned to the Union, or as inherent or implied in the Union or resulting therefrom. Number 4, wherein all power and authority of the sovereign independent India, its constituent parts and organs of government are derived from the people. Number 5, wherein shall be guaranteed and secured to all the people of India justice, social, economic and political, equality of status of opportunity and before the law, freedom of thought, expression, belief, faith, worship, vocation, association and action, subject to law and public morality. Number 6, wherein adequate safeguards shall be provided for minorities, backward and tribal areas and depressed and other backward classes. Number 7, whereby shall be maintained the integrity of the territory of the Republic and its sovereign rights on land, sea and air according to justice and the law of civilized nations. Number 8, this ancient land attains its rightful and honored place in the world and makes its full and willing contribution to the promotion of world peace and the welfare of mankind. This resolution was unanimously adopted by the Assembly on January 22, 1947. It influenced the eventual shaping of the Constitution through its all subsequent stages. Its modified version forms the preamble of the present Constitution. Changes by the Independence Act. The representatives of the princely state who had stayed away from the Constituent Assembly gradually joined it on April 28, 1947. Representatives of the 6 states were part of the Assembly after the acceptance of the Mountbatten Plan of June 3, 1947 for the partition of the country. The representatives of most of the other princely states took their seats in the Assembly. The members of the Muslim League from the Indian Dominion also entered the Assembly. The Indian Independence Act of 1947 made the following three changes in the position of the Assembly. Number 1. The Assembly was made a fully sovereign body which could frame any constitution it pleased. The Act empowered the Assembly to abrogate or alter any law made by the British Parliament in relation to India. Number 2. The Assembly also became a legislative body. In other words, two separate functions were assigned to the Assembly, that is, making of the Constitution for Free India and enacting of ordinary laws for the country. These two tasks were to be performed on separate days. Thus, the Assembly became the first Parliament of Free India Dominion Legislature. Whenever the Assembly met as the constituent body, it was chaired by Dr. Rajendra Prasad, and when it met as the legislative body, it was chaired by G.V. Mavlankar. These two functions continued till November 26, 1949, when the task of making the constitution was over. Number 3. The Muslim League members hailing from the areas included in the Pakistan withdrew from the Constituent Assembly for India. Consequently, the total strength of the Assembly came down to 299 as against 389 originally fixed in 1946 under the Cabinet Mission Plan. The strength of the Indian provinces, formerly British province, was reduced from 296 to 229 and those of the princely states from 93 to 70. The state-wise membership of the Assembly as on December 31st, 1947 is shown in future tables of this chapter. Other functions performed. In addition to the making of constitution and enacting of ordinary laws, the Constituent Assembly also performed the following functions. Number 1. It ratified the India's membership of the Commonwealth in May 1949. Number 2. It adopted the national flag on July 22, 1947. Number 3. It adopted the national anthem on July 24, 1950. Number 4. It adopted the national song on January 24, 1950. Number 5. It elected Dr. Rajendra Prasad as the first President of India on January 24, 1950. In all, the Constituent Assembly had 11 sessions over 2 years, 11 months and 18 days. The constitution makers had gone through the constitutions of about 60 countries and the draft constitution was considered for 114 days. The total expenditure incurred on making the constitution amounted to rupees 64 lakh. On January 24, 1950, the Constitution Assembly had its final session. It, however, did not end and continued as the Provisional Parliament of India from January 26, 1950 till the formation of new parliament after the first general election of 1951 to 52. Committees of the Constituent Assembly. The Constituent Assembly appointed a number of committees to deal with the different tasks of constitution making. Out of these, 8 were major committees and other were minor committees. The names of these committees and their chairmen are given below. Major committees. Number 1. Union Powers Committee, Jawaharlal Nehru. Number 2. Union Constitution Committee, Jawaharlal Nehru. Number 3. Provincial Constitution Committee, Sardar Patel. Number 4. Drafting Committee, Dr. B.R. Ambedkar. Number 5. Advisory Committee on Fundamental Rights, Minorities and Tribal and Excluded Areas, Sardar Patel. This committee had the following 5 subcommittees. Fundamental Rights Subcommittee, J.B. Kripalani. Minorities Subcommittee, S.C. Mukherjee. Northeast Frontier Tribal Areas and Assam Excluded and Partially Excluded Areas Subcommittee, Gopinath Bardoloi. Excluded and partially excluded areas other than those in Assam Subcommittee, A.V. Thakkar. Northwest Frontier Tribal Areas Subcommittee. Number 6. Rules of Procedure Committee, Dr. Rajendra Prasad. Number 7. States Committee, Committee for Negotiating with the States, Jawaharlal Nehru. Number 8. Steering Committee, Dr. Rajendra Prasad. Minor Committees. Number 1. Finance and Staff Committee, Dr. Rajendra Prasad. Number 2. Credentials Committees, Aladi Krishna Swamy Iyer. Number 3. House Committee, Dr. Pattabi Sitaramaiya. Number 4. Order of Business Committee, Dr. K.M. Munshi. Number 5. Ad hoc Committee on the National Flag, Dr. Rajendra Prasad. Number 6. Committee on Functions of the Constituent Assembly, G.V. Mavlankar. Number 7. Ad hoc Committee on the Supreme Court, S. Bardachari, not an Assembly member. Number 8. Committee on Chief Commissioners Provinces, B. Pattabi Sitaramaiya. Number 9. Expert Committee on the Financial Provisions of the Union Constitution, Nalini Ranjan Sarkar, not an Assembly member. Number 10. Linguistic Province Commission, S.K. Dhar, not an Assembly member. Number 11. Special Committee to examine the draft Constitution, Jawaharlal Nehru. Number 12. Press Gallery Committee, Usha Nas Sen. Number 13. Ad hoc Committee on Citizenship, S. Vardachari, not an Assembly member. Drafting Committee, Among all the committees of the Constituent Assembly, the most important committee was the Drafting Committee set up on August 29, 1947. It was this committee that was entrusted with the task of preparing a draft of the new constitution. It consisted of 7 members. They were number 1, Dr. B.R. Ambedkar, Chairman. Number 2, N. Gopalaswamy Iyengar. Number 3, Aladi Krishna Swamy Iyer. Number 4, Dr. K.M. Munshi. Number 5, Sayyid Muhammad Sadallah. Number 6, N. Madhav Rao. He replaced B.L. Mittar, who resigned due to ill health. Number 7, T.T. Krishnamachari. He replaced D.P. Khetan, who died in 1948. The drafting committee, after taking into consideration the proposals of the various committees, prepared the first draft of the Constitution of India, which was published in February 1948. The people of India were given 8 months to discuss the draft and propose amendments. In the light of the public comments, criticisms, and suggestions, the drafting committee prepared a second draft which was published in October 1948. The drafting committee took less than 6 months to prepare its draft. In all, it sat only for 141 days. Enactment of the Constitution. Dr. B.R. Ambedkar introduced a final draft of the Constitution in the Assembly on November 4, 1948. First reading. The Assembly had a general discussion on it for 5 days till November 9, 1948. The second reading, clause by clause consideration, started on November 15, 1948 and ended on October 17, 1949. During this stage, as many as 7563 amendments were proposed and 2473 were actually discussed in the Assembly. The third reading of the draft started on November 14, 1949. Dr. B.R. Ambedkar moved a motion, the Constitution as settled by the Assembly by be passed. The motion on draft Constitution was declared as passed on November 26, 1949 and received the signatures of the members and President. Out of the total 299 members of the Assembly, only 284 were actually present on that day and signed the Constitution. This is also the date mentioned in the Preamble as the date on which the people of India in the Constituent Assembly adopted, enacted, and gave to themselves the Constitution. The Constitution as adopted on November 26, 1949 contained a preamble, 395 articles and 8 schedules. The preamble was enacted after the entire Constitution was already enacted. Dr. B.R. Ambedkar, the then Law Minister, piloted the draft Constitution in the Assembly. He took a very prominent part in the deliberations of the Assembly. He was known for his logical, forceful, and persuasive arguments on the floor of the Assembly. He is recognized as the father of the Constitution of India. This brilliant writer, constitutional expert, undisputed leader of the scheduled caste, and the chief architect of the Constitution of India is also known as the modern Manu. Enforcement of the Constitution. Some provisions of the Constitution pertaining to citizenship, election, provisional parliament, temporary and transitional provisions, and short titles contained in Article 5, 6, 7, 8, 9, 60, 324, 366, 367, 379, 380, 388, 391, 392 and 393 came into force on November 26, 1949 itself. The remaining provisions, the major part of the Constitution, came into force on January 26, 1950. This day is referred to in the Constitution as the date of its commencement and celebrated as the Republic Day. January 26 was specifically chosen as the date of commencement of the Constitution because of its historical importance. It was on this day in 1930 that Purna Swaraj Day was celebrated following the resolution of the Lahore session, December 1929 of the INC. With the commencement of the Constitution, the Indian Independence Act of 1947 and the Government of India Act of 1935, with all enactments amending or supplementing the later act, was repealed. The abolition of Privy Council Jurisdiction Act 1949 was, however, continued. Experts Committee of the Congress. While elections to the Constituent Assembly were still in progress, on July 8, 1946, the Congress Party, Indian National Congress, appointed an experts committee for the purpose of preparing material for the Constituent Assembly. This committee consisted of the following members. Number 1, Jawaharlal Nehru as its chairman. Number 2, M. Asif Ali. Number 3, K. M. Munshi. Number 4, N. Gopalaswamy Iyengar. Number 5, K. T. Shah. Number 6, Dr. Gadgil. Number 7, Humayun Kabir. Number 8, K. Santhanam. Later, on the chairman's proposal, it was resolved that Krishna Kriplani be co-opted as member and convener of the committee. The committee had two sittings, the first at New Delhi from July 20 to 22, 1946, and the second at Bombay from August 15 to 17, 1946. Apart from a number of notes prepared by its members, the committee discussed the procedure to be adopted by the Constituent Assembly, the question of the appointment of various committees, and the draft of a resolution on the objective of the Constitution to be moved during the first session of the Constituent Assembly. On the role played by the committee in the making of constitution, Granville Austin, a British constitutional expert, observed it was the Congress Expert Committee that set India on the road to her present constitution. The committee members, working within the framework of the Cabinet Mission Scheme, made general suggestions about autonomous areas, the powers of provincial governments and the centre, and about such issues as the princely state and the amending power. They also drafted a resolution closely resembling the objective resolution. Criticism of the Constituent Assembly. The critics have criticized the Constituent Assembly on various grounds. These are as follows. Number one, not a representative body. The critics have argued that the Constituent Assembly was not a representative body as its members were not directly elected by the people of India on the basis of universal adult franchise. Number two, not a sovereign body. The critics maintained that the Constituent Assembly was not a sovereign body as it was created by the proposals of the British government. Further, they said that the Assembly held its session with the permission of the British government. Number three, time consuming. According to the critics, the Constituent Assembly took unduly long time to make the Constitution. They stated that the framers of the American Constitution took only 4 months to complete their work. In this context, Naziruddin Ahmed, a member of the Constituent Assembly, coined a new name for the drafting committee to show his contempt for it. He called it a drifting committee. Number 4. Dominated by Congress. The critics charged that the Constituent Assembly was dominated by the Congress Party. Granville Austin, an American constitutional expert, remarked, the Constituent Assembly was a one-party body, is an essentially one-party country. The Assembly was Congress and the Congress was India. Number 5. Lawyer-politician domination. It is also maintained by the critics that the Constituent Assembly was dominated by lawyers and politicians. They pointed out that other sections of the society were not sufficiently represented. Thus, this in them is the main reason for the bulkiness and complicated language of the Constitution. Number 6. Dominated by Hindus. According to some critics, the Constituent Assembly was a Hindu-dominated body. Lord Viscount Simon called it a body of Hindus. Similarly, Winston Churchill commented that the Constituent Assembly represented only one major community in India. Important facts. Number 1. Elephant was adopted as the symbol of the Constituent Assembly. Number 2. So B.N. Rao was appointed as the constitutional advisor, legal advisor to the Constituent Assembly. Number 3. H.B.R. Iyengar was the secretary to the Constituent Assembly. Number 4. S.N. Mukherjee was the chief draftsman of the Constitution in the Constituent Assembly. Number 5. Prem Bihari Narayan Raizada was the calligrapher of the Indian Constitution. The original Constitution was handwritten by him in a flowing italic style. Number 6. The original version was beautified and decorated by artists from Shantiniketan, including Nandalal Bose and Biohar Ram Manohar Sinha. Number 7. Biohar Ram Manohar Sinha illuminated beautiful and ornamented the original preamble calligraphed by Prem Bihari Narayan Raizada. Number 8. The calligraphy of the Hindi version of the original Constitution was done by Vasant Krishnan Vaidya and elegantly decorated and illuminated by Nandalal Bose. Hindi text of the Constitution. Originally, the Constitution of India did not make any provision with respect to an authoritative text of the Constitution in India, Constitution in the Hindi language. Later, a provision in this regard was made by the 58th Constitutional Amendment Act of 1987. This amendment inserted a new Article 394A in the last part of the Constitution, that is, Part 22. This article contains the following provision. Number 1. The President shall cause to be published under his authority the translation of the Constitution in Hindi language, the modifications which are necessary to bring it in conformity with the language, style and terminology adopted in the authoritative text of the central acts in Hindi can be made in it. All the amendments of the Constitution made before such publication should be incorporated in it. Number 2. The translation in Hindi of every amendment of the Constitution made in English. The translation of the Constitution and its every amendment published shall be construed to have the same meaning as the original text in English. If any difficulty arises in the matter, the President shall cause that Hindi text to be revised suitably. Number 3. The translation of the Constitution and its every amendment published shall be deemed to be for all purpose its authoritative text in Hindi. Salient features of the Constitution. The Indian Constitution is unique in its content and spirit. Though borrowed from almost every constitution of the world, the Constitution of India has several salient features that distinguish it from the constitutions of the other countries. It should be noted at the outset that a number of original features of the Constitution as adopted in 1949 have undergone a substantial change on account of several amendments, particularly 7th, 42nd, 44th, 73rd, 74th, 97th, and 101st Amendment. In fact, the 42nd Amendment Act 1976 is known as Mini Constitution due to the important and large number of changes made by it in various parts of the Constitution. However, in the Keshwanand Bharti case of 1973, the Supreme Court ruled that the constituent power of Parliament under Article 368 does not enable it to alter the basic structure of the Constitution. Salient features of the Constitution. The salient features of the Constitution as it stands today are as follows. Number 1. Lengthiest written Constitution. Constitutions are classified into written like the American Constitution or unwritten like the British Constitution. The Constitution of India is the lengthiest of all the written constitution of the world. It is a very comprehensive, elaborate and detailed document. Originally 1949, the Constitution contained a preamble, 395 articles divided into 22 parts and 8 schedules. Presently 2019, it consists of a preamble, about 470 articles divided into 25 parts and 12 schedules. The various amendments carried out since 1951 have deleted about 20 articles and 1 part 8th and added about 95 articles, 4 parts 6th, 4th A, 9th A, 9th B and 14A and 4 schedules 9, 10, 11 and 12. No other constitution in the world has so many articles and schedules. 4 factors have contributed to the elephantine size of our constitution. They are A. Geographically factors, that is vastness of the country and its diversity. B. Historical factors, example, the influence of the Government of India Act of 1935 which was bulky. C. Single constitution for both the center and the state. D. Dominance of legal luminaries in the Constituent Assembly. The Constitution contains not only the fundamental principles of governance but also detailed administrative provisions. Further, those matters which is other modern democratic countries have been left to the ordinary legislation or established political conventions have also been included in the constitutional document itself in India. Drawn from various sources. The Constitution of India has, number 2, drawn from various sources. The Constitution of India has borrowed most of its provisions from the constitutions of various other countries as well as from the Government of India Act of 1935. Dr. B.R. Ambedkar proudly acclaimed that the Constitution of India has been framed after ransacking of all the known constitutions of the world. The structural part of the Constitution is to a large extent derived from the Government of India Act of 1935. The philosophical part of the Constitution, the fundamental rights and the directive principle of a state policy derive their inspiration from the American and Irish constitutions respectively. The political part of the Constitution, the principle of the cabinet government and the relation between executive and the legislature have been largely drawn from the British Constitution. The other provision of the Constitution have been drawn from the constitutions of Canada, Australia, Germany, USSR, now Russia, France, South Africa, Japan and so on. The most profound influence and material source of the Constitution is the Government of India Act 1935. The federal scheme, judiciary, governors, emergency powers and the Public Service Commission and most of the administrative details are drawn from the Act. More than half of the provisions of Constitution are identical to or bear a close resemblance to the Act of 1935. Number 3. Blend of rigidity and flexibility. Constitutions are also classified into rigid and flexible. A rigid constitution is one that requires a special procedure for its amendment, as for example, the American Constitution. A flexible constitution, on the other hand, is one that can be amended in the same manner as the ordinary laws are made, as for example, the British Constitution. The Constitution of India is neither rigid nor flexible, but a synthesis of both. Article 368 provides for 2 types of amendments. A. Some provisions can be amended by a special majority of the Parliament, that is, a 2/3 majority of the members of each house present and voting, and a majority of the total membership of each house. B. Some other provisions can be amended by a special majority of the Parliament and with the ratification by half of the total states. At the same time, some provisions of the Constitution can be amended by a simple majority of the Parliament in the manner of ordinary legislative process. Notably, these amendments do not come under Article 368. Number 4. Federal system with unitary bias. The Constitution of India establishes a federal system of government. It contains all the usual features of a federation, that is, two government, division of powers, written constitution, supremacy of constitution, rigidity of constitution, independent judiciary, and bicameralism. However, the Indian Constitution also contains a large number of unitary or non-federal features, that is, a strong center, single constitution, single citizenship, flexibility of the constitution, integrated judiciary, appointment of a state governor by the center, all India services, emergency provisions, and so on. Moreover, the term federation has nowhere been used in the Constitution. Article 1, on the other hand, describes India as a union of a state, which implies two things. 1. Indian federation is not the result of an agreement by the states, and 2. No state has the right to secede from the federation. Hence, the Indian Constitution has been variously described as federal in form but unitary in spirit, quasi-federal by K.C. Weare, bargaining federalism by Morris Jones, cooperative federalism by Greenwell Austen, federation with a centralizing tendency by Ivor Jennings, and so on. Number 5. Parliamentary form of government. The Constitution of India has opted for the British parliamentary system of government rather than the American presidential system of government. The parliamentary system is based on the principle of cooperation and coordination between the legislative and executive organs, while the presidential system is based on the doctrine of separation of powers between the two organs. The parliamentary system is also known as the Westminster model of government, responsible government, and cabinet government. The Constitution establishes the parliamentary system not only at the center but also in the states. The features of parliamentary government in India are: A. Presence of nominal and real executives. B. Majority party rule. C. Collective responsibility of the executive to the legislature. D. Membership of the ministers in the legislature. E. Leadership of the prime minister or the chief minister. F. Dissolution of the lower house, Lok Sabha or assembly. Even though the Indian parliamentary system is largely based on the British pattern, there are some fundamental differences between the two. For example, the Indian Parliament is not a sovereign body like the British Parliament. Further, the Indian state has an elected body, republic, while the British state has hereditary head, monarchy. In a parliamentary system, whether in India or Britain, the role of the Prime Minister has become so significant and crucial that the political scientists like to call it a prime ministerial government. Number 6. Synthesis of parliamentary sovereignty and judicial supremacy. The doctrine of sovereignty of Parliament is associated with the British Parliament, while the principle of judicial supremacy with that of the American Supreme Court. Just as the Indian parliamentary system differs from the British system, the scope of judicial review powers of the Supreme Court in India is narrower than that of what exists in US. This is because the American Constitution provides for due process of law against that of procedure established by law contained in the Indian Constitution, Article 21. Therefore, the framers of the Indian Constitution have preferred a proper synthesis between the British principle of parliamentary sovereignty and the American principle of judicial supremacy. The Supreme Court, on the one hand, can declare the parliamentary laws as unconstitutional through its power of judicial review. The Parliament, on the other hand, can amend the major portion of the Constitution through its constituent power. Number 7. Integrated and independent judiciary. The Indian Constitution establishes a judicial system that is integrated as well as independent. The Supreme Court stands at the top of the integrated judicial system in the country. Below it, there are high courts at the state level. Under a high court, there is a hierarchy of subordinate courts, that is, district courts and other lower courts. The single system of court enforces both the central law as well as the state law, unlike in USA, where the federal laws are enforced by the federal judiciary and the state laws are enforced by the state judiciary. The Supreme Court is a federal court, the highest court of appeal, the guarantor of the fundamental rights of the citizens and the guardian of the Constitution. Hence, the Constitution has made various provisions to ensure its independent, security of tenure of the judges, fixed service conditions for the judges, all the expenses of the Supreme Court charged on the Consolidated Fund of India, prohibition on discussion on the conduct of judges in the legislature, ban on practice after retirement, power to punish for its contempt wasted in the Supreme Court, separation of the judiciary from the executive, and so on. Number 8. Fundamental rights. Part 3rd of the Indian Constitution guarantees 6 fundamental rights to all the citizens. A. Right to equality, Article 14 to 18. B. Right to freedom, Article 19 to 22. C. Right against exploitation, Article 23 to 24. D. Right to freedom of religion, Article 25 to 28. E. Cultural and educational rights, Article 29 to 30. F. Right to constitutional remedies under Article 32. The fundamental rights are meant for promoting the idea of political democracy. They operate as limitations on the tyranny of the executive and arbitrary laws of the legislature. They are justiciable in nature, that is, they are enforceable by the courts for their violation. The aggrieved person can directly go to the Supreme Court, which can issue the writs of habeas corpus, mandamus, prohibition, certiorari, and quo warranto for the restoration of his rights. However, the fundamental rights are not absolute and subject to reasonable restrictions. Further, they are not sacrosanct and can be curtailed or repealed by the Parliament through a Constitutional Amendment Act. They can also be suspended during the operation of a national emergency except the rights guaranteed by Article 20 and 21. Number 9. Directive Principles of State Policy. According to Dr. B.R. Ambedkar, the directive principles of state policy is a noble feature of the Indian Constitution. They are enumerated in Part 4th of the Constitution. They can be classified into 3 broad subcategories: socialistic, Gandhian, and liberal intellectual. The directive principles are meant for promoting the ideal of social and economic democracy. They seek to establish a welfare state in India. However, unlike the fundamental rights, the directives are non-justiciable in nature, that is, they are not enforceable by the courts for their violation. Yet, the Constitution itself declares that these principles are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. Hence, they impose a moral obligation on the state authorities for their application. But the real force sanctioned behind them in political, that is, public opinion. In the Minerva Mills case, 1980, the Supreme Court held that the Indian Constitution is founded on the bedrock of the balance between the fundamental rights and the directive principles. Fundamental duties. Number 10. Fundamental duties. The original Constitution did not provide for the fundamental duties of the citizens. These were added during the operation of Internal Emergency 1975 to 77 by the 42nd Constitutional Amendment Act of 1976 on the recommendation of the Swaran Singh Committee. The 86th Constitutional Amendment Act of 2002 added one more fundamental duty. The Part 4th A of the Constitution, which consists of only one article, 51A, specifies the 11 fundamental duties, that is, to respect the Constitution, national flag and national anthem, to protect the sovereignty, unity and integrity of the country, to promote the spirit of common brotherhood amongst all the people, to preserve the rich heritage of our composite culture, and so on. The fundamental duties serve as a reminder to citizens that while enjoying their rights, they have also to be quite conscious of duties they owe to their country, their society, and to their fellow citizens. However, like the directive principles, the duties are also non-justiciable in nature. Number 11. A secular state. The Constitution of India stands for a secular state, hence, it does not uphold any particular religion as the official religion of the Indian state. The following provisions of the Constitution reveal the secular character of the Indian state. A. The term secular was added to the preamble of the Indian Constitution by the 42nd Constitutional Amendment Act of 1976. B. The preamble secures to all its citizens of India liberty of belief, faith and worship. C. The state shall not deny to any person equality before the law or equal protection of the laws. Article 14. D. The state shall not discriminate against any citizen on the ground of religion. Article 15. E. Equality of opportunity for all citizens in matters of public employment. Article 16. F. All persons are equally entitled to freedom of conscience and the right to freely profess, practice and propagate any religion. Article 25. G. Every religious denomination or any of its section shall have the right to manage its religious affairs. Article 26. H. No person shall be compelled to pay any taxes for the promotion of a particular religion. Article 27. I. No religious instruction shall be provided in any educational institution maintained by the state. Article 28. J. Any section of the citizen shall have the right to conserve its distinct language, script or culture. Article 29. K. All minorities shall have the right to establish and administer educational institutions of their choice. Article 30. I. The state shall endeavour to secure for all the citizens a uniform civil code. Article 44. The Western concept of secularism connotes a complete separation between the religion, the church, and the state, the politics. The negative concept of secularism is inapplicable in the Indian situation where the society is multi-religious. Hence, the Indian Constitution embodies the positive concept of secularism, that is, giving equal respect to all religions and protecting all religions equally. Moreover, the Constitution has also abolished the old system of communal representation, that is, reservation of seats in the legislature on the basis of religion. However, it provides for the temporary reservation of seats for the scheduled castes and scheduled tribes to ensure adequate representation to them. Number 12. Universal Adult Franchisee. The Indian Constitution adopts universal adult franchisee as a basis of elections to the Lok Sabha and the state legislative bodies. Every citizen who is not less than 18 years of age has a right to vote without any discrimination of caste, race, religion, sex, literacy, wealth, and so on. The voting age was reduced to 18 years from 21 years in 1989 by the 61st Constitutional Amendment Act of 1988. The introduction of universal adult franchisee by the constitution makers was a bold experiment and highly remarkable in view of the vast size of the country, in huge population, high poverty, social inequality, and overwhelming literacy. Universal adult franchisee makes democracy broad-based, enhances the self-respect and prestige of the common people, upholds the principle of equality, enables minorities to protect their interest, and opens up new hopes and vistas for weaker sections. Number 13. Single citizenship. Though the Indian Constitution is federal and investigates a dual polity, central and states, it provides for only a single citizenship, that is, the Indian citizenship. In countries like USA, on the other hand, each person is not only a citizen of USA but also a citizen of the particular state to which he belongs. Thus, he owes allegiance to both and enjoys dual sets of rights, one conferred by the national government and another by the state government. In India, all citizens, irrespective of the state in which they are born or reside, enjoy the same political and civil rights of citizenship all over the country, and no discrimination is made between them. Despite the constitutional provisions for a single citizenship and uniform rights for all the people, India has been witnessing the communal riots, class conflict, caste wars, linguistic clashes, and ethnic disputes. This means that the cherished goal of the constitution makers to build a united and integrated Indian nation has not been fully realized. Number 14, independent bodies. The Indian Constitution not only provides for the legislative, executive, and judicial organ of the government, central and state, but also establishes certain independent bodies. They are investigate by the Constitution as the bulwarks of the democratic system of government in India. These are A. Election commissions to ensure free and fair elections to the Parliament, the state legislature, the office of the President of India, and the office of Vice President of India. B. Comptroller and Auditor General of India to audit the accounts of the central and state governments. He acts as the guardian of public purse and comments on the legality and propriety of government expenditure. C. Union Public Service Commission to conduct examinations for recruitment to all India services and higher central services and to advise the President on disciplinary matters. D. State Public Service Commission in every state to conduct examinations for recruitment to state services and to advise the governor on disciplinary matters. The Constitution ensures the independence of these bodies through various provisions like security of tenure, fixed service conditions, expenses being charged on the Consolidated Fund of India, and so on. Number 15. Emergency provisions. The Indian Constitution contains elaborate emergency provisions to enable the President to meet any extraordinary situation effectively. The rationality behind the incorporation of these provisions is to safeguard the sovereignty, unity, integrity, and security of the country, the democratic political system, and the Constitution. The Constitution investigates three types of emergencies, namely A. National emergency on the ground of war or external aggression or armed rebellion, Article 352. B. State emergency, President's rule on the ground of failure of constitutional machinery in the states, Article 356, or failure to comply with the directions of the Centre, Article 365, and C. Financial emergency on the ground of threat to the financial stability or credit of India, Article 360. During an emergency, the central government becomes all powerful and the states go into the total control of the center. It converts the federal structure into a unitary one without a formal amendments of the constitution. This kind of transformation of the political system from federal during normal times to unitary during emergency is a unique feature of the Indian constitution. Number 16. Three-tier government. Originally, the Indian constitution, like any other federal constitution, provided for a dual polity and contained provisions with regard to the organizations and powers of the center and the states. Later, the 73rd and 74th Constitutional Amendment Act 1992 have added a third tier of government, that is local, which is not found in any other constitution of the world. The 73rd Amendment Act of 1992 gave constitutional recognition to the panchayat rural local governments by adding a part 9th and a new schedule 11 to the constitution. Similarly, the 74th Amendment Act of 1992 gave constitutional recognition to the municipalities, urban local governments by added a new part 9th and a new schedule 12 to the constitution. Number 17. Cooperative societies. The 97th Constitutional Amendment Act of 2011 gave a constitutional status and protection to cooperative societies. In this context, it made the following three changes in the Constitution. Number 1. It made the right to form cooperative societies a fundamental right, Article 19. Number 2. It included a new directive principle of a state policy on promotion of cooperative societies, Article 43b. Number 3. It added a new part 9th B in the Constitution, which is entitled as the Cooperative Societies, Article 243ZH to 243ZT. The new part 9th B contains various provisions to ensure that the cooperative societies in the country function in a democratic, professional, autonomous and economically sound manner. It empowers the Parliament in respect of multi-state cooperative societies and the state legislatures in respect of other cooperative societies to make the appropriate law. Criticism of the Constitution. The Constitution of India, as framed and adopted by the Constituent Assembly of India, has been criticized on the following grounds. Number 1. A borrowed constitution. The critics opined that the Indian Constitution contained nothing new and original. They described it as a borrowed constitution or a bag of borrowings or a hodgepodge constitution or a patchwork of several documents of the word constitutions. However, this criticism is unfair and illogical. This is because the framers of the constitution made necessary modifications in the features borrowed from other constitutions for their suitability to the Indian conditions, at the same time avoiding their faults. While answering the above criticism in the Constituent Assembly, Dr. B.R. Ambedkar, the chairman of the drafting committee, said, "One likes to ask whether there can be anything new in a constitution framed at this hour in the history of the world. More than 100 years have rolled over when the first written constitution was drafted. It has been followed by many countries reducing their constitution to writing. What the scope of a constitution should be has long been settled. Similarly, what are the fundamentals of a constitution are recognized all over the world. Given these facts, the constitution in their main provisions must look similar. The only new things, if there can be any, in a constitution framed so late in the day are the variations made to remove the faults and to accommodate it to the needs of country. The charge of producing a blind copy of the constitution of other countries is based, I am sure, on an adequate study of the constitution." Number 2. A carbon copy of 1935 Act. The critics said that the framers of the constitution have included a large number of the provisions of the Government of India Act of 1935 into the Constitution of India. Hence, they called the constitution as a carbon copy of the 1935 Act or an amended version of the 1935 Act. For example, N. Srinivasan observed that the Indian constitution in both the languages and a substance a close copy of the Act of 1935. Similarly, Sir Ivor Jennings, a British constitutionalist, said that the constitution derives directly from the Government of India Act of 1935, from which, in fact, many of its provisions are copied almost textually. Further, P.R. Deshmukh, a member of the Constituent Assembly, commented that the constitution is essentially the Government of India Act of 1935 with only adult franchisee added. The same Dr. B.R. Ambedkar answered the above criticism in the Constituent Assembly in the following way: As to the accusation that the draft constitution has reproduced a good part of the provisions of the Government of India Act 1935, I make no apologies. There is nothing to be ashamed of in borrowing. It involves no plagiarism. Nobody holds any patent rights in the fundamental ideas of the Constitution. What I am sorry about is that the provision taken from the Government of India Act 1935 relate mostly to the details of administration. Number 3. Un-Indian or anti-Indian. According to the critics, the Indian constitution is an un-Indian or anti-Indian because it does not reflect the political traditions and the spirit of India. They said that the foreign nature of the constitution makes it unsuitable to the Indian situation or unworkable in India. In this context, K. Hanumanthaiah, a member of the Constituent Assembly, commented, we wanted the music of Veena or sitar, but here we have the music of an English band. That was because our constitution makers were educated that way. Similarly, Loknath Mishra, another member of the Constituent Assembly, criticized the constitution as a slavish imitation of the West, much more a slavish surrender to the West. Further, Lakshmi Narayan Sahu, also a member of the Constituent Assembly, observed the ideals on which this draft constitution is framed have no manifest relation to the fundamental spirit of India. This constitution would not provide suitable and would break down soon after being brought into operation. Number 4. An un-Gandhian constitution. According to the critics, the Indian constitution is un-Gandhian because it does not contain the philosophy and ideals of Mahatma Gandhi, the father of Indian nation. They opine that the constitution should have been raised and built upon village panchayat and district panchayat. In this context, the same member of the Constituent Assembly, K. Hanumanthaiah, said that is exactly the kind of constitution Mahatma Gandhi did not want and did not envisage. T. Prakasham, another member of the Constituent Assembly, attributed this lapse to Ambedkar's non-participation in the Gandhian movement and the antagonism towards the Gandhian ideas. Number 5. Elephantine size. The critics stated that the Indian constitution is too bulky and too detailed and contains some unnecessary elements. Sir Ivor Jennings, a British constitutionalist, observed that the provisions borrowed were not always well selected and that the constitution, generally speaking, was too long and complicated. In this context, H.V. Kamath, a member of the Constituent Assembly, commented, the emblem and the crest that we have selected for our assembly is an elephant. It is perhaps in consonance with that our constitution too is the bulkiest that the world has produced. He also said, I am sure the House does not agree what we should make the constitution an elephantine one. Number 6. Paradise of the lawyers. According to the critics, the Indian constitution is too legalistic and very complicated. They opine that the legal language and phraseology adopted in the constitution makes it a complex document. The same Sir Ivor Jennings called it a lawyer paradise. In this context, H.K. Maheshwari, a member of the Constituent Assembly, observed the draft tends to make people more litigious, more inclined to go to law courts, less truthful, and less likely to follow the methods of truth and non-violence. If I may say so, the draft is really a lawyer's paradise. It opens up vast avenues of litigation and will give our able and ingenious lawyers plenty of work to do. Similarly, P.R. Deshmukh, another member of the Constituent Assembly, said, I should however like to say that the draft of the articles that have been brought before the House by Dr. Ambedkar seems to my mind to be far too ponderous, like the ponderous terms of law manual. A document dealing with a constitution hardly uses so much of padding and so much of verbiage. Perhaps it is difficult for them to compose a document which should be, to my mind, not a law manual, but a socio-political document, a vibrating, pulsating and life-giving document, but to our misfortune, that was not to be, and we have been burdened with so much of words which could have been very easily eliminated. This is the end of chapter, but this chapter also contains too many tables. So, for referring the table, you may refer the 6th edition of M.Laxmikant book, or you can refer online PDFs. Thank you so much. Chapter 4. Preamble of the Constitution. The American Constitution was the first to begin with a preamble. Many countries, including India, followed this practice. The term preamble refers to the introduction or preface of the Constitution. It contains the summary or essence of the Constitution. N.A. Palkhiwala, an eminent jurist and constitutional expert, called the Preamble as the identity card of the Constitution. The Preamble to the Indian Constitution is based on the Objectives Resolution drafted and moved by Pandit Nehru and adopted by the Constituent Assembly. It has amended by the 42nd Constitutional Amendment Act 1976, which added three new words: socialist, secular, and integrity. Text of the Preamble. The Preamble in its present form reads, "We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution." Ingredients of the Preamble. The Preamble reveals four ingredients or components. Number one, source of authority of the Constitution. The Preamble states that the Constitution derives its authority from the people of India. Number two, nature of Indian state. It declares India to be of a sovereign, socialist, secular, democratic, and republican polity. Number three, objectives of the Constitution. It specifies justice, liberty, and equality, fraternity as the objective. Number four, date of adoption of the Constitution. It stipulates November 26, 1949 as the date. Keywords in the Preamble. Certain keywords: sovereign, socialist, secular, democratic, republic, justice, liberty, equality, and fraternity are explained as follows. Number one, sovereign. The word sovereign implies that India is neither a dependency nor a dominion of any other nation, but an independent state. There is no authority above it, and it is free to conduct its own affairs, both internal and external. Though in 1949, India declared the continuation of her full membership of the Commonwealth of Nations and accepted the British Crown as the head of the Commonwealth. This extra constitutional declaration does not affect India's sovereignty in any manner. Further, India's membership of the United Nations organization also in no way constitutes a limitation on her sovereignty. Being a sovereign state, India can either acquire a foreign territory or cede a part of its territory in favor of a foreign state. Number two, socialist. Even before the term was added by the 42nd Amendment in 1976, the Constitution had a socialist content in the form of certain directive principles of state policy. In other words, what was hitherto implicit in the Constitution has now been made explicit. Moreover, the Congress Party itself adopted a resolution to establish a socialistic pattern of society in its Avadi session as early as in 1955 and took measures accordingly. Notably, the Indian brand of socialism is a democratic socialism and not a communistic socialism, also known as state socialism, which involves the nationalization of all means of production and distribution and the abolition of private property. Democratic socialism, on the other hand, holds faith in a mixed economy where both public and private sectors coexist side by side. As the Supreme Court says, democratic socialism aims to end poverty, ignorance, disease, and inequality of opportunity. Indian socialism is a blend of Marxism and Gandhism, leaning heavily towards the Gandhian socialism. The new economic policy 1991 of liberalization, privatization, and globalization has, however, diluted the socialistic credentials of the Indian state. Number 4. Number 3. Secular. The term secular too was added by the 42nd Constitutional Amendment Act of 1976. However, as the Supreme Court said in 1974, although the words secular state were not expressly mentioned in the Constitution, there can be no doubt that Constitution makers wanted to establish such a state, and accordingly Articles 25 to 28 guaranteeing the fundamental rights to freedom of religion have been included in the Constitution. The Indian Constitution embodies the positive concept of secularism, that is, all religions in our country, irrespective of their strength, have the same status and support from the state. Number 4. Democratic. A democratic polity, as stipulated in the preamble, is based on the doctrine of popular sovereignty, that is, possession of supreme power by the people. Democracy is of two types, direct and indirect. In direct democracy, the people exercise their supreme power directly. As in the case of Switzerland, there are four devices of direct democracy, namely referendum, initiative, recall, and plebiscite. In indirect democracy, on the other hand, the representatives elected by the people exercise the supreme power and thus carry on the government and make the laws. This type of democracy, also known as representative democracy, is of two kinds, parliamentary and presidential. The Indian Constitution provides for representative parliamentary democracy, under which the executive is responsible to the legislature for all its policies and actions. Universal adult franchisee, periodic elections, rule of law, independence of judiciary, and absence of discrimination on certain grounds are the manifestation of the democratic character of the Indian polity. The term democratic is used in the preamble in the broader sense, embracing not only political democracy but also social and economic democracy. This dimension was stressed by Dr. Ambedkar in his concluding speech in the Constituent Assembly on November 25, 1949, in the following way. Political democracy cannot last unless there lies at the base of its social democracy. What does social democracy mean? It means a way of life which recognizes liberty, equality, and fraternity. The principles of liberty, equality, and fraternity are not to be treated as separate items in a trinity. They form a union of trinity in the sense that to divorce one from the other is to defeat the very purpose of democracy. Liberty cannot be divorced from equality. Equality cannot be divorced from liberty. Nor can liberty and equality be divorced from fraternity. Without equality, liberty would produce the supremacy of the few over the many. Equality without liberty would kill individual initiative. In the same context, the Supreme Court observed in 1997 that the Constitution envisions to establish an egalitarian social order, rendering to every citizen social, economic, and political justice in a social and economic democracy of the Bharat Republic. Number 5. Republic. A democratic polity can be classified into two categories, monarchy and republic. In a monarchy, the head of the state, usually king or queen, enjoys a hereditary position, that is, it comes into effect office through succession. Example, Britain. In a republic, on the other hand, the head of the state is always elected directly or indirectly for a fixed period. Example, USA. Therefore, the term republic in our preamble indicates that India has an elected head called the president. He is elected indirectly for a fixed period of 5 years. A republic also means two or more things. One, vesting of political sovereignty in the people and not in a single individuality like a king. Second, the absence of any privileged class and hence all public offices being open to every citizen without any discrimination. Justice. Number 6. Justice. The term justice in the preamble embraces three distinct forms: social, economic, and political, secured through various provisions of fundamental rights and directive principles. Social justice denotes the equal treatment of all citizens without any social distinction based on caste, color, race, religion, sex, and so on. It means absence of privileges being extended to any particular section of the society and improvement in the conditions of backward classes, SC, ST, and OBCs, and women. Economic justice denotes the non-discrimination between people on the basis of economic factors. It involves the elimination of glaring inequalities in wealth, income, and property. A combination of social justice and economic justice denotes what is known as distributive justice. Political justice implies that all citizens should have equal political rights, equal access to all political offices, and equal voice in the government. The ideal of justice, social, economic, and political, has been taken from the Russian Revolution of 1917. Number 7. Liberty. The term liberty means the absence of restraints on the activities of individuals and at the same time providing opportunities for the development of individual personalities. The preamble secures to all its citizens of India liberty of thought, expression, belief, faith, and worship through their fundamental rights, enforceable in court of law in case of violation. Liberty, as elaborated in the preamble, is very essential for the successful functioning of the Indian democratic system. However, liberty does not mean license to do what one likes and has to be enjoyed within the limitations mentioned in the Constitution itself. In brief, the liberty conceived by the preamble or fundamental right is not absolute but qualified. The ideals of liberty, equality, and fraternity in our preamble have been taken from the French Revolution, 1789 to 1799. Number 8. Equality. The term equality means the absence of special privileges to any section of the society and the provisions of adequate opportunities for all individuals without any discrimination. The preamble secures to all its citizens of India equality of status and opportunity. This provision embraces three dimensions of equality: civic, political, and economic. The following provisions of the chapter on fundamental rights ensure civic equality. Number 1. Equality before the law under Article 14. Number 2. Prohibition of discrimination on grounds of religion, race, caste, sex or place of birth under Article 15. Number 3. Equality of opportunity in matters of public employment under Article 16. Number 4. Abolition of untouchability under Article 17. Number 5. Abolition of titles under Article 18. There are two provisions in the Constitution that seek to achieve political equality. 1. No person is to be declared ineligible for inclusion in electoral rolls on the grounds of religion, race, caste or sex under Article 325. 2. Elections to the Lok Sabha and the state assemblies to be on the basis of adult suffrage under Article 326. The directive principle of state policy under Article 39 secures to men and women equal rights to an adequate means of livelihood and equal pay for equal work. Number 9. Fraternity. Fraternity means a sense of brotherhood. The Constitution promotes this feeling of fraternity by the system of single citizenship. Also, the fundamental duties, Article 51A, say that it shall be the duty of every citizen of India to promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, regional or sectional diversities. The preamble declares that fraternity has to assure two things: the dignity of the individual and the unity and integrity of the nation. The word integrity has been added to the preamble by the 42nd Constitutional Amendment Act of 1976. According to K.M. Munshi, a member of the drafting committee of the Constituent Assembly, the phrase dignity of the individual signifies that the Constitution not only ensures material betterment and maintain a democratic setup, but that it also recognizes that the personality of every individual is sacred. This is highlighted through some of the provisions of the fundamental rights and directive principles of state policy, which ensures the dignity of individuals. Further, the fundamental duties under Article 51A also protect the dignity of women by stating that it shall be the duty of every citizen of India to renounce practices derogatory to the dignity of women, and also makes it duty of every citizen of India to uphold and protect the sovereignty, unity and integrity of India. The phrase unity and integrity of the nation embraces both the psychological and territorial dimensions of national integration. Article 1 of the Constitution describes India as a union of states to make it clear that the states have no right to secede from the unions, implying the indestructible nature of the Indian state. It aims at overcoming hindrances to national integration like communalism, regionalism, casteism, linguism, secessionism, and so on. Significance of the Preamble. The Preamble embodies the basic philosophy and fundamental values, political, moral, and religious, on which the Constitution is based. It contains the grand and noble vision of the Constituent Assembly and reflects the dreams and aspirations of the founding fathers of the Constitution. In the words of Sir Aladi Krishnaswamy Iyer, a member of the Constituent Assembly who played a significant role in making the Constitution, the preamble to our Constitution expresses what we had thought or dreamed so long. According to K.M. Munshi, a member of the drafting committee of the Constituent Assembly, the preamble is the horoscope of our sovereign democratic republic. Pandit Thakur Das Bhargav, another member of the Constituent Assembly, summed up the importance of the preamble in the following words: the preamble is the most precious part of the Constitution. It is the soul of the Constitution. It is a key to the Constitution. It is a jewel set in the Constitution. It is a proper yardstick with which one can measure the worth of the Constitution. Sir Ernest Barker, a distinguished English political scientist, paid a glowing tribute to the political wisdom of the authors of the preamble. He described the preamble as the keynote to the Constitution. He was so moved by the text of the preamble that he quoted it at the opening of his popular book, Principles of Social and Political Theory, 1951. M. Hidayatullah, a former Chief Justice of India, observed, preamble resembles the Declaration of Independence of the United States of America, but is more than a declaration. It is the soul of our constitution which lays down the pattern of our political society. It contains a solemn resolve which nothing but a revolution can alter. Preamble as part of the constitution. One of the controversies about the preamble is as to whether it is a part of the constitution or not. In the Berubari Union case of 1960, the Supreme Court said that the preamble shows the general purpose behind the several provisions in the Constitution and is thus a key to the minds of the makers of the Constitution. Further, where the terms used in many articles are ambiguous or capable of more than one meaning, some assistance at interpretation may be taken from the objectives enshrined in the preamble. Despite this recognition of the significance of preamble, the Supreme Court specifically opined that preamble is not a part of the Constitution. In the Keshwanand Bharti case of 1973, the Supreme Court rejected the earlier opinion and held that preamble is a part of the Constitution. It observed that the preamble is of extreme importance and the Constitution should be read and interpreted in the light of the grand and noble vision expressed in the preamble. In the LIC of India case 1995, also, the Supreme Court again held that the preamble is an integral part of the Constitution. Like any other part of the Constitution, the preamble was also enacted by the Constituent Assembly. But after the rest of the Constitution was already enacted, the reason for inserting of the preamble at the end was to ensure that it was in conformity with the Constitution as adopted by the Constituent Assembly. While forwarding the preamble for votes, the President of the Constituent Assembly said the question is that preamble stands for part of the Constitution. The motion was then adopted, hence the current opinion held by the Supreme Court that the preamble is a part of the Constitution is in consonance with the opinion of the founding fathers of the Constitution. However, two things should be noted. Number one, the preamble is neither a source of power to legislature nor a prohibition upon the powers of legislature. Number two, it is a non-justiciable, that is, its provisions are not enforceable in courts of law. Amendability of the preamble. The question as to whether the preamble can be amended under Article 368 of the Constitution arose for the first time in the historic Keshwanand Bharti case of 1973. It was urged that the preamble cannot be amended as it is not a part of the Constitution. The petitioner contended that the amending power in Article 368 cannot be used to destroy or damage the basic elements of the fundamental features of the Constitution, which are enshrined in the preamble. The Supreme Court, however, held that the preamble is a part of the Constitution. The court stated that the opinion tendered by in the Berubari Union case of 1960 in this regard was wrong and held that the preamble can be amended subject to the condition that no amendment is done to the basic features. In other words, the court held that the basic elements of the fundamental features of the Constitution as contained in the preamble cannot be altered by an amendment under Article 368. The preamble has been amended only once so far in 1976 by the 42nd Constitutional Amendment Act, which has added three new words: socialist, secular, and integrity, and to the preamble. This amendment was held to be valid. Thank you so much. Chapter 5: Union and its Territory. Article 1 to 4 under Part 1st of the Constitution deals with Union and its territory. Union of States. Article 1 describes India, that is Bharat, as a union of states rather than a federation of states. This provision deals with two things: one, name of the country, and two, types of polity. There was no unanimity in the Constituent Assembly with regard to the name of the country. Some members suggested the traditional name Bharat, while others advocated the modern name India. Hence, the Constituent Assembly had to adopt a mix of both, India, that is Bharat. Secondly, the country is described as union, although its constitution is federal in structure. According to Dr. B.R. Ambedkar, the phrase Union of State has been preferred to the Federation of State for two reasons. One, the Indian Federation is not the result of an agreement among the states like the American Federation, and two, the states have no right to secede from the Federation. The Federation is an union because it is indestructible. The country is an integral whole and divided into different states only for the convenience of administration. According to Article 1, the territory of India can be classified into three categories. Number 1, territories of the state. Number 2, Union territories. Number 3, territories that may be acquired by the Government of India at any time. The names of states and union territories and their territorial extent are mentioned in the first schedule of the Constitution. At present, there are 28 states and 9 union territories. The provisions of the Constitution pertaining to the states are applicable to all the states in the same manner. However, the special provisions under Part 21 applicable to the states of Maharashtra, Gujarat, Nagaland, Assam, Manipur, Andhra Pradesh, Telangana, Sikkim, Mizoram, Arunachal Pradesh, Goa, and Karnataka override the general provisions relating to the states as a class. Further, the 5th and 6th schedule contain separate provisions with respect to the administration of scheduled areas and tribal areas within the states. Notably, the territory of India is a wider expression than the Union of India because the latter includes only states while the former includes not only the states but also union territories and territories that may be acquired by the Government of India at any future time. The states are the members of the federal system and share a distribution of powers with the center. The union territories and the acquired territories, on the other hand, are directly administered by the central government. Being a sovereign state, India can acquire foreign territories according to the modes recognized by international law, that is, cession, following treaty, purchase, gift, lease, or plebiscite, occupation, hitherto unoccupied by a recognized ruler, conquest or subjugation. For example, India acquired several foreign territories such as Dadra and Nagar Haveli, Goa, Daman and Diu, Puducherry and Sikkim since the commencement of the Constitution. The acquisition of these territories are discussed later in this chapter. Article 2 empowers the Parliament to admit into the Union of India or establish new states or such terms and conditions as it thinks fit. Thus, Article 2 grants two powers to the Parliament. A. The power to admit into the Union of India new states. B. The power to establish new state. The first refers to the admission of states which are already in existence, while the second refers to the establishment of states which were not in existence before. Notably, Article 2 relates to the admission or establishment of new states that are not part of the Union of India. Article 3, on the other hand, relates to the formation of or changes in the existing states of the Union of India. In other words, Article 3 deals with the internal readjustment inter se of the territories of the constituent states of Union of India. Parliament's power to reorganize the states. Article 3 authorized the Parliament to Number 1. Form a new state by separation of territory from any state or by uniting two or more states or parts of states or by uniting any territory to a part of any state. Number 2. Increase the area of any state. Number 3. Diminish the area of any state. Number 4. Alter the boundaries of any state. Number 5. Alter the name of any state. However, Article 3 lays down two conditions in this regard. 1. A bill contemplating the above changes can be introduced in the Parliament only with the prior recommendation of the President, and 2. Before recommending the bill, the President has to refer the same to the state legislature concerned for expressing its views within a specified period. Further, the power of Parliament to form any new states includes the power to form a new state or union territory by uniting a part of any state or union territory to any other state or union territory. The President or Parliament is not bound by the views of the state legislature and may either accept or reject them, even if the views are received in time. Further, it is not necessary to make a fresh reference to the state legislature every time an amendment to the bill is moved and accepted in Parliament. In case of a union territory, no reference need to be made to concerned legislature to ascertain its views, and the Parliament can itself take any action as it deems fit. It is thus clear that the Constitution authorizes the Parliament to form new states or alter the areas, boundaries or names of the existing states without their consent. In other words, the Parliament can redraw the political map of India according to its will. Hence, the territorial integrity or continued existence of any state is not guaranteed by the Constitution. Therefore, India is rightly described as an indestructible union of destructible states. The union government can destroy the states, whereas the state government cannot destroy the union. In USA, on the other hand, the territorial integrity or continued existence of a state is guaranteed by the Constitution. The American federal government cannot form new state or alter the borders of existing state without the consent of the states concerned. That is why the USA is described as an indestructible union of indestructible states. Moreover, the Constitution, under Article 4, itself declares that laws made for admission or establishment of new states under Article 2 and formation of new states and alteration of areas, boundaries, or names of existing states under Article 3 are not to be considered as amendments of the Constitution under Article 368. This means that such laws can be passed by a simple majority and by the ordinary legislative process. Does the power of Parliament to diminish the areas of a state under Article 3 include also the power to cede Indian territory to a foreign country? The question came up for examination before the Supreme Court in a reference made by the President in 1960. The decision of the central government to cede part of a territory known as Berubari Union, West Bengal to Pakistan led to political agitation and controversy and thereby necessitated the presidential reference. The Supreme Court held that the power of Parliament to diminish the area of a state under Article 3 does not cover cession of Indian territory to a foreign country. Hence, Indian territory can be ceded to a foreign state only by amending the Constitution under Article 368. Consequently, the 9th Constitutional Amendment Act 1960 was enacted to transfer the said territory to Pakistan. On the other hand, the Supreme Court in 1969 ruled that settlement of a boundary dispute between India and another country does not require a constitutional amendment. It can be done by executive action as it does not involve cession of Indian territory to a foreign country. Exchange of territories with Bangladesh. The 100th Constitutional Amendment Act 2015 was enacted to give effect to the acquiring of certain territories by India and transfer of certain other territories to Bangladesh in pursuance of the agreement and its protocol entered into between the Government of India and Government of Bangladesh. Under this deal, India transferred 111 enclaves to Bangladesh while Bangladesh transferred 51 enclaves to India. In addition, the deal also involved the transfer of adverse possessions and the demarcation of a 6.1 kilometer undemarcated border stretch. For these three purposes, the amendment modified the provisions relating to the territories of four states, Assam, West Bengal, Meghalaya and Tripura, in the first schedule of the Constitution. The background of this amendment is as follows. Number 1. India and Bangladesh have a common land boundary of approximately 4096.7 kilometers. The India-East Pakistan land boundary was determined as per the Radcliffe Award of 1947. Dispute arose out of some provisions in the Radcliffe Award which were sought to be resolved through the Bagay Award of 1950. Another effort was made to settle these disputes by the Nehru-Noon Agreement of 1958. However, the issue relating to division of Berubari Union was challenged before the Supreme Court. To comply with the opinion rendered by the Supreme Court, the Constitution 9th Amendment Act 1960 was passed by the Parliament. Due to the continuous litigation and other political developments at that time, the Constitution 9th Amendment Act 1960 could not be notified in respect of territories in former East Pakistan, presently Bangladesh. Number 2. On May 16, 1974, the agreement between India and Bangladesh concerning the demarcation of the land boundary and related matters was signed between both the countries to find a solution to the complex nature of the border demarcation involved. This agreement was not ratified as it involved, inter alia, transfer of territory which requires a constitutional amendment. In this connection, it was also required to identify the precise area on the ground which would be transferred. Subsequently, the issues relating to demarcation of an undemarcated boundary, the territories in adverse possession and exchange of enclaves were identified and resolved by signing a protocol on September 6, 2011, which forms an integral part of the land boundary agreement between India and Bangladesh 1974. The protocol was prepared with support and concurrence of the concerned state governments of Assam, Meghalaya, Tripura and West Bengal. Evolution of states and union territories. Integration of princely states. At the time of independence, India comprised two categories of political units, namely the British provinces under the direct rule of British government and the princely states under the rule of native princes but subject to the paramountcy of British crown. The Indian Independence Act of 1947 created two independent and separate dominions of India and Pakistan and gave three options to the princely states, that is, joining India, joining Pakistan, or remaining independent. Of the 552 princely states situated within the geographical boundaries of India, 549 joined India, and the remaining three, Hyderabad, Junagadh, and Kashmir, refused to join India. However, in course of time, they were also integrated with India. India Hyderabad by means of police action, Junagadh by means of referendum, and Kashmir by the instrument of accession. In 1950, the constitution contained a fourfold classification of the states and territories of the Indian Union: Part A, Part B, and Part C states, and Part D territories. In all, they numbered 29. Part A state comprised 9 erstwhile governors' province of British India. Part B states consisted of 9 erstwhile princely states with legislatures. Part C states consisted of erstwhile chief commissioners' provinces of British India and some of the erstwhile princely state. These Part C contains in all 10 in number were centrally administered. The Andaman and Nicobar Islands were capped as the solitary Part D territories. Dhar Commission and JVP Committee. The integration of princely states with the rest of India has purely an ad hoc arrangements. There has been a demand from different regions, particularly South India, for reorganization of states on linguistic basis. Accordingly, in June 1948, the Government of India appointed the Linguistic Provinces Commission under the chairmanship of S.K. Dhar to examine the feasibility of this. The commission submitted its report in December 1948 and recommended the reorganization of states on the basis of administrative convenience rather than the linguistic factor. This created much resentment and led to the appointment of another Linguistic Provinces Committee by the Congress in December 1948 itself to examine the whole question afresh. It consisted of Jawaharlal Nehru, Vallabhbhai Patel, and Pattabhi Sitaramaiah, and hence was popularly known as JVP Committee. It submitted its report in April 1949 and formally rejected language as the basis of reorganization of states. States in Part A: Assam, Bihar, Bombay, Madhya Pradesh, Madras, Odisha, Punjab, United Province, and West Bengal. States in Part B: Hyderabad, Jammu and Kashmir, Madhya Pradesh, Madhya Bharat, Mysore, Patiala in East Punjab, Rajasthan, Saurashtra, Travancore, Cochin, Vindhya Pradesh. States in Part C: Ajmer, Bhopal, Bilaspur, Cooch Behar, Coorg, Delhi, Himachal Pradesh, Kutch, Manipur, Tripura. Territories in Part D: Andaman and Nicobar Islands. However, in October 1953, the Government of India was forced to create the first linguistic state known as Andhra State by separating the Telugu-speaking areas from the Madras State. This followed a prolonged popular agitation and the death of Potri Sriramalu, a congressperson of standing, after a 56-day hunger strike for the cause. Faisal Ali Commission. The creation of Andhra State intensified the demand from other regions for creation of states or linguistic bases. This forced the Government of India to appoint in December 1953 a three-member State Reorganization Commission under the chairmanship of Faisal Ali to re-examine the whole question. Its other two members were K.M. Panikkar and H.N. Kunjru. It submitted its report in September 1955 and broadly accepted language as the basis of reorganization of states, but it rejected the theory of one language, one state. Its view was that the unity of India should be regarded as the primary consideration in any redrawing of the country's political units. It identified four major factors that can be taken into account in any scheme of reorganization of states. Number 1. Preservation and strengthening of the unity and security of the country. Number 2. Linguistic and cultural homogeneity. Number 3. Financial, economic and administrative considerations. Number 4. Planning and promotion of the welfare of the people in each state as well as the nation as a whole. Territory of India in 1956. States: Andhra Pradesh, Assam, Bihar, Bombay, Jammu and Kashmir, Kerala, Madhya Pradesh, Madras, Mysore, Odisha, Punjab, Rajasthan, Uttar Pradesh and West Bengal. Union Territories: Andaman and Nicobar Islands, Delhi, Himachal Pradesh, Lakshadweep, Minicoy and Amindivi Island, Manipur and Tripura. The Commission suggested the abolition of the fourfold classification of states and territories under the original constitution and creation of 16 states and 3 centrally administered territories. The Government of India accepted these recommendations with certain minor modifications by the States Reorganization Act 1956 and the 7th Constitutional Amendment Act 1956. The distinction between Part A and Part B states was done away with and Part C states were abolished. Some of them were merged with adjacent states and some other were designated as union territories. As a result, 14 states and 6 union territories were created on November 1st, 1956. The State Reorganization Act 1956 established the new states of Kerala by merging the Travancore, Cochin state with the Malabar district of Madras state and Kasargod of South Canara, Dakshin Kannada. It merged the Telugu-speaking areas of Hyderabad state with the Andhra state to create the Andhra Pradesh state. Further, it merged the Madhya Bharat state, Vindhya Pradesh state and Bhopal state into the Madhya Pradesh state. Similarly, it merged the Saurashtra state and Kutch state into the Bombay state, the Coorg state into that of Mysore state, the Patiala and East Punjab state union PAPSU into that of Punjab state, and the Ajmer state into the Rajasthan state. Moreover, it created the new union territory of Laccadive, Minicoy and Amin Divi Islands from the territory detached from the Madras state. New states and union territories created after 1956. Even after the large-scale reorganization of the states in 1956, the political map of India underwent continuous changes due to the pressure of popular agitations and political conditions. The demand for the creation of some more states on the basis of language for cultural homogeneity resulted in the bifurcation of existing states. Maharashtra and Gujarat. In 1960, the bilingual state of Bombay was divided into two separate states, Maharashtra and Marathi-speaking people and Gujarat for Gujarati-speaking people. Gujarat was established as the 15th state of the Indian Union. Dadra and Nagar Haveli. The Portuguese ruled this territory until its liberation in 1954. Subsequently, the administration was carried on till 1961 by an administrator chosen by the people themselves. It was converted into a Union Territory of India by the 10th Constitutional Amendment Act 1961. Goa, Daman and Diu. India acquired these three territories from the Portuguese by means of a police action in 1961. They were constituted as a union territory by the 12th Constitutional Amendment Act 1962. Later in 1987, Goa was conferred a statehood. Consequently, Daman and Diu was made a separate union territory. Puducherry. The territory of Puducherry comprises the former French establishments in India known as Puducherry, Karaikal, Mahe and Yanam. The French handed over this territory to India in 1954. Subsequently, it was administered by as an acquired territory till 1962 when it was made a union territory by the 14th Constitutional Amendment Act. Nagaland. In 1963, the state of Nagaland was formed by taking the Naga Hills and Tuensang area out of the state of Assam. This was done to satisfy the movement of the hostile Nagas. However, before giving Nagaland the status of 16th state of Indian Union, it was placed under the control of Governor of Assam in 1961. Haryana, Chandigarh and Himachal Pradesh. In 1966, the state of Punjab was bifurcated to create Haryana. In 17th state of the Indian Union and the Union Territory of Chandigarh. This followed the demand for a separate Sikh homeland Punjabi Suba raised by the Akali Dal under the leadership of Master Tara Singh. On the recommendation of Saha Commission 1966, the Punjabi-speaking areas were constituted into the unilingual state of Punjab, the Hindi-speaking areas were constituted into the state of Haryana, and the hill areas were merged with the adjoining Union Territory of Himachal Pradesh. In 1971, the Union Territory of Himachal Pradesh was elevated to the status of a state, 18th state of the Indian Union. Manipur, Tripura and Meghalaya. In 1972, the political map of northeast India underwent a major change. Thus, the two union territories of Manipur and Tripura and the sub-state of Meghalaya got statehood, and the two union territories of Mizoram and Arunachal Pradesh, originally known as Northeast Frontier Agency, came into being. With this, the number of states of the Indian Union increased to 21, Manipur 19th, Tripura 20th and Meghalaya 21st. Initially, the 22nd Constituent Assembly Act 1969 created Meghalaya as an autonomous state or sub-state within the state of Assam with its own own legislature and council of ministers. However, this did not satisfy the aspiration of the people of Meghalaya. The union territories of Mizoram and Arunachal Pradesh were also formed out of the territories of Assam. Sikkim. Till 1947, Sikkim was an Indian princely state ruled by Chogyal. In 1947, after the lapse of British paramountcy, Sikkim became a protectorate of India, whereby the Indian government assumed responsibility for the defense, external affairs, and communications of Sikkim. In 1974, Sikkim expressed its desire for greater association with India. Accordingly, the 35th Constitutional Amendment Act of 1974 was enacted by the Parliament. This amendment introduced a new class of statehood under the Constitution by conferring on Sikkim the status of an associate state of the Indian Union. For this purpose, a new Article 2A and a new Schedule 10th Schedule containing the terms and conditions of association were inserted in the Constitution. This experiment, however, did not last long as it could not fully satisfy the aspirations of the people of Sikkim. In a referendum held in 1975, they voted for the abolition of the institution of Chogyal and Sikkim becoming an integral part of India. Consequently, the 36th Constitutional Amendment Act 1975 was enacted to make Sikkim a full-fledged state of the Indian Union, the 22nd state. This amendment amended the first and the fourth schedules to Constitution and added a new article 371F to provide for certain special provisions with respect to the administration of Sikkim. It also repealed Article 2A and the 10th schedule that were added by the 35th Amendment Act of 1974. Mizoram, Arunachal Pradesh and Goa. In 1987, three new states of Mizoram, 14 Arunachal Pradesh, 15 and Goa 16 came into being as the 23rd, 24th and 25th states of the Indian Union respectively. The Union Territory of Mizoram was conferred the status of a full state as a sequel to the signing of a Memorandum of Settlement Mizoram Peace Accord in 1986 between the central government and the Mizo National Front, ending the two-decade-old insurgency. Arunachal Pradesh had also been a union territory from 1972. The state of Goa was created by separating the territory of Goa from the union territory of Goa, Daman and Diu. Chhattisgarh, Uttarakhand and Jharkhand. In 2000, three more new states of Chhattisgarh, Uttarakhand and Jharkhand were created out of the territories of Madhya Pradesh, Uttar Pradesh and Bihar respectively. These became the 26th, 27th and 28th states of the Indian Union respectively. Telangana. In 2014, the new state of Telangana came into existence as the 29th state of the Indian Union. It was carved out of the territories of Andhra Pradesh. The Andhra State Act 1953 formed the first linguistic state of India, known as the state of Andhra, by taking out of the Telugu-speaking areas from the state of Madras. Now Tamil Nadu, Kurnool was the capital of Andhra state, and the state high court was established at Guntur. The State Reorganization Act of 1956 merged the Telugu-speaking areas of Hyderabad state with the Andhra state to create the enlarged Andhra Pradesh state. The capital of the state was shifted to Hyderabad. Again, the Andhra Pradesh Reorganization Act 2014 bifurcated the Andhra Pradesh into two separate states, namely the Andhra Pradesh Residuary and the Telangana. Jammu and Kashmir and Ladakh. Till 2019, the erstwhile state of Jammu and Kashmir had its own constitution and thus enjoyed a special status by virtue of Article 370 of the Constitution of India. In 2019, the special status was abolished by a presidential order known as the Constitution Application to Jammu and Kashmir Order 2019. This order superseded the earlier order known as the Constitution Application to Jammu and Kashmir Order 1954. The 2019 order extended all the provisions of the Constitution of India to Jammu and Kashmir also. However, the inoperative Article 370 continued to remain in the text of the Constitution of India. Further, the Jammu and Kashmir Reorganization Act 2019 bifurcated the erstwhile state of Jammu and Kashmir into two separate union territories, namely the Union Territory of Jammu and Kashmir and the Union Territory of Ladakh. The Union Territory of Jammu and Kashmir comprises all the district of erstwhile state of Jammu and Kashmir except the Kargil and Leh district, which have gone to the Union Territory of Ladakh. Thus, the number of states and the union territories increased from 14 and 6 in 1956 to 28 and 2019 respectively. Changes of names. The names of some states in union territories have also been changed. The United Province was the first state to have a new name. It was renamed Uttar Pradesh in 1950. In 1969, Madras was renamed as Tamil Nadu. Similarly, in 1973, Mysore was renamed as Karnataka. In the same year, Lakshadweep, Minicoy, and Amindevi Islands were renamed Lakshadweep. In 1992, the Union Territory of Delhi was redesignated as the National Capital Territory of Delhi without being conferred the status of a full-fledged state by the 69th Constitutional Amendment Act 1991. In 2006, Uttaranchal was renamed as Uttarakhand. In the same year, Pondicherry was renamed as Puducherry. In 2011, Odisha was renamed as Odisha. Currently, we have 28 states and 9 union territories. The states are Andhra Pradesh, Arunachal Pradesh, Assam, Bihar, Chhattisgarh, Goa, Gujarat, Haryana, Himachal Pradesh, Jharkhand, Karnataka, Kerala, Madhya Pradesh, Maharashtra, Manipur, Meghalaya, Mizoram, Nagaland, Odisha, Punjab, Rajasthan, Sikkim, Tamil Nadu, Telangana, Tripura, Uttarakhand, Uttar Pradesh, and West Bengal. Union territories are Andaman and Nicobar Islands, Chandigarh, Dadra and Nagar Haveli, Daman and Diu, Delhi National Capital Territory, Jammu and Kashmir, Ladakh, Lakshadweep, and Puducherry. The theoretical part of this chapter was ended here, but this chapter have further tables about Act and provisions and article number and subject matter. So you can refer to the PDF or the M.Laxmikant book, chapter number 5. Thank you so much. Chapter 6, Citizenship, Meaning and Significance. Like any other modern state, India has two kinds of people, citizens and aliens. Citizens are full members of the Indian state and owe allegiance to it. They enjoy all civil and political rights. Aliens, on the other hand, are the citizens of some other state and hence do not enjoy all the civil and political rights. They are of two categories, friendly aliens or enemy aliens. Friendly aliens are the subjects of those countries that have cordial relations with India. Enemy aliens, on the other hand, are the subjects of that country that is at war with India. They enjoy lesser rights than the friendly aliens. Example, they do not enjoy protection against arrest and detention. Article 22. The Constitution confers the following rights and privileges on the citizens of India and denies the same to aliens. Number 1. Right against discrimination on grounds of religion, race, caste, sex, or place of birth under Article 15. Number 2. Right to equality of opportunity in the matter of public employment under Article 16. Number 3. Right to freedom of speech and expression, assembly, association, movement, residence and profession under Article 19. Number 4. Cultural and educational rights under Article 29 and 30. Number 5. Right to vote in elections to the Lok Sabha and State Legislative Assembly. Number 6. Right to contest for the membership of the Parliament and the State Legislature. Number 7. Eligibility to hold certain public offices, that is President of India, Vice President of India, Judges of the Supreme Court and the High Court, Governors of State, Attorney General of India and Advocate General of States. Along with the above rights, the citizens also owe certain duties towards the Indian state, as for example, paying taxes, respecting the national flag and national anthem, defending the country, and so on. In India, both a citizen by birth as well as a naturalized citizen are eligible for the office of president, while in USA, only a citizen by birth and not a naturalized citizen is eligible for the office of president. Constitutional provisions. The Constitution deals with the citizenship from Article 5 to 11 under Part 2. However, it contains neither any permanent nor any elaborate provisions in this regard. It only identifies the persons who become citizens of India at its commencement, that is, on January 26, 1950. It does not deal with the problem of acquisition or loss of citizenship subsequent to its commencement. It empowers the Parliament to enact a law to provide for such matters and any other matter relating to citizenship. Accordingly, the Parliament has enacted the Citizenship Act 1955, which has been amended from time to time. According to the Constitution, the following four categories of persons became the citizen of India at its commencement, that is, on January 26, 1950. Number 1. A person who had his domicile in India and also fulfilled any one of the three conditions, that is, if he was born in India, or if either of his parents was born in India, or if he has been ordinarily resident in India for 5 years immediately before the commencement of the Constitution, became a citizen of India. Number 2. A person who migrated to India from Pakistan became an Indian citizen if he or either of his parents or any of his grandparents was born in undivided India and also fulfilled any one of the two conditions, that is, in case he migrated to India before July 19, 1948, he had been ordinarily resident in India since the date of his migration, or in case he migrated to India on or after July 19, 1948, he had been registered as a citizen of India, but a person could be so registered only if he had been resident in India for 6 months preceding the date of his application for registration. Number 3. A person who migrated to Pakistan from India after March 1st, 1947, but later returned to India for resettlement could become an Indian citizen. For this, he had to be resident in India for 6 months preceding the date of his application for registration. Number 4. A person who or any of whose parents or grandparents was born in undivided India but who is ordinarily residing outside India shall become an Indian citizen if he has been registered as a citizen of India by the diplomatic or consular representative of India in the country of his residence, whether before or after the commencement of the Constitution. Thus, this provision covers the overseas Indians who may want to acquire Indian citizenship. To sum up, these provisions deal with the citizenship of A. Persons domiciled in India, B. Persons migrated from Pakistan, C. Persons migrated to Pakistan but later returned, D. Persons of Indian origin residing outside India. The other constitutional provisions with respect to the citizenship are as follows. Number 1. No person shall be a citizen of India or be deemed to be a citizen of India if he has voluntarily acquired the citizenship of any foreign state. Number 2. Every person who is or is deemed to be a citizen of India shall continue to be such citizen subject to the provisions of any law made by Parliament. Number 3. Parliament shall have the power to make any provision with respect to the acquisition and termination of citizenship and all other matters relating to citizenship. Citizenship Act 1955. The Citizenship Act of 1955 provides for acquisition and loss of citizenship after the commencement of the Constitution. Originally, the Citizenship Act 1955 also provided for the Commonwealth citizenship, but this provision was repealed by the Citizenship Amendment Act 2003. Acquisition of citizenship. The Citizenship Act of 1955 prescribes 5 ways of acquiring citizenship, that is, birth, descent, registration, naturalization, and incorporation of territory. Number 1. By birth. A person born in India or on after January 26, 1950 but before July 1, 1987 is a citizen of India by birth irrespective of the nationality of his parents. A person born in India on or after July 1, 1987 is considered as a citizen of India only if either of his parents is a citizen of India at the time of his birth. Further, those born in India on or after December 3, 2004 are considered citizens of India only if both of their parents are citizens of India or one of those parents is a citizen of India and the other is not an illegal migrant at the time of their birth. The children of foreign diplomats posted in India and enemy aliens cannot acquire Indian citizenship by birth. Number 2. By descent. A person born outside India on or after January 26, 1950 but before December 10, 1992 is a citizen of India by descent if his father was a citizen of India at the time of his birth. A person born outside India on or after December 10, 1992 is considered as a citizen of India if either of his parents is a citizen of India at the time of his birth. December 3, 2004 onwards, a person born outside India shall not be a citizen of India by descent unless his birth is registered at an Indian consulate within 1 year of the date of birth or with the permission of the central government after the expiry of the said period. An application for registration of the birth of a minor child to an Indian consulate shall be accompanied by an undertaking in writing from the parents of such minor child that he or she does not hold the passport of another country. Further, a minor who is a citizen of India by virtue of descent and is also a citizen of any other country shall cease to be a citizen of India if he does not renounce the citizenship or nationality of another country within 6 months of his attaining full age. Number 3. By registration. The central government may, on an application, register as a citizen of India any person not being an illegal migrant if he belongs to any of the following categories, namely, number 1, a person of Indian origin who is ordinarily resident in India for 7 years before making an application for registration. Number 2, a person of Indian origin who is ordinarily resident in any country or place outside undivided India. Number 3, a person who is married to a citizen of India and is ordinarily resident in India for 7 years before making an application for registration. Number 4, minor children of persons who are citizens of India. Number 5, a person of full age and capacity whose parents are registered as citizens of India. Number 6, a person of full age and capacity who or either of his parents was earlier citizen of independent India and is ordinarily resident in India for 12 months immediately before making an application for registration. Number 7, a person of full age and capacity who has been registered as an overseas citizen of India card holder for 5 years and who is ordinarily resident in India for 12 months before making an application for registration. A person shall be deemed to be of Indian origin if he or either of his parents was born in undivided India or in such other territory which become part of India after the August 15, 1947. All the above categories of persons must take an oath of allegiance before they are registered as citizens of India. Number 4. By naturalization. The central government may, on an application, grant a certificate of naturalization to any person not being an illegal migrant if he possesses the following qualification. Number 1. That he is not a subject or citizen of any country where citizens of India are prevented from becoming subjects or citizens of that country by naturalization. Number 2. That if he is a citizen of any country, he undertakes to renounce the citizenship of that country in the event of his application for Indian citizenship being accepted. Number 3. That he has either resided in India or been in the service of a government in India or partly the one and partly the other throughout the period of 12 months immediately preceding the date of the application. Number 4. That during the 14 years immediately preceding the said period of 12 months, he has either resided in India or been in the service of a government in India or partly the one and partly the other for periods amounting in the aggregate to not less than 11 years. Number 5, that he is of good character. Number 6, that he has an adequate knowledge of a language specified in the 8th schedule of the Constitution. Number 7, that in the event of a certificate of naturalization being granted to him, he intends to reside in India or to enter into or continue in service under a government in India or under an international organization of which India is a member or under a society, company or body of persons established in India. However, the Government of India may waive all or any of the above conditions for naturalization in the case of a person who has rendered distinguished service to the science, philosophy, art, literature, world peace or human progress. Every naturalized citizen must take an oath of allegiance to the Constitution of India. Number 5, by incorporation of territory. If any foreign territory becomes a part of India, the Government of India specifies the persons who among the people of the territory shall be the citizens of India. Such person became the citizen of India from the notified date. For example, when Puducherry became a part of India, the Government of India issued the Citizenship Puducherry Order 1962 under the Citizenship Act 1955. Number 6. Special provisions as to citizenship of persons covered by the Assam Accord. The Citizenship Amendment Act 1985 added the following special provisions as to citizenship of persons covered by the Assam Accord which related to the foreigners issue. Number 1. All persons of Indian origin who came to Assam before the January 1st, 1966 from Bangladesh and who have been ordinarily residents in Assam since the date of their entry into Assam shall be deemed to be citizens of India as from the January 1, 1966. Number 2. Every person of Indian origin who came to Assam on or after the January 1st, 1966, but before the March 25, 1971 from Bangladesh and who has been ordinarily resident in Assam since the date of his entry into Assam and who has been detected to be a foreigner shall register himself. Such a registered person shall be deemed to be a citizen of India for all purposes as from the date of expiry of a period of 10 years from the date of detention as a foreigner, but in the intervening period of 10 years he shall have the same rights and obligations as a citizen of India excepting the right to vote. Loss of citizenship. The Citizenship Act of 1955 prescribes three ways of losing citizenship, whether acquired under the Act or prior to it under the Constitution, that is, renunciation, termination, and deprivation. Number 1. Why renunciation? Any citizen of India of full age and capacity can make a declaration renouncing his Indian citizenship. Upon the registration of that declaration, that person ceases to be a citizen of India. However, if such a declaration is made during a war in which India is engaged, its registration shall be withheld by the central government. Further, when a person renounces his Indian citizenship, every minor child of that person also loses Indian citizenship. However, when such a child attains the age of 18, he may resume Indian citizenship. Number 2. By termination. When an Indian citizen voluntarily, consciously, knowingly, or without duress, undue influence, or compulsion acquires the citizenship of another country, his Indian citizenship automatically terminates. This provision, however, does not apply during a war in which India is engaged. Number 3. By deprivation. It is a compulsory termination of Indian citizenship by the central government if number 1. The citizen has obtained the citizenship by fraud. Number 2. The citizen has shown disloyalty to the Constitution of India. Number 3. The citizen has unlawfully traded or communicated with the enemy during a war. Number 4. The citizen has within 5 years after registration or naturalization been imprisoned in any country for 2 years. Number 5. The citizen has been ordinarily resident out of India for 7 years continuously. Single citizenship. Though the Indian Constitution is federal and in vice case a dual polity, center and states, it provides for only a single citizenship, that is, the Indian citizenship. The citizens in India owe allegiance only to the Union. There is no separate state citizenship. The other federal states like USA and Switzerland, on the other hand, adopted the system of double citizenship. In USA, each person is not only a citizen of USA but also of the particular state to which he belongs. Thus, he owes allegiance to both the state, enjoys dual sets of right, one set conferred by the national government and another by the state government. This system creates the problem of discrimination, that is, a state may discriminate in favor of its citizens in matters like right to vote, right to hold public offices, right to practice professions, and so on. This problem is avoided in the system of single citizenship prevalent in India. In India, all citizens, irrespective of the state in which they are born or reside, enjoy the same political and civil rights of citizenship all over the country, and no discrimination is made between them. However, this general rule of absence of discrimination is subject to some exceptions, that is, number 1, the Parliament under Article 16 can prescribe residence within a state or union territory as a condition for certain employments or appointments in that state or union territory, or local authority or other authority within that state or union territory. Accordingly, the Parliament enacted the Public Employment Requirement as the Residents Act 1957 and thereby authorized the Government of India to prescribe residential qualification only for appointment to non-gazetted posts in Andhra Pradesh, Himachal Pradesh, Manipur and Tripura. As this act expired in 1974, there is no such provisions for any state except Andhra Pradesh and Telangana. Number 2. The Constitution under Article 15 prohibits discrimination against any citizen on grounds of religion, race, caste, sex, or place of birth, and not on the ground of residence. This means that the state can provide special benefits or give preference to its residents in matters that do not come within the purview of the rights given by the Constitution to the Indian citizens. For example, a state may offer concession in fees for education to its residents. Number 3. The freedom of movement and residence under Article 19 is subjected to the protection of interest of any scheduled tribe. In other words, the right of outsiders to enter, reside, and settle in tribal areas is restricted. Of course, this is done to protect the distinctive culture. language, customs, and manners of scheduled tribes and to safeguard their traditional vocation and property against exploitation. Number 4. Till 2019, the legislature of the erstwhile state of Jammu and Kashmir was empowered to define the persons who are permanent resident of the state, confer any special rights and privileges on such permanent residents as respect employment under the state government, acquisition of immovable property in the state, settlement in the state, and right to scholarship and such other forms of aid provided by the government. The above provision was based on Article 35A of the Constitution of India. This article was inserted in the Constitution by the Constitution Application to Jammu and Kashmir Order 1954. This order was issued by the President under Article 370 of the Constitution, which had provided a special status to the erstwhile state of Jammu and Kashmir. In 2019, this special status was abolished by a new presidential order known as the Constitution Application to Jammu and Kashmir Order 2019. This order superseded the earlier 1954 order. The Constitution of India, like that of Canada, has introduced the system of single citizenship and provide uniform rights, except in few cases, for the people of India to promote the feeling of fraternity and unity among them and to build an integrated Indian nation. Despite this, India has been witnessing the communal riots, class conflict, caste wars, linguistic clashes, and ethnic disputes. Thus, the cherished goal of the founding fathers and the constitution makers to build an united and integrated Indian nation has not been fully realized. Overseas citizenship of India. In September 2000, the Government of India, Ministry of External Affairs, had set up a high-level committee on the Indian diaspora under the chairmanship of L.M. Singhvi. The mandate of the committee was to make a comprehensive study of the global Indian diaspora and to recommend measures for a constructive relationship with them. The committee submitted its report in January 2002. It recommended the amendment of the Citizenship Act 1955 to provide for grant of dual citizenship to the persons of Indian origin belonging to certain specified countries. Accordingly, the Citizenship Amendment Act 2003 made provisions for acquisition of overseas citizenship of India by the PIOs of 16 specified countries other than Pakistan and Bangladesh. It also omitted all provisions recognizing or relating to the Commonwealth citizenship from the Principal Act. Later, the Citizenship Amendment Act 2005 expanded the scope of grant of OCI for PIOs of all countries except Pakistan and Bangladesh as long as their home countries all dual citizenship under their local laws. It must be noted here that the OCI is not actually a dual citizenship as the Indian Constitution forbids dual citizenship or dual nationality under Article 9. Again, the Citizenship Amendment Act of 2015 has modified the provisions pertaining to the OCI in the Principal Act. It has introduced a new scheme called Overseas Citizen of India Cardholder by merging the PIO card scheme and the OCI card scheme. The PIO card scheme was introduced on August 19, 2002, and thereafter the OCI card schemes was introduced on December 2, 2005. Both the schemes were running in parallel even though the OCI card scheme had become more popular. This was causing unnecessary confusion in the minds of applicants, keeping in view some problems being faced by applicants and to provide enhanced facilities to them. The Government of India decided to formulate one single scheme after merging the PIO and OCI schemes containing positive attributions of both. Hence, achieving this objective, the Citizenship Amendment Act 2015 was enacted. The PIO scheme was rescinded on January 9, 2015, and it was also notified that all existing PIO cardholders shall be deemed to be OCI cardholders on January 9, 2015. The Citizenship Amendment Act of 2015 replaced the nomenclature of Overseas Citizen of India with that of Overseas Citizen of India cardholder and made the following provisions in the Principal Act. Number 1. Registration of Overseas Citizen of Indian cardholder. The central government may, on an application made in this behalf, register as an Overseas Citizen of India cardholder if any person of full age and capacity who is a citizen of another country but was a citizen of India at a time of or at any time after the commencement of the Constitution, who is a citizen of another country but was eligible to being citizen of India at the time of commencement of the Constitution. Number 3, who is a citizen of another country but belonged to a territory became part of India after the 15th August 1947, who is a child or a grandchild or a great-grandchild of such a person who is minor child of a person mentioned in clause, or a person who is a minor child and whose both parents are citizens of India, or one of the parents is a citizen of India, or spouse of foreign origin of a citizen of India, or spouse of foreign origin of an overseas citizen of India cardholder and whose marriage has been registered and subsisted for a continuous period of not less than 2 years immediately preceding the presentation of the application. No person who or either of whose parents or grandparents or great grandparents is or had been a citizen of Pakistan, Bangladesh, or such other country as the central government may specify shall be eligible for registration as an overseas citizen of India cardholder. The central government may specify the date from which the existing person of Indian origin cardholder shall be deemed to be overseas citizen of Indian cardholders. Notwithstanding anything contained in point number 1, the central government may, if it is satisfied that special circumstances exist, after recording the circumstances and writing, register a person as an overseas citizen of India cardholder. Number 2. Conferment of rights on overseas citizen of Indian cardholder. This point have several points. Number 1, an overseas citizen of Indian cardholder shall be entitled to such rights as the central government may specify in this behalf. Number 2, an overseas citizen of Indian cardholder shall not be entitled to the following rights which are conferred on a citizen of India, that is, he shall not be entitled to the right of equality of opportunity in matters of public employment. He shall not be eligible for election as president. He shall not be eligible for election as vice president. He shall not be eligible for appointment as a judge of the Supreme Court. He shall not be eligible for appointment as a judge of the High Court. He shall not be entitled for registration as a voter. He shall not be eligible for being a member of the House of the People or the Council of State. He shall not be eligible for being a member of the State Legislative Assembly or the State Legislative Council. He shall not be eligible for appointment to public services and post in connection with affairs of the Union or any state except for appointment in such services and post as the central government may specify. Number 3. Renunciation of overseas citizen of Indian card. If any overseas citizen of India cardholder makes in prescribed manner or declaration renouncing the card registering him as an overseas citizen of India cardholder, the declaration shall be registered by the central government, and upon such registration that person shall cease to be an overseas citizen of Indian cardholder. Where a person ceases to be an overseas citizen of India cardholder, the spouse of foreign origin of that person who has obtained overseas citizen of India card and every minor child of that person registered as an overseas citizen of Indian cardholder shall thereupon cease to be an overseas citizen of India cardholder. Number 4. Cancellation of registration as overseas citizen of Indian cardholder. The central government may cancel the registration of a person as an overseas citizen of Indian cardholder if it is satisfied that number 1. The registration as an overseas citizen of Indian cardholder was obtained by means of fraud, false representation, or the concealment of any material fact, or number 2, the overseas citizen of Indian cardholder has shown disaffection towards the Constitution of India. Number 3, the overseas citizen of India cardholder has, during any war in which India may be engaged, unlawfully traded or communicated with an enemy, or number 4, the overseas citizen of India cardholder has, within 5 years after registration, been sentenced to imprisonment for a term of not less than 2 years. Number 5, it is necessary so to do in the interest of the sovereignty and integrity of India, the security of India, friendly relations of India with any foreign country, or in the interest of the general public. Number 6, the marriage of an overseas citizen of India cardholder has been dissolved by a competent court of law or otherwise, or has not been dissolved but during the subsistence of such marriage he has solemnized marriage with any other person. This chapter ended here, but there is a table in this chapter which is talking about comparing NRI, PIO and OCI cardholders. For referring that table, you can read PDF or the M.Laxmikant book chapter number 6 and another table which included articles related to citizenship at a glance. Thank you so much. Chapter 7, Fundamental Rights. The fundamental rights are enshrined in Part 3rd of the Constitution from Articles 12 to 35. In this regard, the framers of the Constitution derived inspiration from the Constitution of USA, that is Bill of Rights. Part 3rd of the Constitution is rightly described as the Magna Carta of India. It contains a very long and comprehensive list of justiciable fundamental rights. In fact, the fundamental rights in our Constitution are more elaborate than those found in the Constitution of any other country in the world, including the USA. The fundamental rights are guaranteed by the Constitution to all the persons without any discrimination. They uphold the equality of all individuals, the dignity of the individual, the larger public interest, and unity of the nation. The fundamental rights are meant for promoting the ideal of political democracy. They prevent the establishment of an authoritarian and despotic rule in the country and protect the liberties and freedoms of the people against the invasion by the state. They operate as limitations on the tyranny of the executive and arbitrary laws of the legislature. In short, they aim at establishing a government of laws and not a man. The fundamental rights are named so because they are guaranteed and protected by the Constitution, which is the fundamental law of the land. They are fundamental also in the sense that they are most essential for the all round development, material, intellectual, moral, and spiritual of the individuals. Originally, the Constitution provided for 7 fundamental rights, that is, number 1, right to equality under Article 14 to 18, number 2, right to freedom under Article 19 to 22, number 3, right against exploitation under Article 23 to 24, number 4, right to freedom of religion, Article 25 to 28, number 5, cultural and educational rights, Article 29 to 30, right to property, Article 31, right to constitutional remedies, Article 32. However, the right to property was deleted from the list of fundamental rights by the 44th Amendment Act in 1978. It is made a legal right under Article 300A in Part 12 of the Constitution. So at present, there are only 6 fundamental rights. Features of fundamental rights. The fundamental rights guaranteed by the Constitution are characterized by the following. Number 1. Some of them are available only to the citizens, while others are available to all persons, whether citizens, foreigners, or legal persons like corporations or companies. Number 2. They are not absolute but qualified. The state can impose reasonable restrictions on them. However, whether such restrictions are reasonable or not is to be decided by the courts. Thus, they strike a balance between the rights of the individual and those of the society as a whole, between individual liberty and social control. Number 3. All of them are available against the arbitrary action of the state. However, some of them are also available against the action of private individuals. Number 4. Some of them are negative in character, that is, place limitations on the authority of the state, while others are positive in nature, conferring certain privileges on the persons. Number 5. They are justiciable, allowing persons to move the courts for their enforcement if and when they are violated. Number 6. They are defended and guaranteed by the Supreme Court. Hence, the aggrieved person can directly go to the Supreme Court, not necessarily by way of appeal against the judgment of High Court. Number 7. They are not sacrosanct or permanent. The Parliament can curtail or repeal them, but only by a Constitutional Amendment Act and not by an ordinary act. Moreover, this can be done without affecting the basic structure of the Constitution. Number 8. They can be suspended during the operation of a national emergency except the rights guaranteed by Articles 20 and 21. Further, the 6 rights guaranteed by Article 19 can be suspended only when emergency is declared on the grounds of war or external aggression, external emergency, and not on the ground of armed rebellion, that is internal emergency. Number 9. Their scope of operation is limited by Article 31A, saving of laws, providing for acquisition of estates, etc. Article 31B, validation of certain acts and regulations included in the 9th schedule, and Article 31C, saving of laws giving effect to certain directive principles. Number 10. Their application to the members of armed forces, paramilitary forces, police forces, intelligence agencies, and analogous services can be restricted or abrogated by the Parliament, Article 33. Number 11. Their application can be restricted while martial law is in force in any area. Martial law means military rule imposed under abnormal circumstances to restore order under Article 34. It is different from the imposition of national emergency. Number 12. Most of them are directly enforceable, self executory, while a few of them can be enforced on the basis of a law made for giving effect to them. Such a law can be made only by the Parliament and not by state legislature, so that uniformity throughout the country is maintained under Article 35. Definition of a state. The term state has been used in different provisions concerning the fundamental rights. Hence, Article 12 has defined the term for the purpose of Part 3rd. According to it, state includes the following. Number 1. Government and Parliament of India, that is executive and legislative organ of the Union Government. Number 2. Government and legislature of a state, that is executive and legislative organ of the state government. Number 3. All local authority, that is municipalities, panchayats, district board, improvement trust, etc. Number 4. All other authorities, that is statutory or non-statutory authority like LIC, ONGC, SAIL, etc. Thus, state has been defined in a wider sense so as to include all its agencies. It is the action of these agencies that can be challenged in the courts or violating the fundamental rights. According to the Supreme Court, even a private body or an agency working as an instrument of the state falls within the meaning of the state under Article 12. Laws inconsistent with fundamental rights. Article 13 declares that all laws that are inconsistent with or in derogation of any of the fundamental rights shall be void. In other words, it expressively provides for the doctrine of judicial review. This power has been conferred on the Supreme Court under Article 32 and the High Courts under Article 226 that can declare a law unconstitutional and invalid on the ground of contravention of any of the fundamental rights. The term law in Article 13 has been given a wide connotation so as to include the following. Number 1. Permanent laws enacted by the Parliament or the state legislature. Number 2. Temporary laws like ordinances issued by the President or the state governors. Number 3. Statutory instruments in the nature of delegated legislation, executive legislation like order, bylaw, rule, regulation, or notification. Number 4. Non-legislative sources of law, that is, custom or uses having the force of law. Thus, not only a legislation but any of the above can be challenged in the courts as violating a fundamental right and hence can be declared as void. Further, Article 13 declares that a constitutional amendment is not a law and hence cannot be challenged. However, the Supreme Court held in the Keshwanand Bharti case of 1973 that a constitutional amendment can be challenged on the ground that it violates a fundamental right that forms a part of the basic structure of the Constitution and hence can be declared as void. Table number 7.1, Fundamental Right at a Glance. Number 1. Right to equality, Article 14 to 18. It consists of equality before law and equal protection of law under Article 14. Prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth under Article 15. Equality of opportunity in matters of public employment under Article 16. Abolition of untouchability and prohibition of its practice under Article 17. Abolition of titles except military and academic, Articles 18. Number 2. Right to freedom under Article 19 to 22. It consists of protection of 6 rights regarding freedom of speech and expression, assembly, association, movement, residence or profession under Article 19. Protection in respect of conviction for offences under Article 20. Protection of life and personal liberty under Article 21. Right to elementary education under Article 21A. Protection against arrest and detention in certain cases under Article 22. Number 3. Right against exploitation under Article 23 to 24. Prohibition of traffic in human being and forced labor under Article 23. Prohibition of employment of children in factories under Article 24. Number 4. Right to freedom of religion under Article 25 to 28. Freedom of conscience and free profession, practice and propagation of religion under Article 25. Freedom to manage religious affairs under Article 26. Freedom from payment of taxes for promotion of any religion under Article 27. Freedom from attending religious instruction or worship in certain educational institution, Article 28. Number 5. Cultural and educational rights under Article 29 and 30. Protection of language, script, and culture of minorities under Article 29. Right of minorities to establish and administer educational institutions under Article 30. Number 6. Right to constitutional remedies, Article 32. Right to move the Supreme Court for the enforcement of fundamental rights, including the writs of habeas corpus, mandamus, prohibition, certiorari, and quo warranto under Article 32. Table number 7.2. Fundamental rights of foreigners. Fundamental right available only to citizens and not to foreigners. Number 1. Prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth under Article 15. Number 2. Equality of opportunity in matters of public employment under Article 16. Number 3. Protection of 6 rights regarding freedom of speech and expression, assembly, association, movement, residence, and profession under Article 19. Number 4. Protection of life and personal liberty under Article 21. Number 5. Right of minorities to establish and administer educational institutions under Article 30. Fundamental rights available to both citizen and foreigners except enemy aliens. Number 1. Equality before law and equal protection of laws under Article 14. Number 2. Protection in respect of conviction for offences under Article 20. Number 3. Protection of life and personal liberty under Article 21. Number 4. Right to elementary education under Article 21A. Number 5. Protection against arrest and detention in certain cases under Article 22. Number 6. Prohibition of traffic in human beings and forced labor under Article 23. Number 7. Prohibition of employment of children in factories under Article 24. Number 8. Freedom of conscience and free profession, practice and propagation of religion under Article 25. Number 9. Freedom to manage religious affairs, Article 26. Number 10. Freedom from payment of taxes for promotion of any religion, Article 27. Number 11. Freedom from attending religious instruction or worship in a certain educational institutions. Right to equality. Number 1. Equality before law and equal protection of laws. Article 14 says that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. This provision confers rights on all persons, whether citizens or foreigners. Moreover, the word person includes legal persons, that is, statutory corporations, companies, registered societies, or any other type of legal person. The concept of equality before law is of British origin, while the concept of equal protection of law has been taken from the American Constitution. The first concept connotes the absence of any special privileges in favor of any person, the equal subjection of all persons to the ordinary law of the land administered by ordinary law courts, and no person, whether rich or poor, high or low, official or non-official, is above the law. The second concept, on the other hand, connotes the equality of treatment under equal circumstances, both in the privileges conferred and liabilities imposed by the laws. The similar application of the same laws to all persons who are similarly situated, and the like should be treated alike without any discrimination. Thus, the former is a negative concept while the latter is a positive concept. However, both of them aim at establishing equality of legal status, opportunity, and justice. The Supreme Court held that where equals and unequals are treated differently, Article 14 does not apply, while Article 14 forbids class legislation. It permits reasonable classification of persons, objects, and transactions by the law, but the classification should not be arbitrary, artificial, or evasive. Rather, it should be based on an intelligible, differential, and substantial distinction. Rule of law. The concept of equality before law is an element of the concept of rule of law propounded by A.V. Dicey, the British jurist. His concept has the following 3 elements or aspect. Number 1. Absence of arbitrary power, that is, no man can be punished except for a breach of law. Number 2. Equality before the law, that is, equal subjugation of all citizens, rich or poor, high or low, official or non-official, to the ordinary law of the land administered by the ordinary law courts. Number 3. The primacy of the rights of the individual, that is, the Constitution is the result of the rights of the individual as defined and enforced by the courts of law rather than the Constitution being the source of the individual rights. The first and the second elements are applicable to the Indian system and not the third one. In the Indian system, the Constitution is the source of the individual rights. The Supreme Court held that the rule of law, as embodied in Article 14, is a basic feature of the Constitution. Hence, it cannot be destroyed even by an amendment. Exceptions to equality. The rule of equality before law is not absolute and there are constitutional and other exceptions to it. These are mentioned below. Number 1. The President of India and the Governor of States enjoy the following immunities under Article 361. First, the President or the Governor is not answerable to any court the exercise and performance of powers and duties of the office. Second, no criminal proceedings shall be instituted or continued and the President or the Governor in any court during his terms of office. Third, no process for arrest or imprisonment of the President or Governor shall be issued from any court during his term of office. Fourth, no civil proceedings against the President or the Governor to be instituted during his term of office in any court in respect of act done by him in his personal capacity, whether before or after he entered upon his office, until the expiration of 2 months and after notice has been delivered to him. Number 2. No person shall be liable to any civil or criminal proceedings in any court in respect of the publication of in a newspaper or by radio or television of a substantially true report of any proceedings of either House of Parliament or either House of the Legislature of a state under Article 361A. Number 3. No member of Parliament shall be liable to any proceedings in any court in respect of anything said or any vote against given by him in Parliament or any committee thereof, Article 105. Number 4. No member of the legislature of a state shall be liable to any proceedings in any court in respect of anything said or any vote given by him in the legislature or any committee thereof, Article 194. Number 5. Article 31C is an exception to Article 14. It provides that the laws made by the state for implementing the directive principles contained in Clause B or Clause C of Article 39 cannot be challenged on the grounds that they are violative of Article 14. The Supreme Court held that where Article 31C comes in, Article 14 goes out. Number 6. The foreign sovereigns, ambassadors and diplomats enjoy immunity from criminal and civil proceedings. Number 7. The UNO and its agencies enjoy the diplomatic immunity. Number 2. Prohibition of discrimination on certain grounds. Article 15 provides that the state shall not discriminate against any citizens on grounds only of religion, race, caste, sex, or place of birth. The two crucial words in this provision are discrimination and only. The word discrimination means to make an adverse distinction between with regard to or distinguished unfavorably from others. The use of the word only connotes the discrimination on other grounds is not prohibited. The second provision of Article 15 says that no citizen shall be subjected to any disability, liability, restriction or condition on grounds only of religion, race, caste, sex or place of birth with regard to access to shops, public restaurants, hotels and places of public entertainment. The use of wells, tanks, bathing ghats, roads and places of public resort maintained wholly or partly by state funds to the dedicated to the use of general public. This provision prohibits discrimination both by the state and private individuals, while the former provisions prohibits discrimination only by the state. There are 4 exceptions to this general rule of non-discrimination. Number 1. The state is permitted to make any special provisions for women and children, for example, reservation of seats for women in local bodies or provisions of free education for children. Number 2. The state is permitted to make any special provisions for the advancement of any socially and educationally backward classes of citizens or for the scheduled caste and scheduled tribes. For example, reservation of seats or fee concessions in public educational institutions. Number 3. The state is empowered to make any special provisions for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes or the scheduled tribes regarding their admission to educational institutions. including private educational institutions, whether aided or unaided by the state, except the minority educational institutions. Number 4. The state is empowered to make any special provisions for the advancement of any economically weaker section of citizens. Further, the state is allowed to make a provision for the reservation of up to 10% of seats for such sections in admission to educational institutions, including private educational institutions, whether aided or unaided by the state, except the minority educational institutions. This reservation of up to 10% would be in addition to the existing reservations. For this purpose, the economically weaker section should be notified by the state from time to time on the basis of family income and other indicators of economic disadvantage. Reservation for OBCs in educational institutions. The above exception was added by the 93rd Amendment Act of 2005. In order to give effect to this provision, the Centre enacted the Central Educational Institutions Reservation in Admission Act 2006, providing a quota of 27% for candidates belonging to the other backward classes in all central higher educational institutions, including the Indian Institute of Technology and the Indian Institute of Management. In April 2008, the Supreme Court upheld the validity of both the Amendment Act and the OBC Quota Act, but the court directed the central government to exclude the creamy layer advanced sections among the OBCs while implementing the law. The children of the following different categories of people belong to creamy layer among OBCs and thus will not get the quota benefit. Number 1. Persons holding constitutional posts like President, Vice President, Judges of Supreme Court and High Court, Chairman and Member of UPSC and SPSC, CEC, CAG and so on. Number 2. Group A, Class 1 and Group B, Class 2 officers of the All India Central and State Services and employees holding equivalent posts in PSUs, banks, insurance organizations, universities, etc. and also in private employment. Number 3. Persons who are in the rank of colonel and above in the army and equivalent post in the navy, the air force and the paramilitary forces. Professionals like doctors, lawyers, engineers, artists, authors, consultants and so on. Number 5. Person engaged in trade, business and industry. Number 6. People holding agricultural land above a certain limit and vacant land or buildings in urban areas. Number 7. Persons having gross annual income of more than rupees 8 lakh or possessing wealth above the exemption limit. In 1993, when the creamy layer ceiling was introduced, it was rupees 1 lakh. It was subsequently revised to rupees 2.5 lakh in 2004, rupees 4.5 lakh in 2008, rupees 6 lakh in 2013 and rupees 8 lakh in 2017. Reservation for EWS in educational institutions. The above exceptions was added by the 103rd Amendment Act of 2019. In order to give effect to this provision, the central government issued an order in 2019 providing 10% reservation to the economically weaker section in admission to educational institutions. The benefit of this reservation can be availed by the persons belonging to EWS who are not covered under any of the existing schemes of reservations for SC, ST and OBCs. The eligibility criteria laid down in this regard is as follows. Number 1. Persons whose family has gross annual income below rupees 8 lakh are to be identified as EWS for the benefit of reservation. The income would include income from all sources, that is salary, agriculture, business, profession, etc. and it would be income for the financial year prior to the year of application. Number 2. Persons whose family owns or possesses any one of the following assets are to be excluded from being identified as EWS, irrespective of the family income. 5 acres of agricultural land and above, residential flat of 1000 square feet and above, residential plot of 100 square yards and above in notified municipality, residential plot of 200 square yards and above in areas other than the notified municipalities. Number 3. The property held by a family in different locations or different places, cities would be clubbed while applying the land or property holding test to determine EWS status. Number 4. Family for this purpose would include the person who seeks benefit of reservation, his or her parents and siblings belong the age of 18 years and also his or her spouse and children below the age of 18 years. Number 3. Equality of opportunity in public employment. Article 16 provides for equality of opportunity for all citizens in matters of employment or appointed to any office under the state. No citizen can be discriminated against or be ineligible for any employment or office under the state on grounds of only religion, race, caste, sex, descent, place of birth, or residence. There are four exceptions to this general rule of equality of opportunity in public employment. Number one, Parliament can prescribe residence as a condition for certain employment or appointment in a state or union territory or local authority or other authority, as the Public Employment Requirement as to Residence Act of 1957 expired in 1974. There is no such provision for any state except Andhra Pradesh and Telangana. Number two, the state can provide for reservation of appointments or post in favor of any backward class that is not adequately represented in the state services. Number three, a law can provide that the incumbent of an office related to religious or denominational institution or a member of its governing body should belong to the particular religion or denomination. Number four, the state is permitted to make a provision for the reservation of up to 10% of appointments or posts in favor of any economically weaker section of citizen. This reservation of up to 10% would be in addition to the existing reservation. For this purpose, the economically weaker section should be notified by the state from time to time on the basis of family income and other indicators of economic disadvantage. Mandal Commission and Aftermath. In 1979, the Morarji Desai government appointed the Second Backward Classes Commission under the chairmanship of B.P. Mandal, a member of parliament, in terms of Article 340 of the Constitution, to investigate the conditions of the socially and economically, educationally backward classes and suggest measures for their advancement. The Commission submitted its report in 1980 and identified as many as 3743 castes as socially and educationally backward classes. They constitute nearly 52% component of the population, excluding the SC/ST. The Commission recommended the reservation of 27% government jobs for the other backward classes so that the total reservation for all SC, ST and OBCs amount to 50%. It was after 10 years in 1990 that the VP Singh government declared reservation of 27% government jobs for the OBCs. Again in 1991, the Narasimha Rao government introduced two changes: preference to the poorer section among the OBCs in 27% quota, that is, adoption of the economic criteria in granting reservation, and reservation of another 10% of jobs for poorer economically backward sections of higher castes who are not covered by any existing schemes of reservation. In the famous Mandal case of 1992, the scope and extent of Article 16(4), which provides for reservation of jobs in favor of backward classes, has been examined thoroughly by the Supreme Court. Though the court has rejected the additional reservation of 10% for poorer section of higher castes, it upheld the constitutional validity of 27% reservation for the OBCs with certain conditions. That is, the advanced section among the OBCs, the creamy layer, should be excluded from the list of beneficiary of reservation. This was point number A. Point number B. No reservation in promotions. Reservation should be confined to initial appointments only. Any existing reservation in promotions can continue for 5 years only, that is up to 1997. Point number C. The total reserved quota should not exceed 50% except in some extraordinary situations. This rule should be applied every year. Now, point number D. The carry forward rule in case of unfiled backlog vacancies is valid, but it should not violate 50% rule. Point number E. A permanent statutory body should be established to examine complaints of over-inclusion and under-inclusion in the list of OBCs. With regard to the above ruling, the Supreme Court, the government has taken the following actions. Point number A. Ram Nandan Committee was appointed to identify the creamy layer among the OBCs. It submitted its report in 93, which was accepted. Point number B. National Commission for Backward Classes was established in 1993 by an Act of Parliament. Its mandate was to examine the complaints of under-inclusion, over-inclusion or non-inclusion of any class of citizens in the list of backward classes for the purpose of job reservation. Later, the 102nd Amendment Act of 2018 conferred a constitutional status on the Commission and also enlarged its functions. For this purpose, the amendment inserted a new Article 338B in the Constitution. Point number C. In order to nullify the ruling with regard to reservation in promotion, the 77th Amendment Act was enacted in 1995. It added a new provisions in Article 16 that empowers the state to provide for reservation in promotion of any service under the state in favor of the SC and ST and that are not adequately represented in the state services. Again, The 85th Amendment Act of 2001 provides for consequential seniority in the case of promotion or by virtue of rule of reservation for the government servants belonging to the SC and ST with retrospective effect from June 1995. Point number D. The ruling with regard to backlog vacancies was nullified by the 81st Constitutional Amendment Act of 2000. It added another new provisions in Article 16 that empowers the state to consider the unified reserved vacancies of a year as a separate class of vacancies to be filed up in any succeeding year or years. Such class of vacancies are not to be combined with the vacancies of the year in which they are being filed up to determine the ceiling of 50% reservation on total number of vacancies of that year. In brief, it ends the 50% ceiling on reservation in backlog vacancies. Point number E. The 76th Amendment Act of 1994 has placed the Tamil Nadu Reservation Act of 1994 in the 9th schedule to protect it from judicial review, as it provided for 69% of reservation, far exceeding the 50% ceiling. Reservation for EWS in public employment. The above exception was added by the 103rd Amendment Act of 2019. In order to give effect to this provision, the central government issued an order in 2019 providing 10% reservation to the economically weaker section in civil post and services in the Government of India. The benefit of this reservation can be availed by the persons belonging to the EWS who are not covered under any of the existing schemes of reservation for SC, ST and OBCs. The eligibility criteria laid down in this regard had already been explained under Article 15. Further, the scientific and technical posts which satisfy all the following conditions can be exempted from the purview of this reservation. First, the post should be in grades above the lower grades in Group A of the service concerned. Second, they should be classified as scientific or technical in terms of Cabinet Secretariat Order 1961, according to which scientific and technical post for which qualifications in the natural sciences or exact sciences or applied sciences or in technology or prescribed and incumbents of which have to use that knowledge in the discharge of their duties. 3. The post should be for conducting research or for gazetting, organizing, guiding and directing research. Number 4. Abolition of untouchability. Article 17 abolishes untouchability and forbids its practice in any form. The enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with law. In 1976, the Untouchability Offences Act 1955 has been comprehensively amended and renamed as the Protection of Civil Rights Act 1955 to enlarge the scope and make penal provisions more stringent. The Act defines civil rights as any right accruing to a person by reason of the abolition of untouchability by Article 17 of the Constitution. The term untouchability has not been defined either in the Constitution or in the Act. However, the Mysore High Court held that the subject matter of Article 17 is not untouchability in its literal or grammatical sense, but the practice as it had developed historically in the country. It refers to the social disabilities imposed on certain classes of persons by reasons of their birth in certain castes. Hence, it does not cover any social boycott of a few individuals for their exclusion from religion services, etc. The Supreme Court held that the right under Article 17 is available against private individuals, and it is the constitutional obligations of the state to take necessary action to ensure that this right is not violated. Number 5. Abolition of titles. Article 18 abolishes titles and makes 4 provisions in that regard. A. It prohibits the state from conferring any title except a military or academic distinction or any body, whether a citizen or a foreigner. B. It prohibits a citizen of India from accepting any title from any foreign state. C. A foreigner holding any office of profit or trust under the state cannot accept any title from any foreign state without the consent of the President. D. No citizen or foreigner holding any office of profit or trust under the state is to accept any present, emolument or office from or under any foreign state without the consent of the President. From the above, it is clear that the hereditary titles of nobility like Maharaja, Rai Bahadur, Rai Sahib, Diwan Bahadur, etc., which were conferred by colonial states, are banned by Article 18, as these are against the principle of equal status of all. In 1996, the Supreme Court upheld the constitutional validity of the national awards Bharat Ratna, Padma Vibhushan, Padma Bhushan, and Padma Shri. It ruled that these awards do not amount to titles within the meaning of Article 18 that prohibits only hereditary titles of nobility. Therefore, they are not violative of Article 18 as the theory of equality does not mandate that merit should not be recognized. However, it also ruled that they should not be used as suffixes or prefixes to the names of awardees. Otherwise, they should forfeit the awards. These national awards were instituted in 1954. The Janata Party government headed by Morarji Desai discontinued them in 1977, but they were again revived in 1980 by Indira Gandhi government. Right to freedom. Number 1. Protection of six rights. Article 19 guarantees to all citizens the six rights. These are: first, right to freedom of speech and expression; second, right to assemble peaceably and without arms; third, right to form associations or unions or cooperative societies; fourth, right to move freely throughout the territory of India; fifth, right to reside and settle in any part of the territory of India; sixth, right to practice any profession or to carry on any occupation, trade, or business. Originally, Article 19 contained 7 rights, but the right to acquire, hold, and dispose of property was deleted by the 44th Amendment Act of 1978. These 6 rights are protected against only state action and not private individuals. Moreover, these rights are available only to the citizens and to shareholders of a company, but not to foreigners or legal persons like companies or corporations, etc. The state can impose reasonable restrictions on the enjoyment of these 6 rights only on the grounds mentioned in the Article 19 itself and not on any other grounds. Freedom of speech and expression. It implies that every citizen has the right to express his views, opinions, beliefs, and convictions freely by word of mouth, writing, printing, picturing, or any other manner. The Supreme Court held that the freedom of speech and expression includes the following. First, right to propagate one's views as well as views of others. Second, freedom of the press. Third, freedom of commercial advertisements. Fourth, right against tapping of telephonic conversation. Fifth, right to telecast, that is, government has no monopoly on electronic media. Sixth, right against bandh called by a political party or organization. Seventh, right to know about government activities. 8th, right of freedom of silence. 9th, right against imposition of pre-censorship on a newspaper. 10. Right to demonstration or picketing but not right to strike. The state can impose reasonable restrictions on the exercise of the freedom of speech and expression on the grounds of sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, decency or morality, contempt of court, defamation, and incitement to an offense. Freedom of assembly. Every citizen has the right to assemble peaceably and without arms. It includes the right to hold public meetings, demonstrations, and take out processions. This freedom can be exercised only by public, and the assembly must be peaceful, and unarmed. This provision does not protect violent, disorderly, riotous assemblies, or one that causes breach of public peace or one that involves arms. This right does not include the right to strike. The state can impose reasonable restrictions on the exercise of right of assembly on 2 grounds, namely sovereignty and integrity of India and public order, including the maintenance of traffic in the area concerned. Under Section 144 of Criminal Procedure Code 1973, a magistrate can restrain an assembly, meeting or procession if there is a risk of obstruction, annoyance or danger to human life, health or safety, or a disturbance of the public tranquility or a riot or any affray. Under Section 141 of the Indian Penal Code, an assembly of 5 or more persons becomes unlawful if the object is to resist the execution of any law or legal process, to forcibly occupy the property of some person, to commit any mischief or criminal trespass, to force some person to do an illegal act, and to threaten the government or the officials on exercising lawful powers. Freedom of association. All citizens have the right to form associations or unions or cooperative societies. It includes the right to form political parties, companies, partnership firms, societies, clubs, organizations, trade unions, or any body of persons. It not only includes the right to start an association or union, but also to continue with the association or union as such Further, it covers the negative right of not to form or join an association or union. Reasonable restriction can be imposed on the exercise of this right by the state on the grounds of sovereignty and integrity of India, public order and morality. Subject to these restrictions, the citizens have complete liberty to form associations or unions for pursuing lawful objectives and purposes. However, the right to obtain recognition of the association is not a fundamental right. The Supreme Court held that the trade unions have no guaranteed right to effective bargaining or right to strike or right to declare a lockout. The right to strike can be controlled by an appropriate industrial law, freedom of movement. This freedom entitles every citizen to move freely throughout the territory of the country. He can move freely from one state to another or from one place to another within a state. This right underlines the idea that India is one unit so far as the citizens are concerned. Thus, the purpose is to promote national feeling, not parochialism. The grounds of imposing reasonable restrictions on this freedom are two, namely the interest of general public and the protection of interest of any scheduled tribe. The entry of outsiders in tribal areas is restricted to protect the distinctive culture, language, customs, and manners of scheduled tribes and to safeguard their traditional vocation and properties against exploitation. The Supreme Court held that the freedom of movement of prostitutes can be restricted on the ground of public health and in the interest of public morals. The Bombay High Court validated the restrictions on the movement of persons affected by AIDS. The freedom of movement has two dimensions, that is, internal, right to move inside the country, and external, right to move out of the country, and right to come back to the country. Article 19 protects only the first dimension. The second dimension is dealt by Article 21, right to life and personal liberty. Freedom of residence. Every citizen has the right to reside and settle in any part of the territory of the country. This right has two parts. First, the right to reside in any part of the country, which means to stay at any place temporarily. And second, the right to settle in any part of the country, which means to set up a home or domicile at any place permanently. This right is intended to remove internal barriers within the country or between any of its parts. This promotes nationalism and avoids narrow-mindedness. The state can impose reasonable restrictions on the exercise of this right on two grounds, namely the interest of general public and the protection of interest of any scheduled tribes. The right of outsiders to reside and settle in tribal areas is restricted to protect the distinctive culture, language, custom and manners of scheduled tribes and to safeguard their traditional vocation and properties against exploitation. In many parts of the country, the tribals have been permitted to regulate their property rights in accordance with their customary rules and laws. The Supreme Court held that certain areas can be banned for certain kinds of persons like prostitutes and habitual offenders. From the above, it is clear that the right to residence and the right to movement are overlapping to some extent. Both are complementary to each other. Freedom of profession, etc. All citizens are given the right to practice any profession or to carry on any occupation, trade or business. This right is very wide as it covers all the means of earning one's livelihood. The state can impose reasonable restrictions on the exercise of this right in the interest of the general public. Further, the state is empowered to: first, prescribe professional or technical qualifications necessary for practicing any profession or carrying on any occupation, trade or business. Second, carry on by itself any trade, business, industry or service, whether to the exclusion, complete or partial, of citizens or otherwise. Thus, no objection can be made when the state carries on a trade, business, industry or service either as a monopoly, complete or partial, to the exclusion of citizens, all or some only, or in competition with any citizen. The state is not required to justify its monopoly. This right does not include the right to carry on a profession or business or trade or occupation that is immoral, trafficking in women or children, or dangerous harmful drugs or explosives, etc. The state can absolutely prohibit these or regulate them through licensing. Number 2. Protection in respect of conviction for offences. Article 20 grants protection against arbitrary and excessive punishment to an accused person, whether citizen or foreigner or legal person like a company or a corporation. It contains 3 provisions in that direction. First, no ex post facto law. No person shall be convicted of any offence except for violation of a law in force at the time of the commission of the act, nor subjected to a penalty greater than the prescribed by the law in force at the time of the commission of the act. Second, no double jeopardy. No person shall be prosecuted and punished for the same offence more than once. Third, no self-incrimination. No person accused of any offence shall be compelled to be a witness against himself. An ex post facto law is one that imposes penalties retroactively, that is, upon acts already done or which increases the penalties for such act. The enactment of such a law is prohibited by the first provision of Article 20. However, this limitation is imposed only on criminal laws and not on civil laws or tax laws. In other words, a civil liability or a tax can be imposed retrospectively. Further, this provision prohibits only conviction or sentence under an ex post facto criminal law and not the trial thereof. Finally, the protection immunity under this provision cannot be claimed in case of preventive detention or demanding security from a person. The protection against double jeopardy is available only in proceedings before a court of law or a judicial tribunal. In other words, it is not available in proceedings before departmental or administrative authorities as they are not of judicial nature. The protection against self-incrimination extends to both oral evidence and documentary evidence. However, it does not extend to: first, compulsory production of materials object; second, compulsion to give thumb impression, specimen signature, blood specimens; third, compulsory exhibition of the body. Further, it extends only to criminal proceedings and not to civil proceedings or proceedings which are not of criminal nature. Number 3. Protection of life and personal liberty. Article 21 declares that no person shall be deprived of his life or personal liberty except according to procedure established by law. This right is available to both citizens and non-citizens. In the famous Gopalan case of 1950, the Supreme Court has taken a narrow interpretation of the Article 21. It held that the protection under Article 21 is available only against arbitrary executive action and not from arbitrary legislative action. This means that the state can deprive the right to life and personal liberty of a person based on a law. This is because of the expression procedure established by law in Article 21, which is different from the expression due process of law contained in the American Constitution. Hence, the validity of a law that has prescribed a procedure cannot be questioned on the ground that the law is unreasonable, unfair, or unjust. Secondly, the Supreme Court held that the personal liberty means only liberty relating to the person or body of the individual, but in Menka case of 1978, the Supreme Court overruled its judgment in the Gopalan case by taking a wider interpretation of the Article 21. Therefore, it ruled that the right to life and personal liberty of a person can be deprived by a law provided the procedures prescribed by that law is reasonable, fair, and just. In other words, it has introduced the American expression due process of law. In effect, the protection under Article 21 should be available not only against arbitrary executive action but also against arbitrary legislative action. Further, the court held that the right to life as embodied in Article 21 is not merely confined to animal existence or survival, but it includes within its ambit the right to live with human dignity and all those aspects of life which go to make a man's life meaningful, complete, and worth living. It also ruled that the expression personal liberty in Article 21 is of the widest amplitude and it covers a variety of rights that go to constitute the personal liberties of a man. The Supreme Court has reaffirmed its judgment in the Menka case. In the subsequent cases, it has declared the following right as part of Article 21. Number 1. Right to live with human dignity. Number 2. Right to decent environment including pollution-free water and air and protection against hazardous industries. Number 3. Right to livelihood. Number 4. Right to privacy. Number 6. Right to shelter. Number 5. Right to shelter. Number 6. Right to health. Number 7. Right to free education up to 14 years of age. Number 8. Right to free legal aid. Number 9. Right against solitary confinement. Number 10. Right to speedy trial. Number 11. Right against handcuffing. Number 12. Right against inhuman treatment. Number 13. Right against delayed execution. Number 14. Right to travel abroad. Number 15. Right against bonded labor. Number 16. Right against custodial harassment. Number 17. Right to emergency medical aid. 18. Right to timely medical treatment in government hospital. 19. Right not to be driven out of a state. Number 20. Right to fair trial. 21. Right to prisoner to have necessities of life. 22. Right of women to be treated with decency and dignity. 23. Right against public hanging. 24. Right to road in hilly areas. 25. Right to information. 26. Right to reputation. 27. Right to appeal from a judgment of conviction. 28. Right to family pension. 29. Right to social and economic justice and empowerment. 30. Right against bar fetters. 31. Right to appropriate life insurance policy. 32. Right to sleep. 33. Right to freedom from noise pollution. 34. Right to sustainable development. 35. Right to opportunity. Number 4. Right to education. Article 21A declares that the state shall provide free and compulsory education to all children of the age of 6 to 14 years in such a manner as the state may determine. Thus, this provision makes only such elementary education a fundamental right and not higher or professional education. This provision was added by the 86th Constitutional Amendment Act of 2002. This amendment is a major milestone in the country's aim to achieve education for all. The government described this step as the dawn of the second revolution in the chapter of citizen rights. Even before this amendment, the Constitution contained a provision for free and compulsory education for children under Article 45 in Part 4th. However, being a directive principle, it was not enforceable by the courts. Now, there is a scope for judicial intervention in this regard. This amendment changed the subject matter of Article 45 in Directive Principles. It now reads, the state shall endeavour to provide early childhood care and education for all children until they complete the age of 6 years. It also added a new fundamental duty under Article 51A that reads, it shall be the duty of every citizen of India to provide opportunity of education to his child or ward between the age of 6 and 14 years. In 1993 itself, the Supreme Court recognized a fundamental right to primary education in the right to life under Article 21. It held that every child or citizen of this country has a right to free education until he completes the age of 14 years. Thereafter, his right to education is subject to the limits of economic capacity and development of the state. In this judgment, the court overruled its earlier judgment 1992, which declared that there was a fundamental right to education up to any level including professional education like medicine and engineering. In pursuance of Article 21A, the Parliament enacted the Right of Children to Free and Compulsory Education Act 2009. This act seeks to provide that every child has a right to be provided full-time elementary education of satisfactory and equitable quality in a formal school which satisfies certain essential norms and standards. This legislation is anchored in the belief that the values of equality, social justice, and democracy and the creation of a just and human society can be achieved only through provision of inclusive elementary education to all. Number 5. Protection against arrest and detention. Article 22 grants protection to persons who are arrested or detained. Detention is of two types, namely punitive and preventive. Punitive detention is to punish a person for an offence committed by him after trial and conviction in a court. Preventive detention, on the other hand, means detention of a person without trial and conviction by a court. Its purpose is not to punish a person for a past offence, but to prevent him from committing an offence in the near future. Thus, preventive detention is only a precautionary measure and based on suspicion. The Article 22 has two parts. The first part deals with the cause of ordinary law, and the second part deals with the cases of preventive detention law. Number 1. The first part of Article 22 confers the following rights on a person who is arrested or detained under an ordinary law. A. Right to be informed of the grounds of arrest. B. Right to consult and be defended by a legal practitioner. C. Right to be produced before a magistrate within 24 hours including the journey time. D. Right to be released after 24 hours unless the magistrate authorizes further detention. These safeguards are not available to an enemy alien or a person arrested or detained under a preventive detention law. The Supreme Court also ruled under that the arrest and detention in the first part of Article 22 do not cover arrest under the orders of a court, civil arrest, arrest on failures to pay the income tax, and deportation of an alien. They apply only to an act of a criminal or quasi-criminal nature or some activity prejudicial to public interest. Second, the second part of Article 22 grants protection to persons who are arrested or detained under a preventive detention law. This protection is available to both citizens as well as aliens and includes the following. First, the detention of a person cannot exceed 3 months unless advisory board report sufficient causes for extended definition. The board is to consist of judges of a high court. Second, the grounds of detention should be communicated to the determinants. However, the fact considered to be against the public interest need not to be disclosed. Third, the detaining should be afforded an opportunity to make representation against the detention order. Article 22 also authorizes the Parliament to prescribe the circumstances and the classes of cases in which a person can be detained for more than 3 months under a preventive detention law without obtaining the opinion of an advisory board. The maximum period for which a person can be detained in any classes of cases under a preventive detention law and the procedure to be followed by an advisory board in an inquiry. The 44th Amendment Act of 1978 has reduced the period of detention without obtaining the opinion of an advisory board from 3 to 2 months. However, this provision has not yet been brought into force, hence the original period of 3 months still continues. The Constitution has divided the legislative power with regard to preventive detention between the Parliament and the state legislature. The Parliament has exclusive authority to make a law of preventive detention for reasons connected with defense, foreign affairs, and the security of India. Both the Parliament as well as the state legislature can concurrently make a law of preventive detention for reasons connected with the security of a state, the maintenance of public order, and the maintenance of supplies and services essential to the community. The preventive detention laws made by the Parliament are A. Preventive Detention Act 1950, expired in 1969. B. Maintenance of Internal Security Act 1971, repealed in 1978. C. Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974. D. National Security Act 1980. E. Prevention of Black Marketing and Maintenance of Supplies of Essential Commodities Act 1980. F. Terrorist and Disruptive Activities Prevention Act 1985, repealed in 1995. G. Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act 1988. H. Prevention of Terrorism Act 2002, repealed in 2004. Unlawful Activities Prevention Act 1967, as amended in 2004, 8, 12, and 19. It is unfortunate to know that no democratic country in the world has made preventive detention as an integral part of the Constitution as has been done in India. It is unknown in USA. It was resorted to in Britain, but only during First and Second World War time. In India, preventive detention existed even during the British rule. For example, the Bengal State Prisoners Regulation of 1818 and the Defence of India Act of 1939 provided for preventive detention. Right against exploitation. Number 1. Prohibition of traffic in human beings and forced labor. Article 23 prohibits traffic in human beings, begar, forced labor, and other similar forms of forced labor. Any contravention of this provision shall be an offence punishable in accordance with law. This right is available to both citizens and non-citizens. It protects the individual not only against the state but also against private persons. The expression traffic in human beings include selling and buying of man, women, and children like goods, immoral traffic in women and children, including prostitution, devadasis, slavery. To punish these acts, the Parliament has made the Immoral Traffic Prevention Act 1956. The term begar means compulsory work without remuneration. It was a peculiar Indian system under which the local jamidars sometimes used to force their tenants to render services without any payment. In addition to begar, the Article 23 prohibits other similar forms of forced labor like bonded labor. The term forced labor means compelling a person to work against his will. The workforce includes not only physical or legal force but also force arising from the compulsion of economic circumstances, that is, working for less than the minimum wage. In this regard, the Bonded Labour System, Abolition Act 1976, the Minimum Wages Act 1948, the Contract Labour Act 1970, and the Equal Remuneration Act 1976 were made. Article 23 also provides for an exception to this provision. It permits the state to impose compulsory service for public purpose, as for example, military service or social service, for which it is not bound to pay. However, in imposing such service, the state is not permitted to make any discrimination on grounds only of religion, race, caste, or class. Number 2. Prohibition of employment of children in factories, etc. Article 24 prohibits the employment of children below the age of 14 years in any factory, mine, or other hazardous activities like construction work or railway, but it does not prohibit their employment in any harmless or innocent work. The Child Labour Prohibition and Regulation Act 1986 is the most important law in this direction. In addition, the Employment of Children Act 1938, the Factories Act 1948, the Mines Act 1952, the Merchant Shipping Act 1958, the Plantation Labour Act 1951, the Motor Transport Workers Act 1951, Apprentices Act 1961, the Beedi and Cigar Workers Act 1966, and other similar acts prohibited the employment of children below certain age. In 1996, the Supreme Court directed the establishment of Child Labour Rehabilitation Welfare Fund, in which the offending employer should deposit a fine of Rs 20,000 for each child employed by him. It also issued directions for the improvement of education, health and nutrition of children. The Commission for Protection of Child Rights Act 2005 was enacted to provide for the establishment of a National Commission and state commissions for protection of child rights and children's courts for providing speedy trial of offences against children or of violation of child rights. In 2006, the government banned the employment of children as domestic servants or workers in business establishments like hotels, dhabas, restaurants, shops, factories, resorts, spas, tea shops, and so on. It warned that anyone employing under children below age 14 years of age would be liable for prosecution and penal action. The Child Labour Prohibition and Regulation Amendment Act 2016 amended the Child Labour Prohibition and Regulation Act 1986. It has renamed the principal act as the Child and Adolescent Labour Prohibition of Regulation Act 1986. Right to freedom of religion. Number 1. Freedom of conscience and free profession, practice and propagation of religion. Article 25 says that all persons are equally entitled to freedom of conscience and the right to freely profess, practice and propagate religion. The implication of these are: A. Freedom of conscience, inner freedom of any individual to mold its relation with God or creatures in whatever way he desires. B. Right to profess, declaration of one's religious beliefs and faith openly and freely. C. Right to practice, performance of religion, worship, rituals, ceremonies, and exhibition of beliefs and ideas. D. Right to propaganda, transmission and dissemination of one's religious beliefs to others or exposition of the tenets of one's religion, but it does not include a right to convert another person to one's own religion. Forcible conversions impinge on the freedom of conscience guaranteed to all the persons alike. From the above, it is clear that Article 25 covers not only religious beliefs, doctrines, but also religious practices, rituals. Moreover, these rights are available to all persons, citizens as well as non-citizens. However, these rights are subject to public order, morality, health and other provisions relating to fundamental rights. Further, the state is permitted to: A. Regulate or restrict any economic, financial, political or other secular activity associated with religious practice. B. Provide for social welfare and reform or throw open Hindu religious institutions of a public character to all classes and section of Hindus. Article 25 also contains two explanations. 1. Wearing and carrying of kirpans is to be included in the profession of the Sikh religion, and 2. The Hindus in this context include Sikh, Jains and Buddhists. Number 2. Freedom to manage religious affairs. According to Article 26, every religious denomination or any of its section shall have the following rights. A. Right to establish and maintain institutions for religious and charitable purpose. B. Right to manage its own affairs in matters of religion. C. Right to own and acquire movable and immovable property. D. Right to administer such property in accordance with law. Article 25 guarantees rights of individuals, while Article 26 guarantees rights of religious denominations or their sections. In other words, Article 26 protects collective freedom of religion like the rights under Article 25. The rights under Article 26 are also subject to public order, morality and health, but not subject to other provisions relating to the fundamental rights. The Supreme Court held that a religious denomination must satisfy three conditions. A. It should be a collection of individuals who have a system of beliefs, doctrines, which they regard as conducive to their spiritual well-being. B. It should have a common organization. C. It should be designated by a distinctive name. Under the above criteria, the Supreme Court held that the Ramakrishna Mission and Anand Marga are religious denominations within the Hindu religion. It also held that Aurobindo Society is not a religious denomination. Number 3. Freedom from taxation from promotion of a religion. Article 27 lays down that no person shall be compelled to pay any taxes for the promotion or maintenance of any particular religion or religious denomination. In other words, the state should not spend the public money collected by way of tax for the promotion or maintenance of any particular religion. This provision prohibits the state from favoring, patronizing, and supporting one religion over the other. This means that the taxes can be used for the promotion or maintenance of all religions. This provision prohibits only levy of a tax and not a fee. This is because the purpose of a fee is to control secular administration of religious institutions and not to promote or maintain religion. Thus, a fee can be levied on pilgrims to provide them some special service or safety measures. Similarly, a fee can be levied on religious endowments for meeting the regulation expenditure. Number 4. Freedom from attending religious instruction. Under Article 28, no religious instruction shall be provided in any educational institution wholly maintained out of the state funds. However, this provision shall not apply to an educational institution administered by the state but established under any endowment or trust requiring imparting of religious instruction in such institution. Further, no person attending any educational institution recognized by the state or receiving aid out of the state funds shall be required to attend any religious instruction or worship in that institution without his consent. In case of a minor, the consent of his guardian is needed. Thus, Article 28 distinguishes between 4 types of educational institutions. A. Institutions wholly maintained by the state. B. Institutions administered by the state but established under any endowment or trust. C. Institutions recognized by the state. Institution receiving aid from the state. D. A religious instruction is completely prohibited, while religious instruction is permitted, and religious instruction is permitted on a voluntary basis. Cultural and educational rights. Number 1. Protection of interest of minorities. Article 29 provides that any section of the citizen residing in any part of India having a distinct language, script or culture of its own shall have the right to conserve the same. Further, no citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of the state funds on grounds only of religion, race, caste or language. The first provision protects the right of a group, while the second provision guarantees the right of a citizen as an individual irrespective of the community to which he belongs. Article 29 grants protection to both religious minorities as well as linguistic minorities. However, the Supreme Court held that the scope of this article is not necessarily restricted to minorities only, as it is commonly assumed to be. This is because of the use of words section of citizens in the article that include minorities as well as majority. The Supreme Court also held that the right to conserve the language includes the right to agitate for the protection of language. Hence, the political speeches or promises made for the conservation of the language of a section of the citizen does not amount to corrupt practice under the Representation of People Act 1951. Number 2. Right of minorities to establish and administer educational institutions. Article 30 grants the following rights to minorities, whether religious or linguistic. First, all minorities shall have the right to establish and administer educational institutions of their choice. Second, the compensation amount fixed by the state for the compulsory acquisition of any property of a minority educational institution shall not restrict or abrogate the right guaranteed to them. This provision was added by the 44th Amendment Act of 1978 to protect the right of minorities in this regard. The Act deleted the right to property as a fundamental right under Article 31. Third, in granting aid, the state shall not discriminate against any educational institution managed by a minority. Thus, the protection under Article 30 is confined only to minorities, religious or linguistic, and does not extend to any section of citizens as under Article 29. However, the term minority has not been defined anywhere in the Constitution. The right under Article 30 also includes the right of a minority to impart education to its children in its own language. Minority educational institutions are of 3 types. A. Institutions that seek recognition as well as aid from the state. B. Institutions that seek only recognition from the state and not aid. C. Institutions that neither seek recognition nor aid from the state. The institution of first and second type are subject to the regulatory power of the state with regard to syllabus prescription, academic standards, discipline, sanitation, employment of teaching staff, and so on. The institutions of third type are free to administer their affairs but subject to operation of general laws like contract law, labor law, industrial law, tax law, economic regulation, and so on. In a judgment delivered in the Secretary of Malankara Syrian Catholic College case of 2007, the Supreme Court has summarized the general principles relating to the establishment and administration of minority educational institution in the following way. First, the number one, the right of minorities to establish and administer educational institutions to their choice comprises the following rights. First, to choose its governing body in whom the founders of institutions have faith and confidence to conduct and manage affairs to the institution. Second, to appoint teaching staff, teachers, lecturers, and headmasters, principals, and also non-teaching staff, and to take according if there is a dereliction of duty on any part of its employees. Third, to admit eligible students of their choice and to set up reasonable fee structure. Fourth, to use its properties and assets for the benefit of the institution. Number 2. The right conferred on minorities under Article 30 is only to ensure equality with the majority and not intended to place the minorities in a more advantageous position that is the majority. There is no reverse discrimination in favor of minorities. The general laws of the land relating to national interest, national security, social welfare, public order, morality, health, sanitation, taxation, etc. applicable to all will equally apply to minority institutions also. Number 3. The right to establish and administer educational institutions is not absolute, nor does it include the right to maladminister. There can be regulatory measures for ensuring educational character and standards and maintaining academic excellence. There can be checks on administration as are necessary to ensure that the administration is efficient and sound so as to serve the academic needs of the institution. Regulations made by the state concerning generally the welfare of students and teachers, regulations laying down eligibility criteria and qualifications for appointments as also conditions of service for employees, both teaching and non-teaching, regulations to prevent exploitation or oppression of employees, and regulations prescribing syllabus and curriculum of study fall under this category. Such regulations do not in any manner interface with the right under Article 30 Clause 1. Number 4. Subject to the eligibility conditions, qualifications prescribed by the state being met, the unaided minority educational institutions will have the freedom to appoint teachers, lecturers by adopting any rational procedure of selection. Number 5. Extension of aid by the state does not alter the nature and character of the minority educational institutions. The conditions can be imposed by the state to ensure proper utilization of the aid without, however, diluting or abridging the right under Article 30, Clause 1. Right to constitutional remedies. A more declaration of fundamental right in the Constitution is meaningless, useless, and worthless without providing an effective machinery for their enforcement, and if and when they are violated. Hence, Article 32 confers the right to remedies for the enforcement of the fundamental rights of an aggrieved citizen. In other words, the right to get the fundamental right protected is in itself a fundamental right. This makes the fundamental rights real. That is why Dr. Ambedkar called Article 32 as the most important article of the Constitution, an article without which the Constitution would be a nullity. It is the very soul of the Constitution and the very heart of it. The Supreme Court has ruled that Article 32 is a basic feature of the Constitution, hence it cannot be abridged or taken away even by way of an amendment to the Constitution. It contains the following 4 provisions. First, the right to move the Supreme Court by appropriate proceedings for the enforcement of the fundamental right is guaranteed. Second, the Supreme Court shall have power to issue directions or orders or writs for the enforcement of any of the fundamental rights. The writs issued may include habeas corpus, mandamus, prohibition, certiorari, and quo warranto. Third, Parliament can empower any other court to issue directions, orders, and writs of all kinds. However, this can be done without prejudice to the above powers conferred on the Supreme Court. Any other court here does not include High Courts because Article 226 has already conferred these powers on the High Courts. Fourth, the right to move the Supreme Court shall not be suspended except as otherwise provided for by the Constitution. Thus, the Constitution provides that the President can suspend the right to move any court for the enforcement of the fundamental rights during a national emergency under Article 359. It is thus clear that the Supreme Court has been constituted as the defender and guarantor of the fundamental rights of the citizens. It has been vested with the original and wide powers for that purpose. Original because an aggrieved citizen can directly go to the Supreme Court, not necessarily by way of appeal. Wide because its power is not restricted to issuing of orders or directions but also writs of all kinds. The purpose of Article 32 is to provide a guaranteed, effective, expeditious, inexpensive, and summary ready remedy for the protection of the fundamental rights. Only the fundamental rights guaranteed by the Constitution can be enforced under Article 32 and not any other right like non-fundamental constitutional rights, statutory rights, customary rights, and so on. The violation of a fundamental right is the sine qua non for the exercise of the right conferred by Article 32. In other words, the Supreme Court under Article 32 cannot determine a question that does not involve fundamental rights. Article 32 cannot be invoked simply to determine the constitutionality of an executive order or a legislation unless it directly infringes any of the fundamental rights. In case of the enforcement of fundamental rights, the jurisdiction of the Supreme Court is original but not exclusive. It is concurrent with the jurisdiction of the High Court under Article 226. It vests original powers in the High Court to issue directions, orders, and writs of all kinds for the enforcement of the fundamental rights. It means when the fundamental rights of a citizen are violated, the aggrieved party has the option of moving either the High Court or the Supreme Court or the Supreme Court directly. Since the right guaranteed by Article 32, that is the right to move the Supreme Court where a fundamental right is infringed, is in itself a fundamental right, the availability of alternate remedy is no bar to relief under Article 32. However, the Supreme Court has ruled that where relief through High Court is available under Article 226, the aggrieved party should first move the High Court. Writs, types and scope. The Supreme Court under Article 32 and the High Courts under Article 226 can issue the writs of habeas corpus, mandamus, prohibition, certiorari, and quo warranto. Further, the Parliament under Article 32 can empower any other court to issue these writs. Since no such provisions has been made so far, only the Supreme Court and the High Courts can issue the writs and not any other court. Before 1950, only the High Courts of Calcutta, Bombay and Madras had the power to issue the writs. Article 226 now empowers all the High Courts to issue the writs. These writs are borrowed from English law where they are known as prerogative writs. They are so called in England as they were issued in the exercise of the prerogative of the king, who was and is still described as the fountain of justice. Later, the High Court started issuing these writs as extraordinary remedies to uphold the rights and liberties of the British people. The writ jurisdiction of the Supreme Court differs from that of a High Court in three respects. Number 1. The Supreme Court can issue writs only for the enforcement of fundamental rights, whereas a High Court can issue writs not only for the enforcement of fundamental rights but also for any other purpose. The expression for any other purpose refers to the enforcement of an ordinary legal right. Thus, the writ jurisdiction of the Supreme Court in this respect is narrower than that of High Court. Number 2. The Supreme Court can issue writs against a person or government throughout the territory of India, whereas a High Court can issue writs against a person residing or against a government or authority located within its territorial jurisdiction only or outside its territorial jurisdiction only if the cause of action arises within its territorial jurisdiction. Thus, the territorial jurisdiction of the Supreme Court for the purpose of issuing writs is wider than that of a High Court. Number 3. A remedy under Article 32 is in itself a fundamental right and hence the Supreme Court may not refuse to exercise its writ jurisdiction. On the other hand, a remedy under Article 226 is discretionary and hence a High Court may refuse to exercise its writ jurisdiction. Article 32 does not merely confer powers on the Supreme Court as Article 226 does on a High Court to issue writs for the enforcement of fundamental rights or other rights as part of its general jurisdiction. The Supreme Court is thus constituted as a defender and guarantor of the fundamental rights. Now, we will proceed to understand the meaning and scope of different kinds of writs mentioned in Article 32 and 226 of the Constitution. Habeas corpus. It is a Latin term which literally means to have the body of. It is an order which issued by the court to a person who has detained another person to produce the body of the latter before it. The court then examines the cause and legality of detention. It would set the detained person free if the detention is found to be illegal. Thus, this writ is a bulwark of individual liberty against arbitrary detention. The writ of habeas corpus can be issued against both public authorities as well as private individuals. The writ, on the other hand, is not issued where the detention is lawful, the proceeding is for contempt of a legislature of a court, detention is by a competent court, and detention is outside the jurisdiction of the court. Mandamus. It literally means we command. It is a command issued by the court to a public official asking him to perform his official duties that he has failed or refused to perform. It can also be used against any public body, a corporation, an inferior court, a tribunal, or government for the same purpose. The writ of mandamus cannot be issued against a private individual or body to enforce departmental instruction that does not possess statutory force when the duty is discretionary and not mandatory, to enforce a contractual obligation against the President of India or the state governors, against the Chief Justice of a High Court acting in judicial capacity. Prohibition. Literally, it means to forbid. It is issued by a higher court to a lower court or tribunal to prevent the latter from exceeding its jurisdiction or usurping a jurisdiction that it does not possess. Thus, unlike mandamus, that directly activity, the prohibition directs inactivity. The writ of prohibition can be issued only against judicial and quasi-judicial authorities. It is not only available against administrative authorities, legislative bodies, and private individuals or bodies. Certiorari. In the literal sense, it means to be certified or to be informed. It is issued by a higher court to a lower court or tribunal, either to transfer a case pending with the latter to itself or to request the order of the latter in a case. It is issued on the grounds of excess of jurisdiction or lack of jurisdiction or error of law. Thus, unlike prohibition, which is unlikely preventive, certiorari is both preventive as well as curative. Previously, the writ of certiorari could be issued only against judicial and quasi-judicial authorities and not against administrative authorities. However, in 1991, the Supreme Court ruled that the certiorari can be issued even against administrative authorities affecting rights of individuals. Like prohibition, certiorari is also not available against legislative bodies and private individuals or bodies. Quo warranto. In the literal sense, it means by what authority or warrant. It is issued by the court to inquire into the legality of claim of a person to a public office. Hence, it prevents illegal usurpation of public office by a person. The writ can be issued only in case of a substantive public office by a permanent character created by a statute or by constitution. It cannot be issued in cases of ministerial office or private office. Unlike the other four writs, this can be sought by any interested person and not necessarily by the aggrieved person. Armed forces and fundamental rights. Article 33 empowers the Parliament to restrict or abrogate the fundamental rights of the members of armed forces, paramilitary forces, police forces, intelligence agencies, and analogous force. The objective of this provision is to ensure the proper discharge of their duties and the maintenance of discipline among them. The power to make laws under Article 33 is conferred only on the Parliament and not on state legislatures. Any such law made by the Parliament cannot be challenged in any court on the ground of contravention of any of the fundamental rights. Accordingly, the Parliament has enacted the Army Act 1950, the Navy Act 1950, the Air Force Act 1950, the Police Forces Restriction of Rights Act 1966, the Border Security Force Act, and so on. These impose restrictions on their freedom of speech, right to form associations, right to be members of trade unions or political associations, right to communicate with the press, right to attend public meetings or demonstrations, etc. Martial law versus national emergency. Martial law. Martial law affects only fundamental rights, while national emergency affects not only fundamental right but also center-state relations, distribution of revenues and legislative powers between center and state, and may extend the tenure of the Parliament. This was point number 1. Point number 2. Martial law suspends the government and ordinary law courts, while national emergency continues the government and ordinary law courts. Point number 3. It is imposed to martial law is imposed to restore the breakdown of law and order due to any reason, while national emergency can be imposed only on three grounds: war, external aggression, or armed rebellion. Point number 4. Martial law is imposed in some specific areas of the country, while national emergency is imposed either in the whole country or in any part of it. Martial law. Point number 5. Martial law has no specific provision in the constitution, it is implicit, while national emergency has a specific and detailed provision in the constitution, it is explicit in nature. The expression members of the armed forces also covers such employees of the armed forces as barbers, carpenters, mechanics, cooks, chowkidars, bootmakers, tailors who are non-combatants. A parliamentary law enacted under Article 33 can also exclude the court-martial tribunals established under the military law from the writ jurisdiction of the Supreme Court and the High Courts so far as the enforcement of fundamental right is concerned. Martial law and fundamental rights. Article 34 provides for the restriction on fundamental rights while martial law is in force in any area within the territory of India. It empowers the Parliament to indemnify any government servants or other person for any act done by him in connection with the maintenance or restoration of order in any area where martial law was in force. The Parliament can also validate any sentence passed, punishment inflicted, forfeiture ordered, or other act done under martial law in such area. The act of indemnity made by the Parliament cannot be challenged in any court on the ground of contravention of any of the fundamental right. The concept of martial law has been borrowed in India from the English common law. However, the expression martial law has not been defined anywhere in the Constitution. Literally, it means military rule. It refers to a situation where civil administration is run by the military authorities according to their own rules and regulations framed by outside the ordinary law. It does imply the suspension of ordinary law and the government by military tribunals. It is different from the military law that is applicable to the armed forces. There is also no specific or express provision in the Constitution that authorizes the executive to declare martial law. However, it is implicit in Article 34, under which martial law can be declared in any area within the territory of India. The martial law is imposed under the extraordinary circumstances like war, invasion, insurrection, rebellion, riot, or any violent resistance to law. Its justification is to repeal force by force for maintaining or restoring order in the society. During the operation of martial law, the military authorities are vested with abnormal powers to take all necessary steps. They impose restrictions and regulations on the rights of the civilians, can punish the civilians, and even condemn them to death. The Supreme Court held that the declaration of martial law does not ipso facto result in the suspension of the writ of habeas corpus. The declaration of a martial law under Article 34 is different from the declaration of a national emergency under Article 352. The difference between the two are summarized below. Affecting certain fundamental rights. Article 35 lays down that the power to make laws to give effect to certain specified fundamental right shall vest only in the Parliament and not in the state legislatures. This provision ensures that there is uniformity throughout India with regard to the nature of those fundamental rights and punishment for their infringement. In this direction, Article 35 contains the following provisions. Number 1. The Parliament shall have and the legislature of a state shall not have power to make laws with respect to the following matters. A. Prescribing residences as a condition for certain employments or appointments in a state or union territory or local authority or other authority under Article 16. B. Empowering courts other than the Supreme Court and the High Courts to issue directions, orders, and writs of all kinds for the enforcement of fundamental rights under Article 32. C. Restricting or abrogating the application of fundamental rights to members of armed forces, police forces, etc. under Article 33. D. Indemnifying any government servant or any other person for any act done during the operation of martial law in any area under Article 34. Point number 2. Parliament shall have and the legislature of a state shall not have powers to make laws for prescribing punishment for those acts that are declared to be offences under the fundamental right. These include the following. A. Untouchability under Article 17. B. Traffic in human beings and forced labor under Article 23. Further, the Parliament shall, after the commencement of the Constitution, make laws for prescribing punishments for the above Act, thus making it obligatory on the part of the Parliament to enact such laws. Point number 3. Any law in force at the commencement of the Constitution with respect to any of the matters specified above is to continue in force until altered or repealed or amended by the Parliament. It should be noted that Article 35 extends the competence of the Parliament to make a law on the matters specified above, even though some of those matters may fall within the spheres of the state legislature, that is, the state list. Present position of right to property. Originally, the right to property was one of the 7 fundamental rights under Part 3 of the Constitution. It was dealt by Article 19, Clause 1, subsection F, and Article 31. Article 19(1)(f) guaranteed to every citizen the right to acquire, hold, and dispose of property. Article 31, on the other hand, guaranteed to every person, whether citizen or non-citizen, right against deprivation of his property. It provided that no person shall be deprived of his property except by authority of law. It empowered the states to acquire or requisition of the property of a person on 2 conditions. It should be for public purpose and it should provide for payment of compensation to the owner. Since the commencement of the Constitution, the fundamental rights to property has been the most controversial. It has caused confrontations between the Supreme Court and the Parliament. It has led to a number of constitutional amendments, that is 1st, 4th, 7th, 25th, 39th, 40th and 42nd amendments. Through these amendments, Article 31A, 31B and 31C have been added and modified from time to time to nullify the effect of Supreme Court judgments and to protect certain laws from being challenged on the grounds of contravention of fundamental rights. Most of the litigation centered around the obligation of the state to pay compensation for acquisition or requisition of private property. Therefore, the 44th Amendment Act of 1978 abolished the right to property as a fundamental right by repealing Article 19(1)(f) and Article 31 from Part 3rd. Instead, the Act inserted a new Article 300A in Part 12 under the heading Right to Property. It provides that no person shall be deprived of his property except by authority of law. Thus, the right to property still remains a legal right or a constitutional right, though no longer a fundamental right. It is not a part of the basic structure of the Constitution. The right to property as a legal right, as distinct from the fundamental right, has the following implications. A. It can be regulated, that is, curtailed, abridged, or modified without constitutional amendment by an ordinary law of the Parliament. B. It protects private property against executive action but not against legislative action. C. In case of violation, the aggrieved person cannot directly move the Supreme Court under Article 32, right to constitutional remedies including writs for its enforcement. He can move the High Court under Article 226. D. No guaranteed right to compensation in case of acquisition or requisition of the private property by the state. Though the fundamental right to property under Part 3rd has been abolished, the Part 3rd still carries 2 provisions which provide for the guaranteed right to compensation in case of acquisition or requisition of the private property by the state. These 2 cases where compensation has to be paid are: case number 1, when the state acquires the property of a minority educational institution under Article 30. Case number 2, when the state acquires the land held by a person under his personal cultivation and the land is within the statutory ceiling limits under Article 31A. The first provision was added by the 44th Amendment Act 1978, while the second provision was added by the 17th Amendment Act 1964. Further, Article 31A, 31B and 31C have been retained as exceptions to the fundamental right. Exceptions to fundamental right. Number 1. Saving of laws providing for acquisition of estates, etc. Article 31A saves 5 categories of laws from being challenged and invalidated on the ground of contravention of the fundamental rights conferred by Article 14, equality before law and equal protection of laws, and Article 19, protection of 6 rights in respect of speech, assembly, movement, etc. They are related to agricultural land, reforms, industry, and commerce and include the following: A. Acquisition of estates and related rights by the state. B. Taking over the management on properties by the state. C. Amalgamation of corporations. D. Extinguishment or modifications of right of directors or shareholders of corporations. E. Extinguishment or modification of mining leases. Article 31A does not immunize a state law from judicial review unless it has been reserved for the President's consideration and has received his assent. This article also provides for the payment of compensation at market value when the state acquires the land held by a person under his personal cultivation and the land is within the statutory ceiling limit. Number 2. Validation of certain acts and regulation. Article 31B saves the act and regulations included in the ninth schedule from being challenged and invalidated on the ground of contravention of any of the fundamental rights. Thus, the scope of Article 31B is wider than Article 31A. Article 31B immunizes any law included in the ninth schedule from all the fundamental rights, whether or not the law falls under any of the five categories specified in Article 31A. However, in a significant judgment delivered in IR Colo case 2007, the Supreme Court ruled that there could not be any blanket immunity from judicial review of laws included in the ninth schedule. The court held that judicial review is a basic feature of the Constitution and it could not be taken away by putting a law under the ninth schedule. It said that the laws placed under the ninth schedule after April 24, 1973 are open to challenge in court if they violated fundamental rights guaranteed under Article 14, 15, 19 and 21 or the basic structure of the Constitution. It was on April 24, 1973 that the Supreme Court first propounded the doctrine of basic structure or basic feature of the Constitution in its landmark verdict in the Keshwanand Bharti case. Originally, in 1951, the ninth schedule contained only 13 acts and regulations, but at present, in 2016, their number is 282. Of these, the act and regulations of the state legislature deal with land reforms and abolition of the jamidari system, and that of the parliament deal with other matters. Number 3. Saving of laws giving effect to certain directive principles. Article 31C, as inserted by the 25th Amendment Act of 1971, contained the following two provisions. A. No law that seeks to implement the socialistic directive principles specified in Article 39B or C shall be void on the ground of contravention of the fundamental rights conferred by Article 14, equality before law and equal protection of laws, or Article 19, protection of six rights in respect of speech, assembly, movement, etc. B. No law containing a declaration that it is for giving effect to such policy shall be questioned in any court on the ground that it does not give effect to such a policy. In the Keshwanand Bharti case, 1973, the Supreme Court declared the above second provision of Article 31C as unconstitutional and invalid on the ground that judicial review is a basic feature of the Constitution and hence cannot be taken away. However, the above first provision of Article 31C was held to be constitutional and valid. The 42nd Amendment Act 1976 extended the scope of the above first provision of Article 31C by including within its protection any law to implement any of the directive principles specified in Part 4 of the Constitution and not merely in Article 39B or C. However, this extension was declared as unconstitutional and invalid by the Supreme Court in the Minerva Mills case of 1980. Criticism of fundamental rights. The fundamental right enshrined in Part 3 of the Constitution have met with a wide and varied criticism. The arguments of the critics are: Number 1. Excessive limitations. They are subjected to innumerable exceptions, restrictions, qualifications, and explanations. Hence, the critics remarked that the Constitution grants fundamental rights with one hand and takes them away with the other. Jaspat Roy Kapoor went to the extent of saying that the chapter dealing with the fundamental rights should be renamed as Limitations on Fundamental Rights or Fundamental Rights and Limitations Thereon. Number 2. No social and economic rights. The list is not comprehensive as it is mainly consists of political rights. It makes no provision for important social and economic rights like right to social security, right to work, right to employment, right to rest and leisure, and so on. These rights are made available to the citizens of advanced democratic countries. Also, the socialistic constitutions of erstwhile USSR or China provided for such rights. Number 3. No clarity. They are stated in a vague, indefinite, and ambiguous manner. The various phrases and words used in the chapter, like public order, minorities, reasonable restriction, public interest, and so on, are not clearly defined. The language used to describe them is very complicated and beyond the comprehension of the common man. It is alleged that the Constitution was made by the lawyers for the lawyers. Sir Ivor Jennings called the Constitution of India a paradise of lawyers. Number 4. no permanency. They are not sacrosanct or immutable as the parliament can curtail or abolish them, as for example, the abolition of the fundamental right to property in 1978. Hence, they can become a play tool in the hands of politicians having majority support in the parliament. The judicially innovated doctrine of basic structure is the only limitation on the authority of parliament to curtail or abolish the fundamental right. Number 5. Suspension during emergency. The suspension of their enforcement during the operation of national emergency, except Article 20 and 21, is another blot on the efficacy of these rights. This provision cuts at the roots of democratic system in the country by placing the rights of the millions of innocent people in continuous jeopardy. According to the critics, the fundamental rights should be enjoyable in all situations, emergency or no emergency. Number 6. Expensive remedy. The judiciary has been made responsible for defending and protecting these rights against the interference of the legislature and executives. However, the judicial process is too expensive and hinders the common man from getting his rights enforced through the courts. Hence, the critics say that the rights benefit mainly the rich section of the Indian society. Number 7. Preventive detention. The critics assert that the provision for preventive detention, Article 22, takes away the spirit and substance of the chapter on fundamental rights. It confers arbitrary powers on the state and negates individual liberty. It justifies the criticism that the Constitution of India deals more with the rights of the state against the individual than with the right of the individual against the state. Notably, no democratic country in the world has made preventive detention as an integral part of their constitutions as has been made in India. Number 8. No consistent philosophy. According to some critics, the chapter on fundamental rights is not the product of any philosophical principle. Sir Ivor Jennings expressed this view when he said that the fundamental rights proclaimed by the Indian Constitution are based on no consistent philosophy. The critics say that this creates difficulty for the Supreme Court and the High Courts in interpreting the fundamental rights. Significance of fundamental rights. In spite of our criticism and shortcomings, the fundamental rights are significant in the following respect. They constitute, number 1, they constitute the bedrock of democratic system in the country. Number 2, they provide necessary conditions for the material and moral protection of man. Number 3, they serve as a formidable bulwark of individual liberty. Number 4, they facilitate the establishment of rule of law in the country. Number 5, they protect the interest of minorities and weaker section of society. Number 6, they strengthen the secular fabric of the Indian state. Number 7, they check the absoluteness of the authority of the government. Number 8, they lay down the foundation stone of social equality and social justice. Number 9, they ensure the dignity and respect of individuals. Number 10, they facilitate the participation of people in the political and administrative process. Rights outside Part 3rd. Besides the fundamental right included in Part 3rd, there are certain other rights contained in other parts of the Constitution. These rights are known as constitutional rights or legal rights or non-fundamental rights. They are, number 1, no tax shall be levied or collected except by authority of law, Article 265 in Part 12th. Number 2, no person shall be deprived of his property saved by the authority of the law, Article 300A in Part 12th. Number 3, trade, commerce and intercourse throughout the territory of India shall be free, Article 301 in Part 13. Even though the above rights are also equally justiciable, they are different from the fundamental right. In case of violation of a fundamental right, the aggrieved person can directly move the Supreme Court for its enforcement under Article 32, which is in itself a fundamental right. But in case of violation of the above rights, the aggrieved person cannot avail this constitutional remedy. He can move the High Court by an ordinary suit or under Article 226 writ jurisdiction of High Court. The theoretical part of this chapter ended here, but you can refer table of this chapter, which is articles related to fundamental right at a glance. You can find this table in M.Laxmikant book chapter number 7 or online PDFs. Thank you so much. Chapter 8. Directive Principles of State Policy. The directive principles of state policy are enumerated in Part 4th of the Constitution from Articles 36 to 51. The framers of the Constitution borrowed this idea from the Irish Constitution of 1937, which had copied it from the Spanish Constitution. Dr. B.R. Ambedkar described these principles as novel features of the Indian Constitution. The directive principles, along with the fundamental rights, contain the philosophy of the Constitution and is the soul of the Constitution. Greenwell Austin has described the directive principles and the fundamental rights as the conscience of the Constitution. Features of the directive principles. Number one, the phrase directive principles of state policy denotes the ideals that the state should keep in mind while formulating policies and enacting laws. These are the constitutional instructions or recommendations to the state in legislative, executive, and administrative matters. According to Article 36, the term state in Part 4th has the same meaning as in Part 3rd, dealing with fundamental rights. Therefore, it includes the legislative and executive organs of the central and state governments, all local authorities, and all other public authorities in the country. Number two, the directive principles resemble the instrument of instructions enumerated in the Government of India Act of 1935. In the words of Dr. B.R. Ambedkar, the directive principles are like the instrument of instructions which are issued to the Governor General and to the governors of the colonies of India by the British government under the Government of India Act of 1935. What is called directive principles is merely another name for the instrument of instructions. The only difference is that they are instructions to the legislature and the executive. Number three, the directive principles constitute a very comprehensive economic, social, and political program for a modern democratic state. They aim at realizing the high ideals of justice, liberty, equality, and fraternity as outlined in the preamble to the Constitution. They embody the concept of a welfare state and not that of a police state, which existed during the colonial era. In brief, they seek to establish economic and social democracy in the country. Number four, the directive principles are non justiciable in nature, that is, they are not legally enforceable by the courts for their violation. Therefore, the government, central, state, and local, cannot be compelled to implement them. Nevertheless, the Constitution, Article 37, itself says that these principles are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. Number 5. The directive principles, though non justiciable in nature, help the courts in examining and determining the constitutional validity of a law. The Supreme Court has ruled many a times that in determining the constitutionality of any law, if a court finds that the law in question seeks to give effect to a directive principle, it may consider such law to be reasonable in relation to Article 14, equality before law, or Article 19, six freedoms, and thus save such law from unconstitutionality. Classification of the directive principles. The Constitution does not contain any classification of directive principles. However, on the basis of their content and direction, they can be classified into three broad categories, that is, socialistic, Gandhian, and liberal intellectual. Number one, socialistic principles. These principles reflect the ideology of socialism. They lay down the framework of a democratic socialistic state, aim at providing social and economic justice, and set the path towards welfare state. They direct the state, number one, to promote the welfare of the people by securing a social order permeated by justice, social, economic, and political, and to minimize inequalities of income, status, facilities, and opportunities under Article 38. Number two, to secure the citizen the right to adequate means of livelihood for all citizens, the equitable distribution of material resources of the community for the common good, prevention of concentration of wealth and means of production, equal pay for equal work for men and women, preservation of the health and strength of workers and children against forcible abuse, opportunities for healthy development of children under Article 39. Number 3. To promote equal justice and to provide free legal aid to the poor under Article 39A. Number 4. To secure the right to work, to education, and to public assistance in cases of unemployment, old age, sickness, and disablement under Article 41. Number 5. To make provision for just and humane conditions of work and maternity relief under Article 42. Number 6. To secure a living wage, a decent standard of life, and social and cultural opportunities for all workers under Article 43. Number 7. To take steps to secure the participation of workers in the management of industries under Article 43A. Number 8. To raise the level of nutrition and the standard of living of people and to improve public health under Article 47. Number 2. Gandhian principles. These principles are based on Gandhian ideology. They represent the program of reconstruction initiated by Gandhi during the national movement. In order to fulfill the dreams of Gandhi, some of his ideas were included as directive principles. They requires the state, number 1, to organize village panchayats and to endow them with the necessary powers and authority to enable them to function as units of self-government under Article 40. Number 2, to promote cottage industries or an individual or cooperation basis in rural areas under Article 43. Number 3, to promote voluntary formation, autonomous functioning, democratic control, and professional management of cooperative societies under Article 43B. Number 4, to promote the educational and economic interest of SC, ST, and other weaker section of the society and to protect them from social injustice and exploitation under Article 46. Number 5, to prohibit the consumption of intoxicating drinks and drugs which are injurious to health under Article 47. Number 6, to prohibit the slaughter of cows, calves, and other milch and draught cattle and to improve their breeds under Article 48. Number 3, liberal intellectual principles. The principles includes in this category represent the ideology of liberalism. They direct the state, number 1, to secure for all citizens a uniform civil code throughout the country under Article 44. Number 2, to provide early childhood care and education for all children until they complete the age of 6 years under Article 45. Number 3, to organize agriculture and animal husbandry on modern and scientific lines under Article 48. Number 4, to protect and improve the environment and to safeguard forest and wildlife under Article 48A. Number 5, to protect monuments, places, and objects of artistic or historic interest which are declared to be of national importance, Article 49. Number 6, to separate the jurisdiction from the executive in the public services of the state under Article 50. Number 7, to promote international peace and security and maintain just and honorable relations between nations to foster respect for international law and treaty obligations and to encourage settlement of international disputes by arbitration under Article 51. New directive principles. The 42nd Amendment Act of 1976 added 4 new directive principles to the original list. They require the state, number 1, to secure opportunities for healthy development of children under Article 39. Number 2, to promote equal justice and to provide free legal aid to the poor under Article 39A. Number 3, to take steps to secure the participation of workers in the management of industries under Article 43A. Number 4, to protect and improve the environment and to safeguard forest and wildlife under Article 48A. The 44th Amendment Act of 1978 added one more directive principles which require the state to minimize inequalities in income, status, facilities and opportunities under Article 38. The 86th Amendment Act of 2002 changed the subject matter of Article 45 and made elementary education a fundamental right under Article 21A. The amended directive requires the state to provide early childhood care and education for all children until they complete the age of 6 years. The 97th Amendment Act of 2011 added a new directive principles relating to cooperative societies. It requires the state to promote voluntary formation, autonomous functioning, democratic control, and professional management of cooperative societies under Article 43B. Sanction behind directive principles. Sir B. N. Rao, the constitutional advisor to the Constituent Assembly, recommended that the rights of an individual should be divided into two categories, justiciable and non-justiciable, which was accepted by the drafting committee. Consequently, the fundamental rights which are justiciable in nature are incorporated in Part 3rd and the directive principles which are non-justiciable in nature are incorporated in Part 4th of the Constitution. Though the directive principles are non-justiciable, the Constitution, Article 37, makes it clear that these principles are fundamental in the governance of the country and it shall be the duty of the state to apply these principles in making laws. Thus, they impose a moral obligation on the state authorities for their application, but the real force behind them is political, that is, public opinion. As observed by Aladi Krishnaswamy Iyer, no ministry responsible to the people can afford lightheartedly to ignore the provisions in Part 4th of the Constitution. Similarly, Dr. B.R. Ambedkar said in the Constituent Assembly that the government which rests on popular vote can hardly ignore the directive principles while shaping its policy. If any government ignores them, it will certainly have to answer for that before the electorate at the election time. The framers of the Constitution made the directive principles non justiciable and legally non enforceable because Number one, the country did not possess sufficient financial resources to implement them. Number two, the presence of vast diversity and backwardness in the country would stand in the way of their implementation. Number three, the newly won independent Indian state with its many preoccupations might be crushed under the burden unless it was free to decide the order, the time, the place, and the mode of fulfilling them. The constitution makers, therefore, taking a pragmatic view, refrained from giving teeth to these principles. They believed more in an augment public opinion rather than in court procedures as the ultimate sanction for the fulfillment of these principles. Criticism of the directive principles. The directive principles of state policy have been criticized by some members of the Constituent Assembly as well as other constitutional and political experts on the following grounds. Number one, no legal force. The directives have been criticized mainly because of their non justiciable character, while K.T. Shah dubbed them as pious superfluous and compared them with a check on a bank payable only when the resources of the bank permit. Nasruddin contended that these principles are no better than the New Year's resolution, which are broken on the 2nd of January, even as T.T. Krishnamachari described the directives as a veritable dustbin of sentiments. K.C. Viere called them as a manifesto of aims and aspirations and opined that they serve as mere moral humility, and Sir Ivor Jennings thought they are only as pious aspirations. Number two, illogically arranged. Critics opine that the directives are not arranged in a logical manner based on a constituent assembly, constituent philosophy. According to N. Srinivasan, the directives are neither properly classified nor logically arranged. The declaration mixes up relatively unimportant issues with the most vital economic and social questions. It combines rather incongruously the modern with the old and provisions suggested by the reason and science with provisions based purely on sentiments and prejudice. Sir Ivor Jennings too pointed out that these principles have no consistent philosophy. Number 3. Conservative. According to Sir Ivor Jennings, the directives are based on the political philosophy of the 19th century England. He remarked the ghost of Sidney Webb and Beatrice Wavestock through the pages of the text. Part 4th of the Constitution expresses Fabian socialism without the socialism. He opined that the directives are deemed to be suitable in India in the middle of the 20th century. The question whether they are suitable for the 21st century cannot be answered, but it is quite probable that they will be entirely outmoded. Number 4. Constitutional conflict. K. Santhanam has pointed out that the directives lead to a constitutional conflict between the center and the state, between the president and the prime minister, between the governor and the chief minister. According to him, the center can give directions to the state with regard to the implementation of these principles, and in case of non-compliance can dismiss the state government. Similarly, when the prime minister gets a bill which violates the directive principle passed by the parliament, the president may reject the bill on the ground that these principles are fundamental to the governance of the country and hence the ministry has no right to ignore them. The same constitutional conflict may occur between the governor and the chief minister at the state level. Utility of directive principles. In spite of the above criticisms and shortcomings, the directive principles are not an unnecessary appendage to the Constitution. The Constitution itself declares that they are fundamental to the governance of the country. According to L.M. Singhvi, an eminent jurist and diplomat, the directives are the life-giving provisions of the Constitution. They constitute the stuff of the Constitution and its philosophy of social justice. M.C. Chagla, former Chief Justice of India, is of the opinion that if all these principles are fully carried out, our country would indeed be a heaven on earth. India would then be not only democracy in the political sense, but also a welfare state looking after the welfare of its citizens. Dr. B.R. Ambedkar had pointed out that the directives have great value because they lay down that the goal of the Indian polity is economic democracy as distinguished from political democracy. Granville Austin opined that the directive principles are aimed at furthering the goals of the social revolution or to foster this revolution by establishing the conditions necessary for its achievement. Sir B. N. Rao, the constitutional advisor to the Constituent Assembly, stated that the directive principles are intended as moral precepts of the authorities of the state. They have at least an educative value. According to M.C. Shetalbad, the former Attorney General of India, the directive principles, although confer no legal rights and create no legal remedies, are significant and useful in the following ways. Number one, they are like an instrument of instructions or general recommendations addressed to all authorities in the Indian Union. They remind them of the basic principles of the new social and economic order which the Constitution aims at building. Number two, they have served as useful beacon lights to the courts. They have helped the courts in exercising their power of judicial review, that is, the power to determine the constitutional validity of a law. Number three, they form the dominating background to all state action, legislative or executive, and also a guide to the courts in some respect. Number four, they amplify the preamble which solemnly resolves to secure to all the citizens of India justice, liberty, equality, and fraternity. The directives also play the following roles. Number one, they facilitate stability and continuity in domestic and foreign policies in political, economic, and social spheres in spite of change of the party in power. Number two, they are supplementary to the fundamental rights of the citizens. They are intended to fill in the vacuum in part third by providing for social and economic rights. Number three, their implementation creates a favorable atmosphere for the full and proper enjoyment of the fundamental rights by the citizens. Political democracy without economic democracy has no meaning. Number four, they enable the opposition to exercise influence and control over the operations of the government. The opposition can blame the ruling party on the ground that its activities are opposed to the directives. Number five, they serve as a crucial test for the performance of the government. The people can examine the policies and programs of the government in the light of these constitutional declaration. Number six, they serve as common political manifesto. A ruling party, irrespective of its political ideology, has to recognize the fact that these principles are intended to be its guide, philosopher, and friend in its legislative and executive acts. Conflict between fundamental right and directive principles. The justiciability of fundamental rights and non-justiciability of directive principles on the one hand and the moral obligation of a state to implement directive principles under Article 37 on the other hand have led to a conflict between the two since the commencement of the Constitution. In the Champakan Durai Rajan case 1951, the Supreme Court ruled that in case of any conflict between the fundamental rights and the directive principles, the former would prevail it. It declared that the directive principles have to conform to and run as subsidiary to the fundamental rights, but it also held that the fundamental rights could be amended by the Parliament by enacting Constitutional Amendment Act. As a result, the Parliament made the First Amendment Act 1951, the Fourth Amendment Act 1955, and the 17th Amendment Act to implement some of the directives. The above situation underwent a major change in 1967 following the Supreme Court's judgment in the Golaknath case 1967. In that case, the Supreme Court ruled that the Parliament cannot take away or abridge any of the fundamental rights which are sacrosanct in nature. In other words, the court held that the fundamental rights cannot be amended for the implementation of the directive principles. The Parliament reacted to the Supreme Court's judgment in the Golaknath case 1967 by enacting the 24th Amendment Act 1971 and the 25th Amendment Act 1971. The 24th Amendment Act declared that the Parliament has the power to abridge or take away any of the fundamental rights by enacting Constitutional Amendment Act. The 25th Amendment Act inserted a new Article 31C which contained the following two provisions. Number 1. No law which seeks to implement the socialistic directive principles specified in Article 39B and C shall be void on the ground of contravention of the fundamental rights conferred by Article 14, equality before law and equal protection of laws, Article 19, protection of sex rights in respect of speech, assembly, movement, etc., or Article 31, right to property. Number 2. No law containing a declaration for giving effect to such policy shall be questioned in any court on the ground that it does not give effect to such a policy. In the Keshwanand Bharti case of 1973, the Supreme Court declared the above second provision of Article 31C as unconstitutional and invalid on the ground that the judicial review is a basic feature of the Constitution and hence cannot be taken away. However, the above first provision of Article 31C was held to be constitutional and valid. Distinction between fundamental rights and directive principles. Number 1. Fundamental rights are negative as they prohibit the state from doing certain things, while directive principles are positive as they require the state to do certain things. Number 2. Fundamental rights are justiciable, that is, they are legally enforceable by the courts in case of their violation, while directive principles are non-justiciable, that is, they are not legally enforceable by the courts for their violation. Number 3. Fundamental rights aim at establishing political democracy in the country, while directive principles aim at establishing social and economic democracy in the country. Number 4. Fundamental rights have legal sanctions, while directive principles have moral and political sanctions. Number 5. Fundamental rights promote the welfare of the individual, hence they are of personal and individualistic, while directive principles promote the welfare of the community, hence they are societarian and socialistic. Number 6. Fundamental rights do not require any legislation for their implementation. They are automatically enforced. While directive principles require legislation for their implementation, they are not automatically enforced. Number 7. Fundamental rights. The courts are bound to declare a law violative of any of the fundamental rights as unconstitutional and invalid, while in case of directive principles, the court cannot declare a law violative of any of the directive principles as the unconstitutional and invalid. However, they can uphold the validity of a law on the ground that it was enacted to give effect to a directive. Later, the 42nd Amendment Act of 1976 extended the scope of the above first provision of Article 31C by including within its protection any law to implement any of the directive principles and not merely those specified in Article 39B and C. In other words, the 42nd Amendment Act accorded the position of legal primacy and supremacy to the directive principles over the fundamental rights conferred by Article 14, 19 and 31. However, this extension was declared as unconstitutional and invalid by the Supreme Court in Minerva Mills case of 1980. It means that the directive principles were once again made subordinate to the fundamental rights, but the fundamental right conferred by Article 14 and Article 19 were accepted as subordinate to the directive principles specified in Article 39B and C. Further, Article 31, right to property, was abolished by the 44th Amendment Act 1978. In the Minerva Mills case 1980, the Supreme Court also held that the Indian Constitution is founded on the bedrock of the balance between the fundamental rights and the directive principles. They together constitute the core of commitment to social revolution. They are like two wheels of a chariot, one no less than the other. To give absolute primacy to one over the other is to disturb the harmony of the Constitution. This harmony and balance between the two is an essential feature of the basic structure of the Constitution. The goals set out by the directive principles have to be achieved without the abrogation of the means provided by the fundamental rights. Therefore, the present position is that the fundamental right enjoy supremacy over the directive principles. Yet, this does not mean that the directive principles cannot be implemented. The Parliament can amend the fundamental rights for implementing the directive principles so long as the amendment does not damage or destroy the basic structure of the Constitution. Implementation of directive principles. Since 1950, the successive governments at the center and in the states have made several laws and formulated various programs for implementing the directive principles. These are mentioned below. Number 1. The Planning Commission was established in 1950 to take up the development of the country in a planned manner. The successive 5-year plans aimed at securing socio-economic justice and reducing inequalities of income, status and opportunities. In 2015, the Planning Commission was replaced by a new body called Niti Aayog, National Institution for Transforming India. Number 2. Almost all the states have passed land reforms laws to bring changes in the agrarian society and to improve the conditions of the rural masses. These measures include abolition of intermediaries like jamidars, jagirdars, inamdars, etc., tenancy reforms like security of tenure, fair rents, etc., imposition of ceilings on land holdings, distribution of surplus land among the landless laborers, and cooperative farming. Number 3. The Minimum Wages Act of 1948, the Payment of Wages Act 1936, the Payment of Bonus Act 1965, the Contract Labour Regulation and Abolition Act of 1970, the Child Labour Prohibition and Regulation Act 1986, the Bonded Labour System Abolition Act 1976, the Trade Unions Act 1926, the Factories Act 1948, the Mines Act 1952, the Industrial Disputes Act 1947, the Workmen's Compensation Act 1923, and so on have been enacted to protect the interest of the labour section. In 2006, the government banned the child labour. In 2016, the Child Labour Prohibition and Regulation Act 1986 was renamed as the Child and Adolescent Labour Prohibition and Regulation Act 1986. Number 4. The Maternity Benefit Act 1961 and the Equal Remuneration Act 1976 have been made to protect the interest of women workers. Number 5. Various measures have been taken to utilize the financial resources for promoting the common good. These include nationalization of life insurances 1956, the nationalization of 14 leading commercial banks 1969, the nationalization of general insurance 1971, abolition of privy purses 1971, and so on. Number 6. The Legal Service Authority Act 1987 has established a nationwide network to provide free and competent legal aid to the poor and to organize Lok Adalat for promoting equal justice. Lok Adalat is a statutory forum for conciliatory settlement of legal disputes. It has been given the status of a civil court. It awards the enforceable binding on the parties and final as no appeal lies before any court against them. Number 7. Khadi and Village Industries Board, Khadi and Village Industries Commission, Small Scale Industries Board, National Small Industries Corporation, Handloom Board, Handicraft Board, Coir Board, Silk Board, and so on have been set up for the development of cottage industries in rural areas. Number 8. The Community Development Program of 1952, Hill Area Development Program 1960, Drought Prone Area Program 1973, Minimum Needs Program 1974, Integrated Rural Development Program 1978, Jawahar Rojgar Yojana 1989, Samaj Swayam Jayanti Gram Swarojgar Yojana 1999, Sampurn Gramin Rojgar Yojana 2001, National Rural Employment Guarantee Program 2006, and so on have been launched for raising the standards of living of people. Number 9. The Wildlife Protection Act of 1972 and the Forest Conservation Act of 1980 have been enacted to safeguard the wildlife and the forest respectively. Further, the Water and Air Act have provided for the establishment of the central and state pollution control boards, which are engaged in the protection and improvement of environment. The National Forest Policy of 1988 aims at the protection, conservation, and development of forest. Number 10. Agriculture has been modernized by providing improved agricultural inputs, seeds, fertilizers, and irrigation facilities. Various steps have also been taken to organize animal husbandry on modern and scientific lines. Number 11. Three-tier Panchayati Raj system at village, taluka, and Jilla levels has been introduced to translate into reality Gandhiji's dream of every village being a republic. The 73rd Amendment Act 1992 has been enacted to provide constitutional status and protection to these Panchayati Raj institutions. Number 12. Seats are reserved for SCs, STs, and other weaker sections in educational institutions, government services, and representative bodies. The Untouchability Offences Act 1955, which was renamed as the Protection of Civil Rights Act in 1976, and the Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act 1989 have been enacted to protect the SCs and STs from social injustice and exploitation. The 65th Constitutional Amendment Act of 1990 established the National Commission for Scheduled Castes and Scheduled Tribes to protect the interest of SCs and STs. Later, the 89th Constitutional Amendment Act of 2003 bifurcated this combined commission into two separate bodies, namely National Commission for Scheduled Caste and National Commission for Scheduled Tribes. Number 12A. Various national level commissions have been established to promote and protect the social, educational, and economic interest of the weaker section of society. These include the National Commission for Backward Classes 1993, the National Commission for Minorities 1993, and the National Commission for Women 1992, and the National Commission for Protection of Child Rights 2007. Further, the 102nd Amendment Act of 2018 conferred a constitutional status on the National Commission for Backward Classes and also enlarged its functions. Number 12B. In 2019, the central government issued orders providing 10% reservation to the economically weaker section in admission to the educationally institutions and civil posts and services in the Government of India. The benefit of this reservation can be availed by the persons belonging to EWS who are not covered under any of the existing schemes of reservations for SCs, STs and OBCs. This reservation was facilitated by the 103rd Amendment Act of 2019. Number 13. The Criminal Procedure Code of 1973 separated the judiciary from the executive in the public services of the state. Prior to this separation, the district authorities like the collector, the sub-divisional officer, the tehsildar and so on used to exercise judicial powers along with the traditional executive powers. After the separation, the judicial powers were taken away from these executive authorities and vested in the hands of district judicial magistrates who took work under the direct control of the state of High Court. Number 14. The Ancient and Historical Monument and Archaeological Sites and Remains Act 1951 has been enacted to protect the monuments, places and objects of national importance. Number 15. Primary health centers and hospitals have been established throughout the country to improve the public health. Also, special programs have been launched to eradicate widespread diseases like malaria, TB, leprosy, AIDS, cancer, filaria, Kala Azar, Guinea worm, yaws, Japanese encephalitis, and so on. Number 16. Laws to prohibit the slaughter of cows, calves, and bullocks have been enacted in some states. Number 17. Some states have initiated the old age pension scheme for people above 65 years. Number 18. India has been followed the policy of non-alignment and Panchasheel to promote international peace and security. In spite of the above steps by the central and state governments, the directive principles have not been implemented fully and effectively due to several reasons like inadequate financial resources, unfavorable socio-economic conditions, population explosion, strained center-state relations, and so on. Directives outside Part 4th. Apart from the directives included in Part 4th, there are some other directives contained in other parts of the Constitution. They are: Number 1. Claims of SCs and STs to services. The claims of members of the scheduled caste and scheduled tribes shall be taken into consideration consistently with the maintenance of efficiency of administration in the making of appointments to services and posts in connection with the affairs of the Union or state, Article 335 in Part 16. Number 2. Instruction in mother tongue. It shall be the endeavour of every state and every local authority within the state to provide adequate facilities for instruction in the mother tongue at the primary stage of education to children belonging to linguistic minority groups. Article 350A in Part 17. Number 3. Development of the Hindi language. It shall be the duty of Union to promote the spread of Hindi language and to develop it so that it may serve as a medium of expression for all the elements of the composite culture of India. Article 351 in Part 17. The above directives are non-justiciable in nature. However, they are also given equal importance and attention by the judiciary on the ground that all parts of the Constitution must be read together. The theoretical part of this chapter ended here, but there is one table which is articles related to directive principles of state policy at a glance. You can refer the book or PDFs at online forums. Thank you so much. Chapter 9. Fundamental Duties. Though the rights and duties of the citizens are correlative and inseparable, the original constitution contained only the fundamental rights and not the fundamental duties. In other words, the framers of the constitution did not feel it necessary to incorporate the fundamental duties of the citizens in the constitution. However, they incorporated the duties of the state in the constitution in the form of directive principles of state policy. Later in 1976, the fundamental duties of citizens were added in the Constitution. In 2002, one more fundamental duty was added. The fundamental duties in the Indian Constitution are inspired by the Constitution of erstwhile USSR. Notably, name of the constitutions of major democratic countries like USA, Canada, France, Germany, Australia, and so on specifically contain a list of duties of citizens. Japanese constitution is perhaps the only democratic constitution in world which contains a list of duties of the citizens. The socialist countries, on the contrary, gave equal importance to the fundamental rights and duties of their citizens. Hence, the Constitution of erstwhile USSR declared that the citizens' exercise of their rights and freedoms was inseparable from the performance of their duties and obligations. Swaran Singh Committee recommendations. In 1976, Congress Party set up Sardar Swaran Singh Committee to make recommendations about fundamental duties, the need and necessity of which was felt during the operation of the internal emergency 1975 to 1977. The committee recommended the inclusion of a separate chapter on fundamental duties in the Constitution. It stressed that the citizens should become conscious that in addition to the enjoyment of rights, they also have certain duties to perform as well. The Congress government at center accepted these recommendations and enacted the 42nd Constitutional Amendment Act in 1976. This amendment added a new part, namely Part 6A, Part 4A to the Constitution. This new part consists of only one article, that is Article 51A, which for the first time specified a code of 10 fundamental duties of the citizens. The ruling Congress Party declared the non-inclusion of fundamental duties in the Constitution as a historical mistake and claimed that what the framers of the Constitution failed to do was being done now. Though the Swaran Singh Committee suggested the incorporation of 8 fundamental duties in the Constitution, the 42nd Constitutional Amendment Act of 1976 included 10 fundamental duties. Interestingly, certain recommendations of the committee were not accepted by the Congress Party and hence not incorporated in the Constitution. These include: number 1. The Parliament may provide for the imposition of such penalty or punishment as may be considered appropriate for any non-compliance with or refusal to observe any of the duties. Number 2. No law imposing such penalty or punishment shall be called in question in any court on the ground of infringement of any of fundamental rights or on the ground of repugnancy to any other provisions of the Constitution. Number 3. Duty to pay taxes should also be a fundamental duty of the citizens. List of fundamental duties. According to Article 51A, it shall be the duty of every citizen of India, number 1, to abide by the Constitution and respect its ideals and institutions, the national flag and the national anthem. Number 2, to cherish and follow the noble ideals that inspired the national struggle for freedom. Number 3, to uphold and protect the sovereignty, unity and integrity of India. Number 4, to defend the country and render national service when called upon to do so. Number 5, to promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic and regional or sectional diversities, and to renounce practice derogatory to the dignity of women. Number 6, to value and preserve the rich heritage of the country's composite culture. Number 7, to protect and improve the natural environment including forest, lakes, rivers and wildlife, and to have compassion for living creatures. Number 8, to develop scientific temper, humanism and the spirit of inquiry and reform. Number 9, to safeguard public property and to abjure violence. Number 10, to strive towards excellence in all spheres of individual and collective activity so that the nation constantly rises to higher levels of endeavor and achievement. Number 11, to provide opportunities for education to his child or ward between the age of 6 and 14 years. This duty was added by the 86th Constitutional Amendment Act of 2002. Features of fundamental duties. Following points can be noted with regard to the characteristics of the fundamental duties. Number 1. Some of them are moral duties while others are civic duties. For instance, cherishing noble ideals of freedom struggle is a moral precept and respecting the Constitution, national flag and national anthem is a civic duty. Number 2. They refer to such values which have been a part of the Indian tradition, mythology, religions, and practices. In other words, they essentially contain just a codification of tasks integral to the Indian way of life. Number three, unlike some of the fundamental rights which extends to all persons, whether citizens or foreigners, the fundamental duties are confined to citizens only and do not extend to foreigners. Number four, like the directive principles, the fundamental duties are also non-justiciable. The Constitution does not provide for their direct enforcement by the courts. Moreover, there is not legal sanction against their violation. However, the Parliament is free to enforce them by suitable legislation. Criticism of fundamental duties. The fundamental duties mentioned in Part 4A of the Constitution have been criticized on the following grounds. Number 1. The list of duties is not exhaustive as it does not cover other important duties like casting vote, paying taxes, family planning, and so on. In fact, duty to pay taxes was recommended by the Swaran Singh Committee. Number 2. Some of the duties are vague, ambiguous, and difficult to be understood by the common man. For example, different interpretations can be given to the phrases like noble ideals, composite culture, scientific temper, and so on. Number 3. They have been described by the critics as a code of moral precepts due to their non-justiciable character. Interestingly, the Swaran Singh Committee had suggested for penalty or punishments for the non-performance of fundamental duties. Number 4. Their inclusion in the Constitution was described by the critics as superfluous. This is because the duties included in the Constitution as fundamental would be performed by the people even though they were not incorporated in the Constitution. Number 5. The critics said that the inclusion of fundamental duties as an appendage to Part 4th of the Constitution has reduced their value and significance. They should have been added after Part 3rd so as to keep them on par with fundamental rights. Significance of fundamental duties. In spite of criticisms and opposition, the fundamental duties are considered significant from the following viewpoints. Number 1. They serve as a reminder to the citizens that while enjoying their rights, they should also be conscious of duties they owe to their country, their society, and to their fellow citizens. Number 2. They serve as a warning against the anti-national and anti-social activities like burning the national flag, destroying public property, and so on. Number 3. They serve as a source of inspiration for the citizens and promote a sense of discipline and commitment among them. They create a feeling that the citizens are not mere spectators but active participants in the realization of national goals. Number 4. They help the courts in examining and determining the constitutional validity of a law. In 1992, the Supreme Court ruled that in determining the constitutionality of any law, if a court finds that the law in question seeks to give effect to a fundamental duty, it may consider such law to be reasonable in relation to Article 14, equality before law, or Article 19, 6 freedoms, and thus save such law from unconstitutionality. Number 5. They are enforceable by law. Hence, the Parliament can provide for the imposition of appropriate penalty or punishment for failure to fulfill any of them. H.R. Gokhale, the then law minister, gave the following reason for incorporating the fundamental duties in the Constitution after 26 years of its inauguration. In post-independent India, particularly on the eve of emergency in June 1975, a section of the people showed no anxiety to fulfill their fundamental obligations of respecting the establishing legal order. The provisions of chapter on fundamental duties would have a sobering effect on these restless spirits who have had a host of anti-national, subversive and unconstitutional agitations in the past. Indira Gandhi, the then Prime Minister, justified the inclusion of fundamental duties in the Constitution and argued that their inclusion would help to strengthen democracy. She said the moral value of fundamental duties would be not to smoother rights but to establish a democratic balance by making the people conscious of their duties equally as they are conscious of their rights. The opposition in the parliament strongly opposed the inclusion of fundamental duties in the constitution by the Congress government. However, the new Janata government headed by Morarji Desai in the post-emergency period did not annul the fundamental duties. Notably, the new government sought to undo many changes introduced in the Constitution by the 42nd Amendment Act of 1976 through the 43rd Amendment Act of 1977 and the 44th Amendment Act of 1978. This shows that there was an eventual consensus on the necessity and desirability of including the fundamental duties in the Constitution. This is more clear with the addition of one more fundamental duty in 2002 by the 86th Amendment Act. Verma Committee Observation. The Verma Committee on Fundamental Duties of the Citizens of 1999 identified the existence of legal provisions for the implementation of some of the fundamental duties. They are mentioned below. Number 1. The Prevention of Insults to National Honor Act of 1971 prevents disrespect to the Constitution of India, the national flag, and the national anthem. Number 2. The various criminal laws in force provide for punishment of encouraging enmity between different sections of people on grounds of language, race, place of birth, religion, and so on. Number 3. The Protection of Civil Rights Act 1955 provides for punishment for offences related to caste and religion. Number 4. The Indian Penal Code declares the imputations and assertions prejudicial to national integration as punishable offences. Number 5. The Unlawful Activities Prevention Act of 1967 provides for the declaration of a communal organization as an unlawful association. Number 6. The Representation of People Act 1951 provides for the disqualification of members of the parliament or a state legislature for indulging in corrupt practices, that is, soliciting votes on the ground of religion or promoting enmity between different sections of people on grounds of caste, race, language, religion, and so on. Number 7. The Wildlife Protection Act of 1972 prohibits trade in rare and endangered species. Number 8. The Forest Conservation Act of 1980 checks indiscriminate deforestation and diversion of forest land for non-forest purposes. Chapter 10. Amendment of the Constitution. Like any other written constitution, the Constitution of India also provides for its amendment in order to adjust itself to the changing conditions and needs. However, the procedure laid down for its amendment is neither as easy as in Britain nor as difficult as in USA. In other words, the Indian Constitution is neither flexible nor rigid but a synthesis of both. Article 368 in Part 20 of the Constitution deals with the powers of Parliament to amend the Constitution and its procedure. State that the Parliament may, in exercise of its constituent power, amend by way of addition, variation or repeal any provision of the Constitution in accordance with the procedure laid down or the purpose. However, the Parliament cannot amend those provisions which form the basic structure of the Constitution. This was ruled by the Supreme Court in the Keshwanand Bharti case of 1973. Procedure for amendment. The procedure for the amendment of the Constitution as laid down in Article 368 is as follows. Number 1. An amendment of the Constitution can be initiated only by the introduction of a bill for the purpose in either House of Parliament and not in the state legislatures. Number 2. The bill can be introduced either by a minister or by a private member and does not require prior permission of the President. Number 3. The bill must be passed in each house by a special majority, that is, a majority of the total membership of the house and a majority of 2/3 of the members of the house present and voting. Number 4. Each house must pass all the bills separately. In case of a disagreement between the two houses, there is no provision for holding a joint sitting of the two houses for the purpose of deliberation and passage of the bill. Number 5. If the bill seeks to amend the federal provisions of the Constitution, it must also be ratified by the legislatures of half of the states by a simple majority, that is, a majority of the members of the House present and voting. Number 6. After duly passed by both the Houses of Parliament and ratified by the state legislatures where necessary, the bill is presented to the President for assent. Number 7. The President must give his assent to the bill. He can neither withhold his assent to the bill nor return the bill for reconsideration of the Parliament. Number 8. After the President's assent, the bill becomes an act, that is, a Constitutional Amendment Act, and the Constitution stands amended in accordance with the terms of the Act. Types of amendment. Article 368 provides for two types of amendments, that is, by a special majority of Parliament and also through the ratification of half of the states by a simple majority. But some other articles provide for the amendment of certain provisions of the Constitution by a simple majority of Parliament, that is, a majority of the members of each house present and voting, similar to ordinary legislative process. Notably, these amendments are not deemed to be amendments of the Constitution for the purpose of Article 368. Therefore, the Constitution can be amended in three ways. Number 1, amendment by simple majority of the Parliament. Number 2, amendment by special majority of the Parliament. Number 3, amendment by special majority of the Parliament and the ratification of half of the state legislatures. By simple majority of Parliament, a number of provisions in the Constitution can be amended by a simple majority of the two houses of Parliament outside the scope of Article 368. These provisions include: Number 1, admission or establishment of new states. Number 2, formation of new states and alteration of areas, boundaries, or names of existing states. Number 3, abolition or creation of legislative councils in a state. Number 4, second schedule emoluments, allowances, privileges, and so on of the president, the governors, the speakers, judges, etc. Number 5, quorum in parliament. Number 6, salaries and allowances of the members of parliament. Number 7, rules of procedure in parliament. Number 8, privileges of the parliament, its members, and its committees. Number 9, use of English language in parliament. Number 10, number of puissant judges in the Supreme Court. Number 11, conferment of more jurisdiction on the Supreme Court. Number 12, use of official language. Number 13, citizenship acquisition and termination. Number 14, elections to parliament and state legislatures. Number 15, delimitation of constituencies. Number 16, union territories. Number 17, fifth schedule, administration of scheduled areas and scheduled tribes. Number 18, sixth schedule, administration of tribal areas. Number 2, by special majority of Parliament. The majority of the provision in the Constitution needs to be amended by a special majority of the Parliament, that is, a majority of the total membership of each House and a majority of 2/3 of the members of each House present and voting. The expression total membership means the total number of members comprising the House irrespective of the fact whether there are vacancies or absentees. Strictly speaking, the special majority is required only for voting at the third reading stage of the bill, but by way of abundant caution, the requirement for special majority has been provided for in the rules of the Houses in respect of all the effective stages of the bill. The provision which can be amended by this way includes: Number 1, fundamental rights. Number 2, directive principles of state policy. And Number 3, all other provisions which are not covered by the first and third categories. Number 3, by special majority of Parliament and consent of states. Those provisions of the Constitution which are related to the federal structure of the polity can be amended by a special majority of the Parliament and also with the consent of half of the state legislatures by a simple majority. If one or some or all other remaining states take no action on the bill, it does not matter. The moment a half of the state give their consent, the formality is completed. There is no time limit within which the states should give their consent to the bill. The following provision can be amended in this way. Number 1, election of the president and its manner. Number 2, extent of the executive power of the union and the state. Number 3, Supreme Court and High Court. Number 4, distribution of legislative powers between the union and the state. Number 5, Goods and Services Tax Council. Number 6, any of the list in the 7th schedule. Number 7, representation of states in parliament. Number 8, power of parliament to amend the constitution and its procedure. Article 368 itself. Criticism of the amendment procedure. Critics have criticized the amendment procedure of the Constitution on the following grounds. Number 1, there is no provision for a special body like Constitutional Convention as in USA or Constituent Assembly for amending the Constitution. The constituent power is vested in the Parliament and only in few cases in the state legislatures. Number 2, The power to initiate an amendment to the constitution lies with the parliament. Hence, unlike in USA, the state legislatures cannot initiate any bill or proposal for amending the constitution except in one case, that is, passing resolution requests the parliament for the creation or abolition of legislative council in the state. Here also, the parliament can either approve or disapprove such as many resolutions or may not take any action on it. Number 3. Major part of the constitution can be amended by the parliament alone either by a special majority or by a simple majority. Only in few cases the consent of the state legislature is required, and that too only half of them, while in USA it is 3/4 of the state. Number 4. The constitution does not prescribe the time frame within which the state legislature should ratify or reject any amendment submitted to them. Also, it is silent on the issue whether the state can withdraw their approval after according the same. Number 5. There is no provision for holding a joint sitting of both the houses of parliament if there is a deadlock over the passage of a constitutional amendment bill. On the other hand, a provision for a joint sitting is made in the case of an ordinary bill. Number 6. The process of amendment is similar to that of a legislative process, except for the special majority. The constitutional amendment bills are to be passed by the parliament in the same way as ordinary bills. Number 7. The provision relating to the amendment procedure are too sketchy, hence they leave a wide scope for taking the matters to the judiciary. Despite these defects, it cannot be denied that the process has proved to be a simple and easy and has succeeded in meeting the changed needs and conditions. The procedure is not so flexible as to allow the ruling parties to change it according to their whims, nor is it so rigid as to be incapable of adapting itself to the changing needs. It is rightly said by K.C. Viere, it strikes a good balance between flexibility and rigidity. In this context, Pandit Jawaharlal Nehru said in the Constituent Assembly, while we want this constitution to be as solid and permanent as we can make it, there is no permanence in the constitution. There should be a certain flexibility. If you make any constitution rigid and permanent, you stop the nation's growth, the growth of a living, vital, organic people. Similarly, Dr. B.R. Ambedkar observed in the Constituent Assembly that the Assembly has not only refrained from putting a seal of finality and infallibility upon this Constitution by denying the people the right to amend the Constitution as in Canada, or making the amendments of the Constitution subject to the fulfillment of extraordinary terms and conditions as in America or Australia, but has provided for a facile procedure for amending the Constitution. K.C. Viere has admired the variety of amendment procedures contained in the Constitution of India. He said, this variety in the amending process is wise but rarely found. According to Granville Austin, the amending process has proved itself one of the most ably conceived aspects of the Constitution. Although it appears complicated, it is merely diverse. Thank you so much. Chapter 11. Basic structure of the Constitution. Emergence of the basic structure. The question whether fundamental rights can be amended by the Parliament under Article 368 came for consideration of the Supreme Court within a year of the Constitution coming into force. In the Shankari Prasad case of 1951, the constitutional validity of the First Amendment Act 1951, which curtailed the right to property, was challenged. The Supreme Court ruled that the power of the Parliament to amend the Constitution under Article 368 also includes the power to amend fundamental rights. The word law in Article 13 includes only ordinary laws and not the Constitutional Amendment Act constitutional laws. Therefore, the Parliament can abridge or take away any of the fundamental rights by enacting a Constitutional Amendment Act, and such a law will not be void under Article 13. But in the Golaknath case of 1967, the Supreme Court reversed its earlier stand. In that case, the constitutional validity of the 17th Amendment Act of 1964, which inserted certain state act in the 9th schedule, was challenged. The Supreme Court ruled that the fundamental rights are given a transcendental and immutable position, and hence the Parliament cannot abridge or take away any of these rights. A Constitutional Amendment Act is also a law within the meaning of Article 13 and hence would be void for violating any of the fundamental rights. The Parliament reacted to the Supreme Court's judgment in the Golaknath case 1967 by enacting the 24th Amendment Act 1971. This act amended Articles 13 and 368. It declared that the Parliament has the power to abridge or take away any of the fundamental rights under Article 368, and such an act will not be a law under the meaning of Article 13. However, in the Keshwanand Bharti case of 1973, the Supreme Court overruled its judgment in the Golaknath case of 1967. It upheld the validity of the 24th Amendment Act of 1971 and stated that the Parliament is empowered to abridge or take away any of the fundamental rights. At the same time, it laid down a new doctrine of the basic structure or basic features of the Constitution. It ruled that the constituent power of Parliament under Article 368 does not enable it to alter the basic structure of the Constitution. This means that the Parliament cannot abridge or take away a fundamental right that forms a part of the basic structure of the Constitution. The doctrine of basic structure of the Constitution was reaffirmed and applied by the Supreme Court in the Indira Nehru Gandhi case of 1975. In this case, the Supreme Court invalidated a provision of 39th Amendment Act of 1975 which kept the election dispute involving the Prime Minister and the Speaker of Lok Sabha outside the jurisdiction of all courts. The court said that this provision was beyond the amending power of Parliament as it affected the basic structure of the Constitution. Again, the Parliament reacted to this judicially innovated doctrine of basic structure by enacting the 42nd Amendment Act of 1976. This act amended Article 368 and declared that there is no limitation on the constituent power of Parliament and no amendment can be questioned in any court or any ground, including that of the contravention of any of the fundamental rights. However, the Supreme Court in the Minerva Mills case of 1980 invalidated this provision as it excluded judicial review, which is a basic feature of the Constitution. Applying the doctrine of a basic structure with respect to Article 368, the court held that since the Constitution has conferred a limited amending power on the Parliament cannot, under the exercise of that limited power, enlarge that very power into an absolute power. Indeed, a limited amending power is one of the basic features of the Constitution, and therefore the limitations on that power cannot be destroyed. In other words, Parliament cannot, under Article 368, expend its amending power so as to acquire for itself the right to repeal or abrogate the Constitution or to destroy its basic features. The donee of a limited power cannot, by the exercise of that power, convert the limited power into an unlimited one. Again, in the Vaman Rao case of 1981, the Supreme Court adhered to the doctrine of the basic structure and further clarified that it would apply to the constitutional amendment enacted after April 24, 1973, that is, the date of the judgment in the Keshwanand Bharti case. Elements of the basic structure. The present position is that the Parliament under Article 368 can amend any part of the Constitution, including the fundamental rights, but without affecting the basic structure of the Constitution. However, the Supreme Court is yet to define or clarify as to what constitutes the basic structure of the Constitution. From the various judgments, the following have emerged as basic structure of the Constitution or elements of the basic structure. Number 1. Supremacy of the Constitution. Number 2. Sovereign, democratic and republican nature of the Indian polity. Number 3. Secular character of the Constitution. Number 4. Separation of powers between the legislature, the executive and the judiciary. Number 5. Federal character of the Constitution. Number 6. Unity and integrity of the nation. Number 7. Welfare state, socio-economic justice. Number 8. Judicial review. Number 9. Freedom and dignity of the individual. Number 10. Parliamentary system. Number 11. Rule of law. Number 12. Harmony and balance between fundamental rights and directive principles. Number 13. Principle of equality. Number 14. Free and fair elections. Number 15. Independence of judiciary. Number 16. Limited power of Parliament to amend the Constitution. Number 17. Effective access to justice. Number 18. Principles or essence underlying fundamental rights. Number 19. Powers of Supreme Court under Article 32, 136, 141 and 142. Number 20. Powers of the High Court under Article 226 and 227. Evolution of the basic structure of the Constitution. Number 1. Keshwanand Bharti case 1973, popularly known as the Fundamental Right case. Elements of the basic structure declared by the Supreme Court in this case are: number 1, supremacy of the Constitution; number 2, separation of power between the legislature, executive, and judiciary; number 3, republic and democratic form of government; number 4, secular character of the Constitution; number 5, federal character of the Constitution; number 6, sovereignty and unity of India; number 7, freedom and dignity of individual; number 8, parliamentary system; number 9, mandate to build a welfare state. Case number 2, Indira Nehru Gandhi case 1975, popularly known as the election case. The elements included under this case are: number 1, India as a sovereign democratic republic; number 2, equality of status and opportunity of an individual; number 3, secularism and freedom of conscience and religion; number 4, government of laws and not of men, that is rule of law; number 5, judicial review; number 6, free and fair elections, which is implied in democracy. Case number 3, Minerva Mills case of 1980. It declared limited power of Parliament to amend the Constitution, judicial review, harmony and balance between the fundamental right and directive principles. Case number 4, Central Coal Fields Limited case 1980. Effective access to justice. Case number 5, Bhim Singh Ji case of 1981. It declared welfare state, socio-economic justice. Case number 6, SP Sampath Kumar case of 1987. It declared rule of law and judicial review. Case number 7, P. Sambamurthy case of 1987. It also declared rule of law and judicial review. Case number 8, Delhi Judicial Service Association case of 1991. It declares powers of the Supreme Court under Article 32, 136, 141 and 142. Case number 9, Indira Swani case 1992, popularly known as the Mandal case. It declared rule of law. Case number 10, Kumar Padma Prasad case of 1992. It declared independence of judiciary. Case number 11, Kyoto Holohan case 1993, popularly known as defection case. It include free and fair election, sovereign democratic republican structure. Case number 12, Raghunath Rao case of 1993. It declared principle of equality, unity and integrity of India. Case number 13, S.R. Bommai case of 1994. It declared federalism, secularism, democracy, unity and integrity of the nation, social justice and judicial review. Case number 14, L. Chandrakumar case of 1997. Powers of the High Courts under Article 226 and 227. Case number 15, Indira Swani's second case 2000. It declared principle of equality. Case number 16, All India Judges Association case 2002, Independent Judicial System. Case number 17, Kuldeep Nayyar case of 2006. It declared democracy, free and fair elections. Case number 18, M. Nagaraj case of 2006, principle of equality. Case number 19, I.R. Kohlo case of 2007, popularly known as 9th Schedule case. Rule of law, separation of power, principles or essence underlying fundamental rights, judicial review, principle of equality. Case number 20, Ram Jethmalani case of 2011, powers of the Supreme Court under Article 32. Case number 21, Namish Sharma case of 2013, freedom and dignity of the individual. And last case, number 22, Madras Bar Association case. It included judicial review and powers of the High Courts under Article 226 and 227 under the basic structure. Thank you so much.